Oh. Wow. How are we doing today, guys? Good job on the likes debate. You're a beast. Thanks, babe.
Hey, little brother screaming.
Yeah, what's up?
Yo,
How you doing?
good. Are you screaming?
Yeah.
Oh, damn. Okay, that wasn't my fault. Real quick.
Yeah.
How you doing?
Horrible.
What's wrong?
The fucking loser canceled or he pushed back the debate today again.
No, he didn't.
Yeah.
No, he didn't.
Indeed, he did. Eli said he's going to try to schedule for next week, but no, I don't know. I think he's just dodging.
Well, gives you more time to prepare.
Maybe. I stayed up all night and I read that paper.
You read the whole thing.
Yeah.
That's stupid. You should have read it with me.
Oh, well, I'm sorry. Were you awake at 5 a.m.?
Actually, I actually was. I probably couldn't have helped, to be honest, last night. But
Yeah. I feel
should've
like it's
waited.
pretty. I feel like it's pretty airtight.
it's air fucking tight, bro. It's air tight, and the counter papers are not good at all. And I think it's really important for you to have some goddamn confidence when you walk into that debate, whether it's with him or whether he
Oh
never
no,
shows
versus
up.
Glenn after reading this paper against Glenn, yeah, 1,000,000% confidence. Yeah, well, obviously. I haven't read any of the
Trillion%.
responses yet.
So the
I will
responses-
say I have to before don't even
Yeah,
don't even say it. If either of the papers try to make the argument that
President, yeah.
an officer doesn't inhabit
Yes,
an office,
that's the
no,
main thing.
no,
No,
no, no,
that's
no,
the main
I didn't
thing.
want to
No.
hear it. I didn't want to hear it. I would just kill myself on the spot.
no one is even arguing really.
It's such
on
a
the
stupid
insurrection part.
fucking point. Yeah, the insurrection point is like foregone.
No one's arguing on the engagement part. Like if you look at the scholarly literature, the scholarly literature, it's not at all dealing with the engagement or the insurrection aspects, really, which are I would think in the engagement part and the incitement part. That's like a little bit more difficult, thorny of an issue that the Supreme Court might actually rule on.
For which
But
part?
The insurrection part, the engagement part, whether or not
Oh
states
yeah,
have the
you
right
know
to
what?
enforce
Yeah,
it.
but you know what argument I like from the paper? Because of the arguments they make, it sidesteps a lot. It doesn't matter. It doesn't matter if it's a
Yeah.
hard question. It doesn't matter if it's complicated. The fact of the matter is if the Constitution is as written, this is what has to
Yes.
happen. So it might be difficult, sure, but who cares? It's not an argument against the enforcement of the self-executing part of the amendment.
But I mean,
right?
in
Full
their
stop.
argument
Yeah.
for why it doesn't apply to Trump, people have been saying, well, I think good lawyers, but they might be good lawyers, but at least not good legal arguments. They'll say something like it wasn't an insurrection because of da da da. I don't think anyone in the literature is arguing those points. They're focusing on this. They're obsessing with the officer question.
It's
They're obsessing
such a
with the
stupid-
president is not an officer. It
Yeah, but
doesn't
then
make
when you look
any
at like
sense at
all the surrounding context, you look at like the I couldn't find an answer to this. Did the president Abraham Lincoln did he do the ironclad oath for the office of the president too, or was it just every other person in office besides the president and vice president?
I don't know if the ironclad oath was enforced for Lincoln. Are you asking for Lincoln?
Well, because
Sorry.
one of the interesting things was all of the parallels that they draw between a lot of the language in Section 3. I'm not going to say it's borrowed by, but it's preceded by a lot of other language for, and the two things they focus on, one is that ironclad oath.
Yeah.
Yeah, and I'm curious, I was trying to find, just to make sure if there's some weird trip up that I'm not aware of, but my understanding is they replaced the ordinary oath with the ironclad oath to get rid of a lot of the Civil War people for a while. But I'm assuming the president takes the same one because all oath takers
Yeah.
take essentially the same oath. Yeah.
Well, the president takes an oath that's sort of prescribed by the Constitution. The Constitution says in Article 6, I believe Article 6, that all officers, everyone, Congress people, everyone who's aligned or has a constitutional office, and even state officials have to swear an oath to support the Constitution.
Yeah.
But Article 2 gives him another additional oath that has to preserve, protect, and defend.
Sure.
And so one of the arguments from the pro-Trump people is that is not an oath to support the Constitution. When it's the more extra oath, it's the better oath, it's the oath that is the one that's special. They are saying that there was really this technical distinction that was intended by the framers of the amendment, and they wanted to separate an oath to support as opposed to an oath to preserve, protect, and defend, instead of thinking them as, well, one of them is just the more advanced version of the previous one.
Is there is there a single piece of historical evidence that
No,
supports
no, no.
that idea that the
That's
president is like
the worst
beyond
part.
or above the
Yeah. That's the worst part. You cannot find a single person, a single statement from anybody during the drafting of this era that said something like this. Oh, we're drafting this so the president is not an officer. Or we're making this so the president is excluded. There's no one. They can't produce a single quote from anyone that says that this was what was intended.
And then just think about the idea of especially if we're talking constitutional language and not even amendment language. Imagine drafting a constitution, making the president an extra special awesome guy when you just fucking rebelled against a monarch. And now you're going to make the one guy that's actually above your most important document for governing law. It's nonsense.
Well, it was inspired. The presidential powers, a lot of them are inspired by the common law, 100%. That's where we get this distinction, and that has something to do with the royal power. But they differed in many key respects. One way in which they differ is this distinction between member and officer, and the definition of officer, and Congress people not being officers, but instead being members. That comes from the English common law. And it was well understood at the time that everyone who the king had the ultimate authority, from God, right?
Yeah.
And everyone under him was, as part of his his cabinet, his advisors, those were officers. But the members of parliament were members, right? This is all terminology that is well known. So the difference between the king and the president is, well, the president is not a king, and the president has, if the president is not a king, he must therefore be an officer. And everyone understood at the time. It's called the office of the president. He's referred to as an officer in the Constitution.
Well,
And
careful. I don't believe that part is true. That's the one
It is.
hang up with that. I don't think they ever explicitly refer to the president
They do.
as an officer.
They do.
Wait, where?
Yes. So, and what they're looking for is officer of the United States, where the president. It's said that the president commissions the officers of the United States.
Yeah.
That's the one place where you're like, wait, why does it say commission officer of the United States if the president is an officer of the United States?
Sure, yeah, but it's around. It's never. I don't think it's ever clearly stated. It's always a roundabout.
He is referred to as an officer because think about this.
Wait, wait, which article?
Yeah.
Because this is the one part of the paper that they had. Because they said there's 24 different references or something in the original draft of the Constitution or whatever that has office of, but I don't believe there's ever an explicit part where they refer to him explicitly as an officer.
Well, they don't say a president is an
I think that was
officer.
part of the rule. Yeah, that's what I mean. That was part of the ruling. The Colorado Supreme Court was saying that he is an officer of the United States.
The impeachment judgment clause. So if you look at the impeachment judgment clause, that is, and I'll give you the direct citation. That's Article 1, Section 3, Clause 7.
Yeah.
It says, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. So that everyone agrees that the president can be subject to impeachment, right?
Yep. Yeah.
Everyone understands that. There's you can read the Federalist Papers.
No, I agree 100%. I agree with you. But even on that clause, it doesn't explicitly refer to him as an officer. Yeah, I understand what you're saying, though. I mean, it's obvious that he is, because who inhabits an office but an officer? And the idea that he wouldn't be an officer somehow is stupid. And I think there's also, in the paper, they cite debate on the floor at the time where people had an argument on whether or not it included the president. Hold on, I wrote this quote down in case this stupid thing fucking comes up. Where is it? It was the the Blackman-Tillerman argument. Third variant of the Blackman-Tillerman argument was explicitly made and explicitly refuted in the congressional debates proposing Section 3. Senator Reverend Johnson of Maryland charged that the language employed was defective because the offices of president and vice president had inadvertently been omitted from Section 3. The amendment does not go far enough, Johnson averred. And then, quote, I do not see but that any one of these gentlemen may be elected president or vice president of the United States, and why did you omit to exclude them? Johnson was complaining that these two officers should be included in Section 3, and there was no good reason to omit them, whereupon Senator Morrill of Vermont interrupted, let me call the senator's attention to the words, or hold any office, civil or military, under the United States. Senator Johnson promptly and somewhat sheepishly retreated. Perhaps I am wrong as to the exclusion from the presidency. No doubt I am, but I was misled by noticing the special exclusion in the case of senators and representatives.
Yeah. So what they'll say to that, what they'll say to that is, well, that has to do with the barred from offices, not the disqualification causing offices. I know that's a distinction that seems a little weird, but there's two parts to Section 3. One is like, if you took this oath, then you will be disqualified from these positions. And so that debate had to do with people who, the position from which you were disqualified. But it didn't say that the president is an officer for purposes of that debate of the disqualifying part, whether or not this is an office for which disqualification is possible. But just to be clear, if you take the view that there's a distinction between office under and officer of for these purposes, what you're saying essentially is that the framers of Section 3 intended this disqualification to exclude presidents, only presidents who had never held any other office, right?
Yeah.
Only presidents who had never been governor, presidents who had never been senator, state, anything, right? They wanted to exclude just people who had only been president, because of course, if you had ever taken an oath,
Any oath.
as another,
Yeah.
as anything else, right?
Yeah.
You would be qualified for that disqualification. But what they're saying is, no. The framers of Section 3 intended to exclude people who had only ever been president from being subject to Section 3. It makes no fucking sense.
Yeah,
and
the reading is just wacky as fuck, yeah.
And there's no policy reason why we would exclude, like, the Secretary of War. Where there wasn't like a rebellious Secretary of War who like defected to the Confederacy or like went to the Confederacy afterwards. And everyone understood this, that Secretaries of War who are not members of Congress, who are definitely who weren't labeled in the Constitution explicitly as officers, but everyone understands them to be.
Yeah.
Everyone understood them to be excluded.
Can you, here's a question. I'm trying to find info on this. For some reason, it's hard to Google around. Griffin's case is brought up a lot.
Yeah.
And the Supreme Court Justice, is it Chase?
Yeah.
Is brought up a lot.
Yes.
Two questions. One, because I heard Glenn mentioned this a lot too. Griffin's case was not a Supreme Court case, was it?
No, it's
It
not
was
a Supreme Court
okay.
case.
Okay, because I
So
keep
this-
hearing
the-
people refer to this as
yeah.
already ruled in the Supreme Court. Okay, so one
Yeah,
and
it's a
two.
great question.
Chase was not a Supreme Court justice when he ruled on it. He was an appellate
He was.
judge. He was?
No, he was he was the Chief Justice, Salmon. I don't know how to pronounce the name, Salmon Chase, and so he was what the Supreme Court judges used to do back in the day.
Oh,
Back
did
in
they rule on?
1864, they rode circuit, and that meant we have to
Gotcha.
haul our ass to all different places of the country to rule in like an intermediate level. So when Salmon Chase was ruling on Griffin's case, he was ruling not as the Supreme Court, but in a circuit court opinion.
Gotcha,
So
gotcha. Okay.
it's a little bit weird of a setup, but
Wait,
he's just
let me-
it's just dead wrong.
Yeah, grab me
that case
something-
is just horrible.
Grab me
It's-
something real quick. Hold on.
How y'all doing?
Okay, I'm here. Yeah,
Yeah,
I
so
read
he-
through the rationale in that case, and the all of the rationale seemed dumb. I think their argument is convincing, especially because at the end the rationale is essentially entirely self-defeating. That some
Yep.
were making the argument that, well, if one was to actually take Section 3 as self-executing, it would be so destructive. Which one is a non sequitur, is an irrelevant argument. Even if it was, it's an amendment as part of the Constitution. But also, two, the fact that Chase himself because of the arguments that he made around de facto judge ship, like not revoking essentially, like, or getting rid of habeas corpus or whatever, that doesn't even matter because he felt like he still would have been able to narrowly rule on the subject matter, and that guy would have just walked free just because Section 3 self-executing thing would have kicked another guy out of being a particular judge or whatever. So he defeats his entire argument by the end of the rationale of the case.
And also there was another case where he, I think having to do with Jefferson Davis. Jefferson Davis, by the way, that everyone agreed would not be able to run for president again. To give you some sense, like one of the arguments was we can't let Jefferson Davis run for or be president ever again, or anyone like him. That was so. For those of you who are like democracy, if they just trusted the people, as in the people in the future, they would have never passed this amendment. This amendment was passed for a reason. If they trusted individuals or states to do what was like correct, then they wouldn't have had to pass this amendment.
Well, and they also there would be no qualifications whatsoever on being president.
Right.
There'd be no age limit. There'd be no naturalization citizenship requirement. There'd be no term limits. Like that argument doesn't make any sense. Even in the original language of the Constitution, there is limitations on who you can elect for president. So the idea that there should be none is ahistorical and aconstitutional. Yeah.
100%. And so back to Justice Chase, he had inconsistent rulings. I think when he was ruling on that case, where the implication was that Section 3 did apply to Jefferson Davis without implementing legislation, which is kind of what this whole thing is about. But there's a more fundamental point here. First, I'll talk about the self-execution part. If you look at Section 5 of the 14th Amendment, which, if you do,
it's brought up a lot.
It says Congress shall have the power by appropriate legislation to enforce the provisions of this article.
Yeah.
This is almost universally always seen as a permissive grant of
and it's
legislative
additive.
authority.
It doesn't mean that the law
correct.
didn't take effect until Congress enacts legislation for it. Congress is just given the additional authority to
Yes,
pass
which
legislation
they've
they want.
exercised.
Yeah, but it doesn't mean that everything prior to that is just magically not law. Or that
Correct.
Congress has to actually,
Because if you look at the 13th Amendment, that has the exact same provision. Congress shall have the power to enforce this article by appropriate legislation. No one thinks that Congress needed to pass a law to execute Section 1 of the ban on slavery. No one thought that. No one thinks that. Equal protection clause of the 14th Amendment is applied without implementing legislation. The due process clause, which is one of the ways in which you incorporate your gun rights as against the states, no one thinks that Congress needs to pass implementing legislation to have the due process clause or to have the natural born citizenship clause. No one thinks that if Congress could get rid of the natural born citizenship clause by not passing a law enforcing it, it makes no sense. This is a self-executing set of provisions, and there's nothing by its terms that says, well, Section 3 is not self-executing, but there's other parts that we like, they are self-executing.
Yeah,
So
I
it's a
think that the
shitty
entirety of the arguments against this, and it's funny because the paper, it does like 2 pages on them, but I think the entirety of the arguments is, 1 is that it's a difficult question, and 2 is that it might produce I'm sorry, hold on. When I say 1 is a difficult question, what I mean is that particular qualification might be more difficult than the age limit. So they're like, oh, well, if it's difficult, then obviously we can't do it. And then 2, that's like an argument that people make. And 2 is that like the consequences might be far-reaching. And those are the 2 primary arguments. And neither of those are legal arguments. They're just not, right? Yeah.
They're not, and they're the things that's why I think they're focusing on this technicality of president officer, which is the shittiest argument there is.
Yeah.
They're focusing on that because it's an obvious way to not deal with the underlying things and to not have to solve this difficult question. And to just
Which
be
is
like,
so
oh,
fucking funny, and I
Yeah.
love that they bring it up so much, is because that is a very like living constitution type of approach to reading the
1,000%.
Constitution. Yeah.
1,000%. No, it's saying we shouldn't resolve this because it's well, I guess if you follow
hard,
their logic,
it's tough, it's inconvenient. Like,
even
they
though
really
no
wanna-
one said
Yeah.
it, right? Like no one said it. It's not explicit. Everyone understands officer to be people who hold office. What could officer mean other than someone who holds office?
Yeah.
And even one thing that they said, and this is the worst argument I've ever heard on that point, is, well, the way that they were going to prevent a president from being put in office, an insurrectionist president from being put in office, is the fact that it bans former presidential electors. That's the stupidest fucking thing in the world. The former presidential electors, it only would ban them if they were former oath takers. There were tons of insurrectionist people who were never oath takers.
Yeah.
And to which Section 3 never applied. So,
So in some
would
ways
be
it's
dead
like-
easy
I like that
to
they point out
find
in
some
some
people to be
ways.
electors who are insurrectionists.
Yeah, in some ways it's broad, and that like the definitions for like rebellion or insurrection are fairly
Right.
broad and can be assessed as such. But in other ways, it's actually way more narrow.
Yeah.
Than people.
Than it
Because
could have been.
You're not
It
being
could have-
life, liberty, pursuit. You're not the office is not property. They make that argument, right? You're not being deprived of anything because you're not allowed to run again. And it's relatively narrow in that you must have been a former oath taker who must have engaged or given aid to or whatever in some form of it. Like it's relatively narrow in who it applies to.
There's
Yeah.
a really, and you should bring this guy on because he's very, very smart. I think, in my opinion.
Bod or Paulson or
No. Well, I think if you reach out to Bod, Paulson, or Akil Amar, who is a constitutional scholar who is often like on podcasts and stuff and brought them up, I think if you reach out to them and gave them the platform to talk a little bit, I think they would say yes, or at least one of them, of those three. I really do, because I think that they have, and I think you should, and I might even encourage you to do that, and I might touch base with you separately on it.
Sure.
'Cause
Maybe, yeah.
they are, honestly, if you take anything away from any of your readings, it should be that the officer argument is the worst of all the arguments.
the dumbest thing I've ever
It's
heard in my
dog
life.
shit.
Yeah.
Couple other things on the question of whether states can enforce it. You'll often get this sort of argument
Whether
that-
states can enforce it.
yeah,
But they already
yeah.
do. They already enforce all the other qualifications for being
Right.
president.
Well, that's
Yeah.
number one. But like, an argument could be made. Well, no one intended that state courts should be the ones to decide this issue. We all intended
State courts
that-
don't have to decide. They already do. They already make the decision every time you go to list somebody. It might not be a court. It's going to be different state to state. I'm just repeating arguments on the paper, right?
Yeah.
But yeah, like you already make this decision when it comes time to list any candidate on a ballot in a primary or an election. You have to decide
Yes.
if they're 35, if they're natural born. All the mechanisms are already there. This is like one of the things that we argued about initially that I kept arguing about. But the mechanism part is not relevant at all. Even if a state has no way, it doesn't matter.
Yes, yeah.
It really truly
they might
does
not,
not
and they
matter.
might
Yeah. It might be, it really doesn't matter. The fact of the matter is that it's something that must be considered. So whatever part of the person, whether it's a person at a post office writing a name on a ballot, or whether it's a state legislature putting it on a ballot, or an election official, or Rappersburg,
If
or
they have the
whoever.
authority to do-
yeah,
yeah.
if anybody with the authority, whatever that process is the process is going to be the person who's in charge of making this determination. Yeah.
Okay. Yeah. Totally agree on that. And then even stepping back a little further, and this is going to unsettle some of you, because and I've already talked about this with Uncivil Law, I think, after you talked with him. But for those of you who don't know this, I'm sorry to bring this to your attention, because this is an unsettling piece of. You could think it's unsettling, or maybe you can think it's part of the framework of our government. And that's people don't vote for president. States are the ones who decide electors,
Yeah.
and states do not need to have elections for president. They don't. States are able to assign their electors in whatever manner they so choose. Obviously, they can't it's not plenary. I don't think in the sense of what. Who was the person you were talking to before?
Oh, Ricada.
Rakita. I think it's close to plenary. Obviously, they would have to. You couldn't say something like presidential electors can't be black.
Yeah, you
or
can't do anything
presidential electors-
non-constitutional. But I'm pretty sure that, like, if Georgia wanted to, I'm pretty sure Georgia, assuming they're not violating their own state constitution, Georgia could pass a law saying we are always going to vote for
Vote
the tallest
the
candidate or
Republican-
something. Yeah, and they could just do
Yeah.
it. And the citizens, I don't think would have. I don't know if you would have any recourse to sue, like in terms of federal. Like, you can't say, well, you're violating the Constitution, blah blah. Because I'm pretty sure states are.
Maybe once they had granted the right to vote through an election, the Supreme Court has described that once a state has decided to give you the vote for president, then the right to vote is fundamental, but they can take away the right. So, like, for instance, they couldn't say something like this: you can vote for president only if you're 30, right? Because obviously that would violate the part of the Constitution that makes the voting age 18, right? But they also have to abide by certain rights and protections that are afforded to most voting rights for legislative office when they decide to give you a vote at all. But they could take that right away. They could take that vote away at any time, and there would be nothing stopping constitutionally from that happening.
Arguably, don't they kind of already? Because I mean, if you're saying California and you're Republican and you vote for president, you literally have zero voice in the electoral college because
Sure.
California allocates 100% of its electoral votes to
The
whoever
winners
wins
take all.
51%.
Yeah.
Yeah, you literally have no voice. Yeah. So I mean, and different states do that differently. Like Maine and Nebraska,
Nebraska do it
apportion
differently.
their So yeah.
And so states were always designed to be this, the people with the primacy in deciding this question. And so it's not weird at all for states to be the ones who decide elector qualifications at all. It's not weird. It's not random. It's really 50 state elections. And the question of why is Colorado deciding this? Well, Colorado's process allows for, we're not going to allow disqualified people to be on our ballots for primary or for the general. That's their process, because guess what? It's their election. It's their process for assigning their electors as a state. That's also why Texas has no standing as to Pennsylvania.
Why would they? Yeah.
Yeah, Pennsylvania can assign their electors however they so deem, so long as it comports with the Constitution. But they don't have to listen to what Texas has to say about that.
Fuck, were you in here when I brought up that somebody mentioned that point? That in the Rekieta debate, I should have caught this, but he argued so aggressively in favor of the plenary power of the state to do whatever they want. And then in the next breath, like 5 minutes later, was arguing, well, actually, one state should be able to tell another state how to do their election. Like, wait, where did the plenary power go? Wait,
It's
what?
very inconsistent.
Yeah.
And also keep in mind that, like, the states had already decided. If you believe in a state's a plenary authority to assign electors, and I believe in something close to that, not 100% all the way there, but like very close to plenary, then once they decided to assign their electors a given way, then that's it. And you can't be undermining that, because that would be, of course, undermine the plenary authority of the state.
Yeah.
What he's arguing for is that random ass citizens from nowhere should be allowed legally to undermine the plenary authority of states to assign their electors, which is totally a contradiction, in my opinion.
Yeah.
On the definitions of insurrection and coup, self-coup, all that stuff, I've sent you some things that I think you need to walk into that debate with these definitions.
I feel like I can. I think I've had enough practice of this, and I've seen so many of these definitions. I think that there can be 20 minutes spent on, like, give me a definition. What do you want to say? And there's just, I don't think you can possibly spin a definition that doesn't incorporate January 6th into it. It's
I agree.
just wild to me. The only possible way they can do it, you can tell because of their rhetoric, the only way they can do it is to downplay the fact of the matter, which shows me that they don't disagree on it. Because nobody will say this. Nobody will say, okay, the people were there to protest the actual transfer of power and to protest against the government's authority to run an election, and there was violence and they managed to delay it, and Donald Trump was... Nobody will say that. They'll say, well, it was a 2-hour protest and the cops let them in. And I think that when they have to go to those arguments over and over again, it's because they know that if you grant the fact of the matter, which is recorded on like 50 billion fucking cell phones, okay? If you grant all the facts of the matter, the insurrection attempt is obvious. It's like self-evident. Like, it's so obvious.
Yeah. I would agree with that, but you need to have like a game plan. And I think the game plan going into that is you have 2 or 3 definitions of insurrection that you think are good. So I've given you 2 or 3, and you need to just have those. And when you give that definition, I think that you need to be like, what's your definition?
Yeah, that's what I'm saying. It would
Greenwald?
probably, yeah. I just stole from
And-
you probably linked to the same thing, but yeah, I just stole from the insurrection stuff that they lay out on the paper. Yeah.
But also grab the one from the Colorado trial court, which I gave you, because one of them is the theoretical one, and the other one is how a court actually interpreted it. You can notice they're different, but they both will at least include what's in January 6th. Same thing with the coup, self-coup stuff that I talked about below. But I really think that the steps for getting him to admit it's an insurrection is this is my definition. It's backed by the historical record and a bunch of examples that the framers of this amendment understood to be insurrections. What is your definition, and what would it include? And if the answer is, well, I don't want to give you...
I understand what you're saying. I don't think it'll come down to that, though. I don't think he'll ever... I think the problem is that he'll fight on the facts. He'll just say that, like, Trump didn't intend this and blah,
You
blah,
don't let
blah,
him.
blah, blah. No, I know. I'm
You'd
just
be
saying
like-
that, like, I don't think our disagreement will actually be on, like, what an insurrection is.
I think you will have that disagreement.
You think
just to be
so?
clear.
Okay.
I think if you're like, what is your... Glenn, you're saying that it's not an insurrection. What's your definition of insurrection? You put him on the spot. Right?
Yeah, of course. That's what
he
I'm saying.
better have something
yeah,
ready.
I can ask him, but, like, yeah, I think it's going to be a fight over the facts.
But then it's going to be like, okay, so under your his definition will either include things like the Whiskey Rebellion, the LA riots, the attack on Fort Sumter, or it won't. If it doesn't include that, you'd be like, wait, how does your insurrection not include these classic insurrections in American history? And if it does include them, then you show the comparison, the facts, and how the Whiskey Rebellion and the initial violence of the Civil War, in terms of the comparable amount of lives lost, there wasn't a huge loss of life.
Yeah, it
right?
doesn't even work, actually, which was another 2 really good arguments in favor. One is that, hold on, fuck. I'm positive I was in favor, but I don't want to say this because I don't know much Civil War history. In Fort Sumter, did nobody die? Or was it just 1 or 2 people?
One person died by accident after
Yeah,
the thing was over.
So that was one of the arguments they put in the paper.
And
Like, well, if you're
Lincoln
going by loss of
invoked the
life-
Insurrection Act.
Yes, yep,
Lincoln invoked
yep.
the Insurrection immediately.
There was
And
insurrection
everyone
there. They
acknowledged
bring
it
up
was insurrection.
lots of Insurrection Act evocations, which is interesting to see how they thought of insurrections at the time. And I think I had like 2 or 3 Yeah. Oh God. And they have them over election results where they bring up.
Yes.
Yeah. I've got like 3 of these written down. They bring up the
That's
paper,
one of the
all in
main
the
ones. I mean,
1800s. Yeah.
And one thing that Akhil Amar did that brought to my attention, he's a constitutional law scholar, is that I actually didn't know that there was these alleged attempts on Lincoln's life, Abraham Lincoln's life, when as soon as he won the 1860 election, and that was one of the moments that many Republicans at the time, would like cite to and would know about and was in their minds as like an attempted insurrection if they had succeeded in killing the incoming president of the United States. That is another moment where like, okay, this entire war, this entire insurrection, this entire rebellion was premised on slavery, which itself was premised on the election and the failure to accept the results of that election of President Lincoln.
Yeah.
And so it's totally like, it's actually crazy how many parallels there are to January 6th in terms of these initial moments and
And
the
there's
lack
there's
of-
so many things that come up too where it's like none of the so for instance people that were disqualified relating to the ironclad oath, none of these people required convictions for
Oh,
insurrection.
yeah, that's another
none of these
horrible,
people
horrible
required there was no court process for any of these people ever. That was never a question. And also to engage in insurrection for the definitions that they gave, a lot of this stuff would have encompassed what wouldn't necessarily be a criminal act. So the idea that over and over again people are like, well,
100%,
charge
yes.
him with insurrection, charge him with incitement. You don't need to be charged with insurrection or incitement historically to have been prevented from holding office under the ironclad oath that was instated at least for a while after the Civil War. Like you never needed to have any of these criminal charges ever historically. That's just never been the case.
100%. And these were smart lawyers who wrote this amendment. They knew how to put the requirement for conviction here. If they wanted to include
course.
it, they would have. They wrote the conviction stuff in other parts of the Constitution.
Yeah, they had it for
people were
the
aware of
treason
it.
stuff, I believe, right? You need 2 witnesses. You need, you shall. I think they even wrote conviction. I think as part of it.
These
Also
people
the,
knew the
um,
difference. They
oh.
knew what a conviction was. They knew
Yeah,
what
there was
criminality was.
An interesting thing too, I had this question as I was reading, and then they answer it almost at the end of the paper. Somebody said in chat, ultimately, they want you to also admit that other left-wing protests were insurrections as well. That might be the case. However, we're talking on the federal level right now. If you think that there was a state insurrection or something going on, then you need to go and that's a whole other question of state constitution and the states enforcing that and how they do all of that stuff. That's a whole separate thing.
Yeah.
However, remember too that the arguments that are being made by this paper are not ones of criminality or not ones of right deprivation or not. It's nothing like that. So nobody's talking about go back and charge all the BLM people. Nobody's talking about arguably even charging Trump with a crime. It just has to do with whether or not a former oath taker can hold an office after having engaged in rebellion or insurrection or offering aid or whatever comfort to. Yeah. So none of that applies to the BLM stuff. It has no application whatsoever.
As
Although
a
they might be-
sidebar, did we ever, hang on, Pisco, did we ever get an answer as to whether or not insurrection was even a formal crime at the time of the ratification?
No,
Because I
no.
thought the code was
I'm not sure.
1948.
No, there's no insurrection or rebellion because in the paper they spend like 2 pages trying to find other definitions, but it was never like formally defined as a crime anywhere. Even when it's referenced in, I think that U.S. code you bring up, they just talk about like the rebellion crime is if you engage in rebellion. It's like, okay, thanks.
Right, because I don't think it was codified as a actual like federal crime until like 1948. And I know that came up in previous conversations and debates that Pisco and I had with others, and we could never get a solid answer if it like had a Civil War era predicate. But I don't think it did.
And there's a well-meaning comment in GGG, I think, from Kagan. It says, why would they do that, though? Wouldn't you want a conviction for this kind of power, for the ability to remove someone from politics? That question isn't a question, even though it's well-meaning, I think, that matters, what I want, right? What I want in terms of procedure, like what the procedure should be, isn't relevant to what the framers designed, right? And if they had wanted a criminal conviction to be a requirement, they would have said so. But the reality is, they didn't want that. They didn't want to have all these trials for thousands of people before this applied. If they had intended there to be like a massive amount of trials for all the previous oath takers who were engaged in insurrection, you think that it would have come up in the discussions. Why can't we point to a single source at the drafting that said, hey, this is only going to apply if there's a criminal trial? Why can't you? Because the truth is, it doesn't require it.
The problem too is that whole line of argumentation, which I'm highly sympathetic to, in that like, man, this seems like it could kind of suck or have far-reaching effects. That might be true, but that's not an argument. Unfortunately, if you believe that the Constitution is the law of the land, and if you believe in the amendment process and that it amends and adds to the Constitution, you kind of have to follow it as written. It doesn't really matter if it would have far-reaching effects, or like, man, don't you think they should have included, conviction requirement here? Maybe not, but it doesn't really matter.
well-
It's not a real question. It doesn't matter, right?
Well, obviously, I don't believe this, and I don't think either of you do too. But what if they try to use that logic against you, like Greenwald says, okay, well, Stephen, by that logic, why didn't they enumerate the presidency as an office? Now, obviously, we
I don't
think
think-
that's bullshit, but like,
They
could we
did.
say
No,
it's
no,
the
they
same
did.
logic?
No,
Well-
they 100% did. The
Oh, no,
question
wait,
is like,
yeah, the
did they
president-
ever?
Or sorry, I don't know why you interrupt you. Go ahead. My bad.
I was just going to say the president is an officer. Everyone understood the president to be an officer. It says that the president holds office in the Constitution. Anyone who like wants to quibble about the difference between holding office and being an officer, I think is engaged in the most bad faith hyper literalism that isn't ever implied. Like we understand that officers are subject to impeachment. The president is subject to impeachment. Officers hold office. The president has office. If you look at the records, everyone referred to them as being officers at the time of the drafting of this amendment, before the drafting of this amendment, all the times previous. It's an officer holds office. And there's an additional piece of research that found that during there was a drafting about how to interpret parts of either a law that was being written by Congress at the time or some other provision that they were writing. And they even explicitly said at the time that like we are anytime that you find the word officer of, office under, or office of, like we are intending that to be the same thing. I can provide that for you, but like essentially that this is all understood to be
I would definitely
encompassing
like
the same
that.
thing. Yeah.
But yeah, so you would just reject the premise. You would say, no, listen, it's
clear,
covered
yeah.
under the general.
Unambiguous.
Yeah, gotcha.
Unambiguous, because what else could they be, right? You are
Like, who is
the Supreme
executing
Court-
the office of president of the United
Right.
States, if not the officer? Like, it's just such a bizarro that is never in any part of our history. I don't think it's ever been debated. Like, well, is the president an officer of the United States? I don't think that's ever been debated. And then, even if you just imagine, like, the implementation of the amendment, why would the president of the United States or the vice president be like people that couldn't maintain their oath? Like, why?
No, I completely agree. I was saying, just kind of like workshopping any sort of like counter argument if somebody wanted to say, well,
what's the
using that
rationale?
logic, would the fact that the president was not specifically enumerated, given that they mentioned senators and representatives and electors. Now, obviously, constitutional.
Wait, but they don't. Wait, I want to stop right there because that's a good point. They don't mention Supreme Court justices. Why are they included?
Correct.
Right. They don't mention secretaries of defense. Why are they included? Because everyone understands. You need to list out separately Congress people and electors. Why?
They're not officers.
Because, electors don't hold office, and
Yeah.
Congress people don't hold office. They don't. They are members, and that distinction comes from the English common law and was well understood by everybody, and it's consistent throughout the Constitution. The Constitution does not refer to Congress people as officers; it refers to them as members. And there's an additional wrinkle here, right, where you cannot be both a congressperson and an officer of the United States at the same time, right? Mm-hmm. People agree with that?
Yeah.
I think it's called the incompatibility clause. Someone can correct me if I'm wrong. But if you were to read the president to not be an officer of the United States, then what you're saying is essentially the president can also be a congressperson at the same time.
They could also serve, as president even after they're impeached, because I'm pretty sure like the impeachment, like the first part of the clause references the president, but then it goes on to say can't hold any, they can no longer hold high office or public office afterwards, which means that you could successfully impeach and convict a president, and then they could just be president again because the presidency itself is not in office. So it's the same logic.
It's the worst argument, and I am not confident a lot with the Supreme Court, but if there were one ruling that I'm pretty confident on, I would say 98% confident on, is that the Supreme Court of the United States is not going to say that the president is not an officer of the United States or doesn't hold office in the
It
United
would be
States.
very wacky.
Well, hang on. So that's the other thing too. I was going to ask you about, because I know you've seen this piece go. I'm pretty sure the Scalia era court. I've seen like in some of the papers. I think it might have been McConnell's paper against, or one of his op-eds, that he refers to a Scalia era decision in which the Supreme Court said that officers are appointed, not elected. So could Greenwald hit Stephen with that? Say, listen, we actually have more recent judicial rulings which say, or which at least suggest that because the presidency or the president is elected and not appointed, he can't be an officer.
Yeah, so that is okay. Wait, can you remind me again which provision you're pointing to?
Oh, I can find you the article itself, but it's like a Scalia era ruling. So it's like within the past 20 years, and there was a court ruling in which they referred to they made the argument that officers are appointed, not elected.
Oh, right, yeah. And, as opposed to commissioned, right? The commissioner.
Right, correct.
Right. So I think the best argument is that the president gets the commission equivalent from Congress. That Congress is the one who commissions the president on January 6th that day, right? So there doesn't need to be a separate commission provision for the president of the United States because there's specific commissioning procedures already for the president. That is the sending of the electoral votes to Congress who counts them. That's the commission equivalent. And so you can be like, therefore a president not an officer of the United States. That's just a bizarre way to read that clause as an implicit rejection of the notion the president is an officer of the United States. The better way to read it is, no, it's specifying that the president has the power to commission all officers except for himself, who's commissioned by Congress with a commission equivalent. That's my
just as like a macro step back, and I know that like a conservative would never admit it, but maybe for like 1% of them, like just think for a minute all of the carve outs we're making for literally God Emperor Trump. Like, not only is he not an officer, so none of this should apply to him, he's also fully immune from all civil and criminal liability. Like, what kind of carve-out are we making right now for the president of the United States? If like, apparently nothing applies to him, he's above the Constitution, he's above the courts. Like, it's such a bizarro world to make these claims. And not see that there might be something problematic about the road you're going down, you know?
I mean, you're literally arguing that the president holds office, but is not an officer.
Yeah.
Well, I'm editing a video right now, but I'm 99% sure that in the crew appellate brief, and I sent it to you, Stephen, but I haven't looked at it in like 2 months. But I'm pretty sure in the appellate brief between the Colorado District Court and the Colorado Supreme Court decision, Crew points out, and Pisco, you might remember this, that at various points in Trump's many lawsuits over the years, he has almost been like Schrodinger's officer. He has in lawsuits said, you know, he's appealed to the fact that he is an officer or was an officer as the president of the United States. And now he's, yeah.
That's part of his officer immunity argument. So he argues that he is an officer for purposes of being immune from criminal things or from civil things, right? So he argues that he is not subject to certain suits while he's in office. And that has to do with like his officer immunity. But he's not officer for purposes of disqualification. It's totally backwards. It's totally outcome driven. And the argument's not going to win. I really don't think it's going to win in the Supreme Court. It might be reversed on other grounds. The Colorado Supreme Court could be reversed on other grounds, but not on that one. That one is crazy for sure.
But that's okay because we've got a court who doesn't value stare decisis, who is very originalist, right? We had no problem tossing Roe and Casey because if it's bad law, it's bad law. So I'm sure they're going to go right back to the origination of this. They're going to do a contextual reading of everything that was said at the time. They're going to see exactly how it ought to be applied, and I'm sure they're going to deliver a just and fair ruling on it, right?
Yeah, I mean, let's hope. I've not been more confident in terms of the law. This just seems like such a slam dunk argument in every respect, and I don't have any really good pushback. I don't think. I go around and discuss this with other people, but they almost always want to argue on the particulars of whether a president is subject to this disqualification at all. But very rarely do people actually want to talk about what Trump did.
I think
the scope
that
of insurrection.
it's either it's either weird non sequitur points like, well, wouldn't this be bad or something? Like the legal arguments. Yeah, the strongest legal argument is probably the one about the officer thing, which is probably ridiculous. All the other faux legal arguments like, well, this would be really inconvenient and maybe it's hard to to figure out like if he's engaged in an insurrection. Like none of these are relevant on a legal level. And then on the fact of the matter, there's a requirement that you've rewritten what happened. It was just a 2-hour protest. Trump didn't really know or engage at all. The elector thing, that never happened. And that's it. Oh, I also like the point that they put out. I wish I would have read this paper 2 months ago. I think it's a waste of time to engage in Trump's state of mind because it really doesn't matter.
I think it
There's
matters.
no good faith exception.
They make the argument in this paper.
hang
Yeah,
on.
there is no good faith exception for doing a coup or rebellion.
Yes, yes,
yeah,
I
because the
agree with
people in
that.
the South
I agree.
believed that they were doing another country. They thought it was the second country. They really thought
Yes.
there was constitution. Doesn't matter. Trump's
I
state
don't
of
know if you
mind
heard me
is
say that during
yeah.
the debate on Kick or Keep, but that guy kept saying it, and this is good logic. Kept saying, well, he actually thought that this was legal, and that's kind of the flavor of Rakita's argument about fraud too.
Yeah.
Well, they thought it was legal, and they thought it would be okay, and so therefore, there's no good faith exception for that in the Constitution, or
Maybe for a
or in
criminal
criminal
conviction, maybe, but that's not what we're talking about here. It has
I
nothing
don't
to
even
do with
think for
this.
criminal.
Probably not, but yeah.
The thing I want to say where his intent does matter, his insurrectionist intent matters. That the intent to do the insurrection and to engage in it, that's of course what matters.
Yeah.
Not but the intent to like whether or not you're doing something legal or illegal, that doesn't matter.
Yeah, and I think
it's
I
about the
kind
intent to do the
of,
insurrection.
I think I got there in a roundabout way when I started pointing out that conservatives like, you guys need to understand that you're not arguing that it wasn't an insurrection. You're just arguing that the insurrection was justified, which is essentially
Yes.
what people are doing.
Yes.
'Cause- Yeah.
Which it could be like you could argue that it was justified. People
Mm-hmm.
argued at the time that the secession from the Union was justified.
Sure.
People honestly thought that, and in response to what I think, this is good logic again, said that the attack on Fort Sumter, they knew what they were doing was illegal. They had arguments for why it wasn't illegal. They
Yeah.
said it was legal because you're occupying our land. We're free now from you, and so what you're doing, you're trespassing on South Carolina. It's absurd to think that there would be a carve out for people who were like in good faith, I don't know, not believing the true illegality of what they were doing. But that's not what this amendment was. This amendment was radical in many ways. So it was conservative in the way that you specified, that it only applies to previous oath takers and not to everybody. That's the way in which it was conservative. But it's radical in that we're not treating these people with kid gloves. We're disqualifying them because they have the gall to try to send some of these people to Congress after that
Which makes
they
sense,
did this.
right?
Yeah.
We just got through the Civil War. I mean, yeah, it super makes sense. So if it seems a little bit heavy-handed or if it seems a little extreme, I mean, yeah, it was the end of the Civil War. Yeah, it
And
was
there's
Reconstruction.
one body that you should be going to, and it's not the courts. If you think that this is too heavy-handed, it shouldn't apply to you. There's exactly one organization that we know can get rid of this.
Which is in the amendment
Congress.
process through Congress.
No.
Yeah. What?
In Section 3, the second
Oh,
sentence
you're
of
right.
Section
Because
3,
well, I was thinking if you wanted to remove them entirely, but
And
you're talking
no
about
one's
the carve
arguing
out
that,
for
right?
Congress. True. Yeah.
no one's saying, hey,
Because Congress
you
can
should-
write an exception.
Yes.
If Congress chooses by majority, Congress can say this shall not apply to whichever person they want. If Congress rules that carve out,
Yes.
that explicit carve out was created at the end of Section 3.
Section
yeah.
3. Yeah. So, but you don't ever hear conservatives being like, hey, let's just go to Congress and because they know that obviously it would never pass.
Yeah.
But that's the institution that's meant to do this. And so if you have a good argument for like that is supposed to be the safeguard against the courts running amok and doing something crazy, you have Congress. That there's no argument to that in terms of like, well, I think it's inconvenient to get 2/3 majority in Congress. Well, I'm sorry.
Too bad.
Then.
Yeah.
How you doing?
Well, I'm annoyed that I stayed up until 9 a.m. reading the shit and he fucking dipped.
You're gonna
on
be
me.
super ready though.
I guess it's kind of disappointing. I feel like it might be an hour of ad homs because I checked out this guy's background and everything. Apparently, he was like a constitutional lawyer. I think he's made 2 videos on this subject, and both of them are fucking horrible. He doesn't engage with any of the legal arguments
No, he
ever.
doesn't.
For the Colorado one, I think he spends about half the video talking about how it's a blue state and there are 7 blue judges and they're all Democrats. Like, okay, well, talk about them. Like, what? Talk about why their ruling is bad. You're
unconstitutional?
literally I think his background is actually as a constitutional lawyer. He should be the most qualified person to talk about why these particular arguments are good or not good. And then in his video discussing them moving from the ballot, yeah, all of the arguments are just they're not legal arguments at all. It's just like, oh well, what about BLM and it's like, okay, yeah, it's just stupid.
And also, we'll bite some bullets. Like if there was a BLM coordinated attack, and when I coordinate, I mean just like one, or like more than one person. If there were 2 people who were engaged in an attack against the federal courthouse at BLM, I would say, yeah, that's a fucking insurrection.
Oh,
It's
but
significant
unfortunately, because we're arguing about the amendment, were those people prior oath takers? Because if not,
Right,
this doesn't
right,
apply
right,
to
yeah.
them, right? Yeah, exactly.
Exactly,
Yeah.
yeah.
Because like, do you want to apply this to all of them? Yeah, sure. How many of them were elected officials? Oh, well, there you go. Yeah.
enough. But I would still call it an insurrection for like
Again, when
definitional
Pisco and I
purposes.
have these conversations, when they say things
Loser. Absolutely shut down. Absolutely fucking destroyed.
I hope he's all right.
He's not. He just got Section 3.
He got Section 3.
He's out of here.
He was a previous oath taker to not shit up Discord, but here he is.
Unbelievable. Also, one quick.
Oh, wait,
hey,
what's up?
Josiah,
You got cut off completely.
you cut out massively.
Oh, sorry. It's this because this fucking video was rendering. I didn't notice. My bad. I'm sure I said infinite wisdom though.
You said you were talking about Glenn, I think.
No, I just said that like your advice to just bite the bullet on BLM with the whataboutisms.
right.
I think that's great because it always shuts people down every time we have this conversation. You and I get hit with a what about BLM? It's
I'll
like, who
bite
cares?
bullets if I have to, but I actually don't think you have to bite. I don't think you have to bite any bullets. I think that the arguments put in this paper are rock solid. One.
Oh no, I agree. You don't
is the
have to.
BLM
But
stuff-
if you just want to like,
No,
if you
I
just
don't.
wanna
I
skip
don't
a
want
step-
to. I don't want to.
You
I
don't?
just want to speak
Oh.
to the law, to the legality of what's listed, and the actual material of the paper. Section 3 is an amendment for the federal government. This doesn't apply to state insurrections. I
But
don't
if
know.
they
Like,
attacked federal courthouses, then it could be, right?
sure. If
attacked-
they did attack a state federal courthouse, and if they were engaged in that, that's fine. Then fine. Then if they were a prior oath taker,
Oath
then they
taker,
ought to
yeah.
be barred from holding future office.
100%.
But that's not what they want. They don't want that. They don't want
want
the. They don't
Kamala
want
Harris,
the.
yeah.
No, not only that. They don't want the self-executing part of Section 8. They want criminal convictions. None of this has to do with criminal convictions. None of this has to do with criminal indictments. None of this has to do with with literally the judicial system at all. It's just a qualification for being
President.
yeah. Not just president, but yeah. So none of this is even.
Oh, right.
None of this is even relevant. Yeah. So I don't think I would bite any bullets on the BLM part. I'll just
Even
argue
if they try to
everything apart.
bury you in whataboutisms, like because that every time we talk about the 14th Amendment or anything pertaining to Trump, it's always BLM or Hunter Biden. That's my experience with it. I know that's Pisco's experience, at least when he and I tag team debates, and I feel like the debates
I
I've
just
watched
do
with
one
you,
sentence
Stephen.
on it. I
Yeah.
just do one sentence on it. I say,
Yeah.
listen, if there were BLM members who attacked a federal courthouse or had in any way tailored their insurrection towards federal things, then it would be, applicable under Section 3 potentially if they were previous oath takers.
If we've
But-
determined also that they've engaged in insurrection or rebellion,
Insurrection.
and that has to be
Yeah.
more than just an attack. I think we all
Yeah.
agree that it has to be more than just an attack. January
Yeah, it has
6th
to have
is
a
more than
specific
just an
purpose.
attack. Yeah.
Yeah. And I would bite the bullet and say a lot of the BLM riots were insurrections, but I don't know if they were insurrections against the Constitution of the United States. I know that like the Chaz Zone was an insurrection. Was it an insurrection against the Constitution of the United States? That's a harder question. But I don't have a problem
that
biting-
felt like against a state, city or state. I feel it would be.
Yeah, but like to the extent that there were any like big federal assets or big federal.
Oh, I guess yeah, I'd have to
there,
see what the
right.
territory encompassed.
It would matter, right? Because like if imagine that there was like this is where they housed a bunch of military officers for or they this is where they were.
Well,
big
but
federal
also for
courthouses.
the arguments in the paper, it's more than just like attacking a federal officer too. It has to be with the explicit intent to try to disrupt like official federal business. So, for instance, if they were doing something at a courthouse to prevent them from like levying or collecting taxes, or prevent them from some form of like federal government administrative business, then sure. But if Chaz existed and there were federal houses there, but like people were going to work and leaving as they do, I don't really think you have an argument there,
But
right?
if the purpose was if the purpose was, and we had a bunch of messages or a bunch of testimony that said, "Hey, what we were trying to do here was we were trying to prevent the 300 military officers here from conducting their duties as members of the National Guard."
Yeah.
I think that would be significant enough and tailored with the intention to undermine and disrupt the enforcement of federal law. And so that to me would very much sound in an insurrection. I would have no problem applying it to left-wing people. at all.
And the chain of it is so easy. Like, guys, like our country's being stolen. We need to have Pence do this thing. They all march to the Capitol. They literally delay the certification of the vote. They're all screaming 1776, hang Mike Pence. Like, they believe that the election was stolen, so they're trying to protest like a legitimate function of government, which was the election process. Like it meets in like 17 different ways the qualification for being an insurrection. It's not even close. Like, whatever the line would be, I think, what do they use in the paper that like there's a like safe harbor versus like shore shipwreck is one phrase they use.
Shore shipwreck and,
yeah. And then like the bullseye of whatever we're talking about that might be on the peripheral. This would surely be like a bullseye scenario that would be fully encompassed. Like, whatever you call an insurrection is so obviously past the line for that in like 15 different ways. Yeah.
There's a comment in the chat. What about stopping the Senate confirmation? Now, insurrection requires the use of force or threat of force, in my opinion. It's not just people who are, use procedural things or things that are not force or threat of force. So if there were an attempt, right? So there was an attempt recently to kill Brett Kavanaugh. You guys forget that? Remember that? Mm-hmm. So the
guy found outside his house, you mean, the gunman?
Yes, yeah. If this was a plan with more than one person, right? If there were more than one person engaged in this effort, then in my opinion that would be an attempted insurrection for sure, 100%. On the specific stopping of the Senate confirmation, for the people who were trying to do that, either A, were in, I believe, in places where they were allowed to be. So they were allowed to be in, Congress was open that day. And so to the extent that they were breaking a law, it was not in terms of their presence, but in terms of their disrupting the procedures or like speaking out at the actual confirmation hearing, or like cornering a senator or something. But it wasn't a threat of life, right? It wasn't a use of force in that context. And I think if you interpret that to be the use of force, I think you have problems.
I also think, I'm curious how important we feel like the use of force is. For instance, would you consider all rebellions insurrections first?
Sorry, go ahead. Say that one more time.
Would you consider all rebellions insurrections?
Yes, I think almost all.
So then the question, here, like one question would be, because I think they brought this up in the paper, is
yeah.
So after Abraham Lincoln, I think like South Carolina, I think they voted to secede or whatever from the Union, or they started to do that. And I think 6 or 7 other states joined them soon after. Like, would you not argue these states are in full rebellion without any violence happening, or?
Yeah, that's a harder question. My inclination, I want to amend what I just said. My inclination is that yes, there is some rebellions that are not insurrections, but I doubt that the Supreme Court will go there, because basically what it would be a more disturbing set of circumstances. But essentially, you could make the argument that Trump's
hold on, maybe
illegal.
When we say disturbing set of circumstances, though, remember, while maybe broad with how we define insurrection or rebellion, we're narrow in who's affected in this particular case and what the effect would be. Because when we talk about like violation of due process, or they bring up like the writ of attainder and stuff like that, right? We're not really talking about depriving people of anything. There's no criminal question here. It's a question of like whether so that's the thing that I want to push on, because I used to ask that question like, well, what about this, or couldn't this lead to this? And it's like, well, hold on, we're pretty limited in terms of what we're actually saying here, which is that you can't hold office again, So even if we were to broaden like the rebellion or insurrection, we would say every single person at J6 was an insurrectionist. There might be absolutely nothing. There's no negative outcome for any of that. Theoretically, if none of them held office, it really would have no impact whatsoever on them, because we're not talking about a criminal matter here, right?
That's true. I just want to say, if you're talking about the rebellions that are not insurrections, you're talking about essentially things that are not necessarily forceful. A peaceful rebellion, or a legal rebellion that doesn't require the use of force. That, to me, I agree that could conceptually be true. I don't think we need to decide that now, and I think that you should be like, I'm not so sure. And I think even Bott and Paulson they say that it's possible that there's that like sort of segment of rebellion that's not forceful, but they don't really have a lot of confidence in it. So I would just be like, it's possible, but it's not something we need to decide right now, and I don't have strong feelings about it.
Sure. Yeah.
Where did you end up on arms? Because I seem to recall, Pisco, you had a debate recently with whatever the chain smoker red pill guy is, and I remember you and Rob Noor and that guy were having a conversation about it, to what extent lethal arms were necessary.
Lethal arms are not necessary.
Well,
and I don't know
it's stupid, because like you just said, like we could imagine like 100 people breaking into a courthouse and just beating everybody up, and like, oh well, it's not an insurrection or rebellion if they literally hit every other thing because they didn't bring a gun. But two, the dumbest part is people did have arms there. Doesn't matter. People were using batons. People were hitting people with flagpoles. Like they have arms there. You only need 1 or 2 for it to be arms, plural.
Well, Stephen, if it was a real rebellion, why didn't they use any of the firearms that they got through the magnetometers or the metal detectors? Or
I don't know.
Like
why
that?
did only one person die at Fort Sumter? I mean, I mean, it doesn't matter.
Yeah, no, I agree.
You
That's
can
just
ask the
stupid.
question. Yeah. But.
I hear you. I'm like workshopping this in real time, because like listen, like I told you in the conversation we had in private, that my card's on the table. I've been a fan of this argument since the day it was unveiled. Pisco actually, and this is where I think nobody can question his credibility on this, because Pisco publicly disagreed with me in my interpretation of this, and then eventually changed his mind, right? So he came to this not out of any sort of partisan loyalty or whatever, which I may be accused of, but I don't think there's any compelling argument to this. And my understanding is based on, again, the appellate briefs and the documentation surrounding Colorado. Even Trump's constitutional expert that he brought for that 5-day bench trial in Colorado conceded that the majority of constitutional experts, and I think that was an exact quote, actually agreed with Cruz's argument that Trump was disqualified, right? That he kind of conceded that in his estimation, the majority view was that this applied to Donald Trump. So it seems to me that there's some sort of, I don't want to say consensus, but I don't think this is a 50-50 issue, but Pisco can probably speak to this better than
I don't think it's a 50-50 issue. There are some good scholars who don't agree with it, but they don't agree with it
On
for
what
bad
basis?
reasons.
Yeah, that's what
so,
I'm curious
like,
what the
you'll-
basis is. Yeah, because it's
you'll
not going
have,
to be on like, well, it's not insurrection. It's not going to be on the retarded arguments that 95% of conservatives are making. Would be my guess.
Yeah, it's largely falling on people who are either one not making specific legal arguments and are making more like practical arguments. This I put in that category. Oh my God, now I'm not remembering his name. I'll get the names for you, but there are some scholar Noah Friedman, is that his name? Noah,
I don't know.
what's his name? Oh my God. It's not Friedman, is it? No, it's Noah something. I think his name is Noah. Who will just make like sort of a consequentialist argument against it, and then the rest of them are kind of funneling down the arguments on the officer, which are the worst of the arguments in my opinion.
Yeah.
It's just an awful argument, and even Trump's lawyers concede that President of the United States is an officer. They just say it's not an officer of the United States.
I'm just
which
so
is, like, a
curious
weird-
how, because when we make the consequentialist arguments of, like, consequences of what? Of like waiting
of
so
doing
long
this,
to
yeah. Noah
enforce
Feldman
it.
is the name,
Of
yeah.
yeah, no, but I'm curious, like, what is it the consequence of? Because lots of things in the Constitution have far-reaching consequences, and the idea that it's inconvenient or might produce a consequence that we don't like—that's not a legal argument, right? That's just like this
Yeah.
feels kind of bad. Or if you
And no one
want to
would
take
argue
the
that.
point of like it's a 9-0 ultra progressive, living, breathing document court that just wants to, legislate from the bench and whatever. I guess if you want to make that argument, it's fine. But with this court, I mean, who are willing to reevaluate, 60-year-old watershed, 80-year-old watershed decisions or whatever, like it just seems it seems wholly inappropriate, yeah, or not inappropriate, like inconsistent with what conservatives always jerk themselves off for their constitutional understanding, right?
Yeah.
Well, Glenn hit you with the, okay, well, Stephen, how can you be a Democrat and, proselytize the virtues of democracy when the thing you're arguing for, by definition, even if it's mandated by the Constitution, is anti-democratic?
Nothing is more
'Cause I hear that too.
democratic than the fact that we have a single document by which our government rules. We have a process by which we can amend said documents, and we absolutely must follow the law from the document. There's no country with no law, like full stop. Whether you're a Democrat or a Republican, you must believe that. Every single oath taker in the United States takes an oath, not to the president, not to the military, not to BLM or not to Trump, but to the Constitution. Like it is the conversation would start there, I would imagine. Like, do you think that the Constitution is the highest ruling document in the land? Do you think that everything stems from it or flows from it? And, I mean, if you disagree
Also,
on that,
there's another argument here, which is Trump won in 2016. Trump won in 2016. Remember that. Was it anti-democratic for Trump to win in 2016? I mean, Trump lost the popular vote. That's
by like
anti-democratic.
3 million votes. Yeah.
He lost it.
Uh-huh.
But no one sits here and says like, "Oh, we can't enforce that part of the Constitution. We can't
Right.
enforce the Electoral College because
It's
obviously
an
it's
anti-majoritarian.
anti-democratic."
Yeah.
What is the
No
best
one would make that
argument?
argument.
Is there a link to the Colorado dissent? I kind of want to read it. Do you know any, like, what were the arguments he used?
Okay, these are the arguments for the Colorado dissent. If you just go to the Supreme Court opinion, they'll be there.
Can you
there's
link
three
me,
dissents.
Josiah, so I can read
Yeah,
it? And then,
yeah,
go
yeah.
ahead. Please go talk, yeah.
Or Josiah, do you mind linking it?
Yeah,
to
I'll
him?
take care of
Okay.
it. Keep talking.
So, two of the
Wait,
or-
sidebar, Stephen.
yeah.
You wanted the dissent from the Colorado justices?
Supreme Court, yeah.
Yeah. Is that
So
what
it
you
would
want?
be,
Yep, that's
yeah.
fine.
If you scroll down on the opinion,
Who
it
cares about
yeah.
lower courts here? Yeah, let's come on.
So we talked about before that we think Section 3 is self-executing in the sense that Congress did not need to actively put it into being. It is the thing itself. It's
Yep.
the thing, the law that from which it's created. But it doesn't necessarily mean that state courts are the ones to be able to hear it. And it doesn't mean that states are opening up their courts to hear these claims. Like you could imagine a state passes a law that says, under no circumstances will our courts enforce Section 3. Now, a lot of people might put like a little, or some people might put a little asterisk and say, well, states aren't allowed to do that or something. I don't know. And there are actually arguments that states can't limit enforcement of federal law in their courts.
Yeah.
But that is an argument that right now I'm not briefed on. But just for the point of this argument, just assume that states could completely get rid of the enforcement provisions of Section 3 in their own states. They could do that, right? And you even see in Minnesota and in Michigan, they have said explicitly, you cannot use our court systems to judge qualifications for primary elections. You can't. You could nominate a chair if you wanted to, and the Michigan courts are no place to hear claims that the chair is ineligible to be president of the United States and therefore can't be on the primary ballot. Come see us again during the general ballot. you can imagine a state that says our state apparatuses will not enforce Section 3 at all, right? So just because it's self-executing in that sense doesn't mean that states couldn't deprive or never give their state apparatuses the authority to enforce Section 3. So back to the dissents. The dissents, all of them think that under state law, this is not allowed. And that there is no provision of Colorado state law that allows the state courts to enforce Section 3. So it's for two of them, it's a pure matter of state law. That they're saying that basically this statute isn't meant to apply to Section 3. But they lost on that. And the Supreme Court won't even review that because the Supreme Court isn't going to be deciding cases like the highest court of Colorado is the court that decides the law of Colorado. So those people you can almost put into a separate category. You don't really need to focus on them. If you were to read their dissents, all you would read is things about, interpreting Colorado state law, which of course you're not that interested in, right? There's one dissent that says there's a procedural due process issue. That is, Trump was not given the power to subpoena certain witnesses, that, the trial lasted a week, which is not like an abnormally short amount of time for a trial. A week-long trial it could be significant. I just had a very complicated trial that lasted like 4 days. So it's not like unheard of to have a trial that's a week, but essentially said that the procedures given to Trump were not enough under the due process clause of the Constitution.
Which sounds
wholly
ridiculous because
It is ridiculous,
there are many ways to challenge ballot things or whatever. But the idea that you'd be guaranteed or afforded due process, doesn't this only have to do with certain things, or like doesn't this encompass things especially around like deprivation of rights? When you talk about like due process or being
that's the first thing. It shows you should go to law school because it shows your first inclination is correct. The first question is like, well, you have to have due process before deprivation of your rights, but like you don't have a right necessarily to run for office, or you don't have a right necessarily to do X amount of things, right? But like if you lived in a given area and the state government tried to increase your taxes, you wouldn't be entitled to like a hearing might actually be entitled to a hearing.
Sure.
So the first question is like, are you even entitled to any process for this?
Yeah.
And then that second question is like whether the process he got was enough if you are entitled to some process. On the first question, there's the difficulty of that states don't even have to have elections, right? How can you have some amount of due process that's required for these kinds of contests if the state could just get rid of elections altogether, right? The state could decide tomorrow, we're not having elections for president anymore in the state. Sorry, our doors are closed. Boom. No one would have any due process claim.
Or what is your due process right now if you're not like listed on a ballot? Right? Because like, don't you have to have a certain percentage of support in the state? Like, do I get due process if I'm not?
If you don't reach that?
Yeah, right. There is no they make that argument in the paper. There is no deprivation of life, liberty, or property. And there were esoteric arguments on like, well, is an office considered property? But I think even in English common law, it wasn't considered as such, and it wouldn't have been as such in the United States. There is no deprivation that's occurring here. Yeah.
You could think of the difference of like where if the government literally takes some of your property, like takes some of your money from your bank account, you probably want, or like seizes an asset you have to hold an attachment or something, that would be a situation where you would want some due process before they do that or after they do that close in time. But if the government just like stopped turning on some benefit it was giving you, let's say you were getting Social Security benefits and all of a sudden the government just turns off the faucet.
Yeah.
Are you entitled to all the procedural rights that are the same if they were to take away the property that you actually have?
Yeah.
So the due process clause is kind of more muddy. And for this situation, I think where states have ultimate authority to assign electors however they want, how much process can the Constitution require?
You're also, any, right? And then also, I don't think I would make this argument because obviously it's very dicey and it makes you sound like a fucking lunatic. But also, I don't know if due process technically even matters. Because technically, because they talk about theoretically conflicting language in amendments, it would be the latest amendment that's added to the Constitution that would supersede one's prior to that. So technically, due process comes to the Fifth Amendment, and technically you could say that
this is lunatic. Yeah.
Well, I mean, they make the argument in the paper, but they usually say because they argue for harmoniousness, right, between this and due process
that's
and
what
this.
I argue for,
of course, which is a better argument. But technically, where conflict arises, right, and they mention Hamilton in the Federalist Papers. Where conflict arises, you would do the last thing that passes in time. So if you but obviously that argument sounds a little unhinged, but I mean constitutionally
we don't even need to reach it. We don't even need to reach it because the process he got was perfectly
sure.
fine.
Yeah, I agree.
In Bush versus Gore, it's not like you had to decide. It's an election case. They have to decide it quickly. It's not like Gore had the opportunity to like depose everyone he'd want to depose. Again, I'm not saying that those issues revolve around that, but like imagine there were a dispute in that time frame. The courts would have to decide that question very, very quickly. And so in that context, there were plenty of like pretrial motioning. There was hearings and stuff. There was essentially a 2.5 month
cross-examination.
There was a whole trial.
Witnesses. Yeah.
And so if you're going to say that this was not procedurally correct, you have to tell us what would have been required. Are you telling me he has to have the right to what? Subpoena Ray Epps? This is essentially just a question of applying law. There's not even like contested facts really at the moment.
Yeah.
It's just a question of like, we all know what happened. We saw what happened. And in my opinion, the questions only revolve or mostly revolve around interpreting what actually did happen. The Supreme Court pulled the case records of what occurred in the lower courts in Colorado. So I hope that they're taking into account and giving some deference to the factual findings of the trial court as they should.
I think one of the dissenting judges also said when they were talking about due process that they actually couldn't explicitly identify what aspects of due process Trump was entitled to. As a matter of fact, I'm pretty sure it was either Boatwright or Samauer. I'm probably butchering his name. I think there was Samauer who dissented, who said, I'm not saying that Trump is entitled to, due process that we would give him in a criminal case, but he should have been given more than what was provided here. So, like, they can't even identify specific things that they would prefer to give him, just more than what he had.
And I think if that's I don't really think the Supreme Court's going to buy the due process argument. They might. I don't feel strongly about the due process argument as I do about the officer question. I do think the most likely thing that they're going to save Trump on is the incitement standard, because the argument
Nothing,
for
but
how
none
he
of that
engaged-
applies. Brandenburg doesn't apply. None of that is relevant here, because also it's not just inciting too. It's right or provides.
Colorado found that Brandenburg doesn't apply. You just identified one of the key differences between. Colorado
Brandenburg does apply
and
here.
That's what Colorado court said, but it's not.
How do they get around the? Maybe I should read their opinion. How do they get around the fact that it's not just incites? It's also provides aid or comfort to, because that's an or that's written.
They don't deal with give aid or comfort to because it wasn't raised by the petitioners. So
okay.
Analyze that. Yeah, I have to bounce, but much love to you guys, and I'm really impressed by you, Stephen. It's clear that you retain most of what you learned. And most of what you read.
So
yeah, but you're gonna be ready, and so much luck to you and hopefully.
Pisco, I'm sorry.
Yeah.
No, before you go,
I live in 30 seconds, but tell me.
Okay, well, the recent decision by the Supreme Court, the 5-4 decision about the border in Texas.
That should have been 9-0. It's crazy. It was.
I understand, but I'm curious. Could there be circumstances under which that might be an insurrection if Texas continues to defy the federal government?
I haven't heard.
Well, like they're still putting up razor wire. They're still putting up the razor wire and the buoys. Now, I guess it didn't.
It's a good question. I have to bounce, but it's a really good question because I do think that the government should be in charge. Federal government. Bye.
love you. Let me read real quick. Hold on, a couple of minutes.
Sure.
Yeah, big kids love that your ideology is an ivory tower and is ever evolving. Good ideas exist on their own merits and not the ideology we most associate with. True, big kid. That's why I played Zerg. Leaks Fredman, I think. $100. Thank you. Great job on the debate with Ben Shapiro. I'm glad we made it happen. It's in part a celebration of a long journey you've been on doing political discourse online. You should be proud, brother. Keep up the great work. Thank you. Lex. And $10, a fellow bro. You crazy, but thanks for saving me from the pool universe. Thanks, buddy. Jesus.
Yeah, I watched your Ben Shapiro thing, dude. It was a really good conversation. I think you guys have a pretty good chemistry for stuff like that. I'd love to see a round two.
Yeah,
he said shit that infuriated me, just FYI. But
I was happy that at very least I think that happened such a. I don't even know if most people care. I was happy though that he did say that. Oh, I do grade Trump on a curve. And I'm like, oh, okay.
That was the thing that infuriated me.
Oh yeah. Hey, at least he said it. I'm happy you said it. Okay, fine. So we're grading Trump differently than any other fucking president. Okay, well that's fine. At least we admit it. Okay, at least we're honest about that. Thank you, God.
Like, of course, would I grade my 7-year-old on the same curve that I would my like a teenager? Yeah. And then when you said, because you didn't look at him, but you need to go back and watch it because the reaction shot was priceless. You were like, so I'm thinking that maybe we don't do that because he's an adult, he's the president of the United States, and then Shapiro frowns in response, like you're fucking crazy for suggesting, and I'm just like, oh, my blood pressure was through the roof. But yeah, he admitted it. He fucking admitted it. And now he's publicly endorsed him, just FYI. I sent you that link. So that will be great fodder for your inevitable round two. So, Ben, I can't help but notice you officially endorsed that toddler malignant narcissist with authoritarian impulses that we talked about before. It's official.
I saw a random comment. I don't know if it was a YouTube comment or a Reddit comment or what, but I thought it was a really good comment. And it was the saying that the guardrails held and that Donald Trump,
they'll probably hold again. The guy said something like, it's kind of like saying somebody gave you $1,000 to shoot you as long as you wear a bulletproof vest and hopefully they don't hit your face. It was some conversation like that. Like, fuck, it was a really snappy way to summarize that. Yeah, maybe he tried to take over the country, but we'll give him one more try. He probably won't do it a second time.
100%. I mean, yeah, the idea that because the guardrails held before that they're, obliged to do so again is insane, especially when these institutions and the guardrails are comprised of people. Like at one point, I don't know, I'll give them the benefit of the doubt here. I am not particularly inclined to, but just based on the good nature of the conversation you all seem to have. At one point he said, okay, because you mentioned, the people he would appoint in a second term, which is a really good point to make. And he said, okay, well, how would he appoint that? Appealing to the idea that he couldn't get his cabinet secretaries confirmed. He doesn't have to. The president can, right now our labor secretary is an acting secretary. She's entitled to like 99% of the powers and privileges associated with the position. The president can just cram somebody in.
Oh yeah, because
they're just
acting.
Yeah.
You're just waiting for confirmation, but they still essentially operate with the full power of the office. Yeah.
100%. And as a matter of fact, like again, arguably the single most powerful position in the executive branch beside the president himself is the White House chief of staff, and that doesn't need any Senate confirmation whatsoever. Mm-hmm. You just appoint whoever you want. So yeah, that's so frustrating. And even at the beginning when he was like, does rhetoric matter? I'm shocked.
Bro,
yeah.
What?
I'm shocked he said that. Like, presidents can tank stock markets based on the shit that they say, or can have like a material effect on, worldwide markets or things like that based on the things that come out of their mouths. Mm-hmm. Why would we ever accept that? But I was hoping too, you'd get a way to say like, having run a media company, Ben, and given what Trump has said about critical media, would you ever tolerate, even if it was just words, if Joe Biden said tomorrow, like that fucking Daily Wire shit, I'm fed up with it. Maybe I'll have Merrick Garland, open up an investigation into Ben Shapiro. Mm-hmm. I don't know.
Yeah, it's just wild. Yeah, but man, they can't give an inch on the Biden-Trump stuff.
No, they can't. Were there any like real surprises in the conversation in terms of like points of consensus you were surprised you agreed on, or points of disagreement?
I don't think anything was that surprising. We didn't get that deep into anything though, but yeah. I did get to say that, like, I hope I said that it was annoying that we get to judge Trump on his 3 years before COVID.
You did.
Okay, thank God. Okay.
You did.
That's so annoying that people say that. Like, oh yeah, well, we can't take Trump's last year. That's not fair. Well, you guys sure as fuck do claim year 4 when you talk about immigration. Like, what the fuck? Like, yeah. Yeah, you guys are real happy. There was like 12 Mexicans trying to come to the United States at the height of COVID. It was like, Donald Trump owned at the border or Title 42. And it's like, okay, fuck you. Yeah. Bullshit. Yeah. But all of Biden, all of Obama had to be great. Mm-hmm. I hope we can have a fucking Democratic president that doesn't come after like a Republican fucking international catastrophe. Okay. Just one time. Please. One time.
That's the trend. 10 out of the past 11 recessions have happened under Republican administrations, which are usually followed by Democratic administrations.
It's insane, too. Yeah. Like, look at the whole Middle East. We're traumatized from fucking Bush. We had Bush at the end of the housing crisis, and then we had Trump at the end of fucking COVID, and then our Democratic presidents have to play these dog shit catch-up games for how long? But I guess, yeah, maybe if it's too easy for Democrats, they have to, like, kneecap themselves. Because Clinton's presidency, I'm pretty sure, is considered overwhelmingly, like, a good presidency, except he fucked around with Monica at the end, I guess.
No, I mean, by most, like, metrics of domestic policy, I mean, obviously, progressives hate Clinton now, but for his time, especially, he was radically successful, especially with respect to jobs. I think he still holds the record of, like, the modern economy and job performance, the number of jobs created on his watch. But did he move you at all? I'm curious about the Abraham Accords, because this is another one that I hear, constantly brought up in terms of Trump accomplishments. Like when you and I had the conversation before, that was one, that and the 2017 Tax and Jobs Act were the only two, well, in the First Step Act. So those are the three things that I could think of beyond they appeal to just general deregulation under Trump. But in terms of policy achievements.
No, what was even his argument for it? No, I just don't think they were that.
Well, he said it was a solid step towards normalizing, the relationship between Saudi Arabia and the UAE, and I think it was Bahrain or the other. And you pointed out,
these countries had all more or less like kind of already were getting along with each other for like decades. Huh.
Do you think? Well, I guess his point was basically effectively, okay, maybe there was like de facto normalization, but the fact that there was something on paper represented a necessary step towards a potential peace that Joe Biden killed somehow.
I guess,
Do you
but like,
buy that
here's
at all?
no Joe Biden. First of all, no Joe Biden. But the problem is like, show me something like big. Like, what are we doing about like Qatar? What are we doing about Iran or Hezbollah or the Houthis or Palestine, Israel? Like, these are the big things, right? Like, oh, we got an official agreement between Bahrain and Israel. It's like, oh yes, hooray! Like, okay, like the two most feuding, enemies in the entirety of the Middle East. Thank God, like no more Scud missiles from Saudi Arabia to Israel. Like, yeah, I don't know, it's just dumb, but
Yeah.
um,
He definitely.
I mean, it's not bad.
ducked
I
you.
will say, I'm sorry, let me qualify. It's
No,
not
go ahead.
bad. Like, the Abraham Accords are good. I think those bilateral peace things are good. But so it's not bad. But I'm just saying it wasn't like peace in the Middle
Peace
East.
in the Middle
everything,
East.
Like, nothing got solved.
Yeah,
nothing
yeah.
got furthered there, really. Yeah.
Yeah, I was pleased that you made a really strong showing initially when you were talking about. I think you were responding to him initially because he went first about which president was better. He answered first. You responded and like addressed some of his arguments. You brought up Afghanistan. I was proud of you there because I think you did it in such a way that he didn't fight you on Afghanistan. He made, I think, a cheap shot later on where we talked about the embarrassment that the Biden administration made. When they pulled out of Afghanistan, he just kind of mentioned that in passing as a way of like emboldening Putin. And
Sure. Did I get to bring up the Doha talks? I don't even remember. I feel like
repeatedly,
Okay, that's good,
repeatedly,
yeah.
in your your NyQuil-induced haze there. Yeah, you did. So, yeah, it's really good, man. Well, outside of this Greenwald debate, do you have any other big political shit besides that and the Ohio thing?
No,
you
nothing
can talk
coming
about?
up. I don't think so. No, nothing coming up. My brain is expanding. Read it now, but as I learn more and more about everything, I'm getting more irritated by the conversation. After reading this paper, re-listening to like Glenn Wald's videos, where I'm like, my brain is now, leaking all this interesting historical constitutional knowledge and everything. And I listen to Greenwald, I was like, well, all 7 Colorado justices are Democrats. And I'm like, this guy's a constitutional lawyer? Like, can I hear like a single shred of legal analysis like anywhere in the entirety of this 30-minute dog shit fucking video? Like, why can't he say anything? This is literally his educated background. I think he actually was a lawyer. He didn't just get his JD.
Yeah.
I think he even practiced for a little bit.
He was.
Like,
He was a practicing
Yeah,
attorney,
where the
yeah.
fuck is the actual legal analysis? This is your job. Yeah, I don't think he read the paper. Oh, no, I know he didn't read the paper. Or even parts of it, which is just annoying because all of his... The thing that I run into, I saw this with Vosh and that one PhD guy that he debated. It's really funny when people bring up objections that are addressed in the material.
material.
Yeah, like why would you if you're going to bring up the objection, then bring up the objection to the objection that's already given in the paper. Like, do that, because he brings up the very case that Gavin, what was it called? Griffin. Yeah, he brings up the very case that the paper dedicates like 5, 6, 7 pages to talking about. Like, why not address their arguments relating to the case? And despite how many times he says it, that was not a Supreme Court case. I don't know why he keeps saying that.
No, the guy was riding circuit.
Yeah.
Now, it's the closest thing, he would say it's the highest level of precedent we had, but I'm pretty sure, and I'm going to fuck the year up, but it was 2022, I think, a case out of New Mexico where a city commissioner or county commissioner in New Mexico, he was a participant in the January 6th insurrection. He was actually in the Capitol. I think they busted him for trespassing.
Yeah.
He was just kicked out of office by a judge, in part on 14th Amendment grounds. Now he would say that that's at a state level, with a county commissioner, it's certainly not something on the level of a president. And there was trespassing involved. Donald Trump didn't trespass, but it's also, the fact that some of the other thing I hear a lot, I guess, from Greenwald and Shapiro and others, and I think he actually, Shapiro mentioned it in your debate, was it's novel. It's novel. It's novel. Everything's fucking novel the first time the case comes around, right? We've never been in a situation where this has had to apply to a president post-Civil War, because John Tyler, as I told you in the DM, the one president we that was alive during the Civil War who joined the Confederacy, he died before the war concluded. So we were never in a position to have to apply this to anybody, and there's no guarantee he would have ran for office again either way. So, no, you did awesome, man. I was glad to finally see it. I know the rest of the community, we were so hyped. All of Reddit, I think right now, or all of your subreddit is all about this debate. So I'm sure you're going to be reading threads for days about it. But yeah, you should definitely check out the links, not just the Baud and Paulson paper. But now that you have more time, if you're interested, there is that hour-long discussion between Baud and a guy named McConnell.
Definitely want to watch
Yeah.
that. Yeah.
Yeah, and then you should also check out, I think the 14th Amendment appellate brief between the district court and the Supreme Court, I think that's important because it's basically the people bringing the case, making their case to the Supreme Court and rebutting all the shit that Trump's attorney said at the district court level. So it's like a refutation, right? So it's you get to see these arguments tested in the paper. But
Yeah.
I linked you to all that. Good luck.
I do
and,
wish that, like, I think it is very telling when you see the types of counter arguments that are being made to excuse Trump of all of his actions, and it's very frustrating how much defense, like the idea that like Trump is accused of doing all of these horrible things. What's your response? Well, I mean, can you actually ever really charge an ex-president with any like civil or criminal thing ever? Maybe not, right? Or like, well,
Right.
was he hold on here. Was he is the operator of an office like actually an officer? Like all of the counter arguments are so ridiculous on
It is.
legal grounds, and they completely cede all of the moral ground instantaneously. When somebody says you've been accused of raping 5,000 women and your first response is, oh, okay, well, you can't hold me criminally liable, so suck my dick. Like you conceded all of the moral ground immediately for the most facetious legal arguments, in my opinion, but who am I? The Supreme Court
Yeah.
will probably end up disagreeing, yeah.
Well, no, it's not only that, but it's also for me, again, the hypocrisy shit, like especially in my content. The thing that drives me nuts is again precisely what Shapiro said, grading Trump on a curve. Now, again, I make no bones about it. I'm unapologetically partisan, but I'm just imagining if Biden ever said something like, I'm above the law or I'm entitled to absolute legal immunity, even though he's a Democrat, that would freak me the fuck out.
Yeah,
and
of
I think
course.
that would be disqualifying. Like I do, because I don't think that the powers of the presidency are so fucking awesome. And I don't mean like cool, I mean as an awe-inspiring that we can't trust for someone to publicly vocalize that regardless of party affiliation, that's super gross and that you can't be trusted. And as a matter of fact, there's I'm not going to call the guy out like harshly because he's a nice guy in DMs and he posted an interesting thread on your subreddit, but he called you out and I out in one of them saying that you would have voted against the Constitution and that I was wrong that the founding fathers didn't fear.
Wait, would have voted against the Constitution? Wait, what the fuck is this article? Or subreddit?
I'll find you the link to it, but basically the thesis is that you probably would have been an anti-federalist at the time if he could transport you back to time to the ratification of the Constitution. That given your objections to Trump's arguments, you would have voted against the ratification of the Constitution, given the concerns you have about the chief executive and checks and balances. Right?
Wait, I'm so curious. What is the I want to read this thread.
Yeah, I will send you the link here in about 5 minutes, and maybe DGG you can find it for
Oh,
you.
thank you. Okay, somebody found it.
Yeah. I'll pull it up real quick and I'll watch it with you.
Originally, this was intended to rebut Pondering Politics' completely ahistorical claim that, at the time of the ratification, that the thing the framers cared above all else was having a chief executive with too much power. However, when you look at the debates between the Federalists, pro-ratification, anti-Federalists, anti-ratification about the powers of the president, including framers of the Constitution wanted a strong president. While I don't know this topic, realize that Destiny is actually an anti-Federalist. Most people turn from the revolution of the Constitution without ignoring articles, comparison of the articles. There was a weak and feckless central government. There was no executive branch. There was no judicial branch. There was only a legislative branch. Jeez, wait, how long is this? Oh, yeah, fuck it, okay. Constitution requires the states to secede their sovereignty to a new, strong central government, but abdicating such powers to a central federal government so soon after the Revolution brought back memories of the British just a short time ago to create a government of laws and not of men. They knew they must divide power among three separate branches, supreme in their own domain. The greatest power lied in the legislative branch. They thought that it was necessary to divide the greatest power among two differently elected bodies. Madison said, had every Athenian citizen been a Socrates, every Athenian assembled would still have been a mob. They knew the president would need to be able to fight back against an overzealous legislation, so the executive should be fortified with the power of the veto. The Constitution prescribed how they, collection, this is Patrick Henry, originally the leaders of the anti-federalist cause, said, at Virginia's ratification away with your president, we shall have a king. Because what could be worse than having a king who believes he has divine authority alone against power of the people? Hamilton in Federalist 69 attacks the argument by saying a president only retains power for as long as popular, but term limits. I'm looking at you. The president would be forced to respond to people's wishes. Additionally, the president of the United States would be liable to be impeached, tried to... Many of Destiny's criticisms against Trump are the precise reasons the anti-federalists oppose the Constitution, especially about the president. I remember him saying that he thought the size of the House should be increased, which is an anti-federalist sentiment. I feel pretty safe in saying he supports the Bill of Rights, which is an anti-federalist argument. I feel safe in saying he supports the criticism of the courts. I'm not sure about the criticism of taking power of the states, but not all... Destiny was also the anti-federalists and would have likely opposed ratifying the Constitution. I feel like that's a pretty wild jump because there are like parts of arguments that they've made up here that I might agree with. It seems kind of retarded, but
Yeah. So the thing that I was surprised he fought on the most is the idea that, again, that one of the things the founding fathers feared above all else was an overly strong chief executive. That is absolutely the case. That's part of the reason why they went with the Articles of Confederation in the first place, because their first instinct was to overly neuter, was to defang the executive. And even during the ratification, founding fathers like Benjamin Franklin, they wanted multiple chief executives. They wanted a council. They didn't want one person with that kind of power. And I don't know. So that's the other thing, too, that really grosses me out about a lot of Republicans and conservatives who say that they're anti-government or small government, want to invest when it's Trump or their guy so much goddamn power in that office where, again, they're a blank check. They can commit crimes with impunity. They have to be impeached first. And you know what? If they abuse the system to kill off the lawmakers to prevent an impeachment or a conviction, that's just the way that the system is designed. And you know what? Maybe they wanted it that way because that's basically how the King of Great Britain functioned at the time, where they were above the law. Maybe it's because that's all they knew. It's super gross. Yeah. So, but yeah. All right, buddy. Well, listen, you have a good rest of your night. Hope you get feeling better, and I'm sure I'll talk to you soon.
Well, everybody be careful.
Love you too. Bye.
Sorry. Okay. Jesus. So, okay. Let me catch you up on all this. I'm sorry. I first saying Pac-Man like 5 years ago, saying Shapiro was your final boss. Loved the debate and seeing your growth and drama through the years. Thanks, buddy. Okay. I think about a year ago, or maybe half a year ago, there were these two guys, Samuel Paulson and William. Or I'm sorry, I don't know why I keep calling him Sam. I don't know why I say this. It's William Baud and Michael Stokes Paulson. Okay, these two guys wrote a paper, and the paper is called "The Sweep and Force of Section 3." So what this paper talks about is we have a 14th Amendment. It was passed after the Civil War. And Section 3 of this 14th Amendment reads as such: no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. So basically, they make an argument that, one, this is an amendment to the Constitution. It is still in full force because it has never been redacted. There is no superseding law. There is no contrary interpretation that does away with Section 3. And that, as read, that Donald Trump, having been an officer of the United States for purposes of the presidency, who had taken an oath to support the Constitution, that he had engaged in insurrection or rebellion against said United States or Constitution, and that he therefore is automatically disqualified from being listed on any ballot. And it's a 130-page paper that I stayed up last night to read, and they just go through the entirety. It's broken out into four. It's broken out into basically into four large sections, where they make the argument about the different parts of this. Basically, the first section is a simple one: is it legally operative today? And the answer is yes, obviously. The second part has to do with the fact that the section is self-executing. So self-executing means that once this amendment was ratified by the Congress and by the states, this is law. It is law. It doesn't say that Congress must enact legislation, that through legislation or whatever. None of that is a requirement for any part of an amendment to become law. It hasn't been in the past. It wasn't in the future. But that it is law. The third part was that Section 3 doesn't contrast with any part or contradict any part of the Constitution. Okay. The third part of the paper has to do with the idea that Section 3 supersedes, qualifies, or satisfies prior constitutional provisions, meaning that there's no part of this that is contradictory to the Constitution. And even if it was, it would supersede it because it's an amendment to the Constitution. But they argue that it's not. That's why they argue they call it harmoniousness between Section 3 of the 14th Amendment and the First Amendment or any other part of the Constitution. And then the fourth part is that the substantive disqualification of Section 3, meaning on the substance of having engaged in insurrection or rebellion, that this is very broad, very sweeping. It includes those who have engaged in insurrection or rebellion or given aid or comfort to the enemies thereof. And they go through tons of historical examples, or maybe not tons, but they go through plenty of historical examples where other people have been disqualified from holding office as a result of language that's essentially identical to this prior to the amending of the Constitution with the 14th Amendment. But because of this paper, I'm pretty sure it's because of this paper, that's why Donald Trump was removed from the ballots in Colorado and wherever else is being fought about now. But I think the courts are essentially citing to this paper and this constitutional argument for why Donald Trump shouldn't be allowed to run for president. But this is the actual paper that made that argument. Only 126 pages. I think the last three are blank too. So there you go. No, they're not. Never mind. But yeah, this is the paper that set out to make that argument, basically. Link it. There you go. I already linked it, but it's also, I think it's paywalled here. So, is it a good argument? If so, why do you think the Supreme Court would reject it? I personally think it's a good argument, but also I'm not a constitutional scholar or a historian, so or lawyer. Who's to say? I don't know on what grounds the Supreme Court would reject this. I don't know. The two writers for this are conservative lawyers, and they argue for a textualist reading of the Constitution, and that on a textualist reading, it's pretty obvious, it's very clear. Everything about this is I don't think they make any difficult arguments in this paper. They all seem pretty straightforward and pretty well supported by the history. So yeah. So how does the Colorado minority opinion weigh against? I don't know. I haven't read it yet. I guess I have time to now, but the Supreme Court will probably say Trump doesn't meet the Brandenburg standard. Yeah, but I don't think the Brandenburg standard applies here, and I think they make that argument very convincingly in the paper.
because I think that the Brandenburg Standard has to do with I need to do crim law. We need to go to law school, boys. The Brandenburg Standard was a test to see if speech was inciting to riot for purposes of a criminal charge that would involve a deprivation of rights. I think that's all criminal matters involve deprivations of rights, right? So there's a due process question there. And I believe that Brandenburg v. Ohio is a test to make sure that essentially, right, that due process is met. However, I don't believe there is a due process question here because nobody is being deprived of rights. You do not have a right as a prior oath taker to hold an office again. There is no deprivation of rights because you're not allowed to be listed on a ballot. So now, supposedly, I think Pisco just said that the petitioners didn't bring up that argument. So apparently the Colorado Supreme Court does deal with the Brandenburg test, but I don't understand why that would even be invoked for the legal argument here. But maybe if that's what the petitioners brought up, or if that's what was being discussed here, maybe that's unfortunately what ends up in the Supreme Court. That would be pretty unfortunate, though, I think. But if I recall, Brandenburg is not a due process test. It is test whether speech is incitement or not. Yeah, but the reason why we need like a strict test is to make sure that like isn't it ultimately make sure like your due process isn't being violated because of a criminal conviction because of your speech considered incitement or blah, blah, blah. Like that's why the Brandenburg test exists, because we're creating a test for like a criminal charge or something, no? You can make the argument that liberty rights are being restricted. No, you can't. I disagree. It's a test for First Amendment protected speech. I don't think that matters. Section 3, the 14th Amendment came after the First Amendment. A later amendment could theoretically violate the First Amendment. Saying that something is a First Amendment right doesn't protect you from later amendments in the Constitution. I think as Hamilton said, when the law conflicts, you strive for harmoniousness, and you'd hope that later additions to the law would be harmonious with prior instantiations of the law. But where they conflict, one must favor the recent addition to or revision of the law. That's how it goes. It's sequential. It's in time. To be fair, and hopefully the court could reject the Brandenburg argument and find that he engaged in insurrection on other grounds. The problem is, describing this as, the problem is that it's not, the debate isn't really about the insurrection part. The debate is whether, it's probably not the job of the, I wish Pisco was here. It's probably not the job of the Supreme Court to find that he engaged in insurrection, because that's not, I don't believe that should be the question brought before the court. The question is whether or not Section 3, the disqualification of the presidency, exists, which it seems to. And if it does, then the determining factor of whether or not somebody had engaged in insurrection is whoever's adding Trump to the ballot. That might be a state election official. It might be a state legislature, but it's their job to figure it out. How they determine that is up to the states. It's up to the states to figure out how they add somebody or don't add somebody to the ballot. It's not the job of a court for a criminal conviction. It's not the job of the Supreme Court to make a determining factor or a determining decision on any of these things. Like, yeah.
Hey, I'm back real quick. I finished my call.
Oh, hi. What's up?
Hey, I heard you needed me.
Oh, I'm just so curious for... I haven't got to read this yet. Well, I don't understand why Brandenburg is brought up at all. Can you tell me?
Yeah. So...
Oh, and then also, before, are you familiar with their dismissal of the Brandenburg arguments in the paper?
Yeah.
Uh-huh.
So, the Brandenburg argument is relevant because... the way Trump did not like take up arms, right?
Okay.
Trump did not like a lot of what he's accused of having done in order to qualify for engaging in insurrection is speech related, right? It involves not.
Yeah, but it doesn't matter though. It's not First Amendment related.
We're not asking if he broke a law
Sure.
because I
Well-
think that some of the arguments that they give in the paper was there are plenty of times where you could be fully within your First Amendment right, but you are still you're still providing comfort or aid to people that are engaged in insurrection or rebellion. So you could be fully within your First Amendment right and still violate Section 3 of the 14th Amendment. So Brandenburg doesn't apply in any size, shape, or form.
Right. So anytime there's speech involved at all, even if it's like you say, like for fraud or conspiracy, that kind of thing, you could see some kind of colorable First Amendment argument. I'm not saying it's going to be a successful one.
Sure.
I'm
hold
not
on.
saying
I'm
it
sorry,
should apply
I'm only
Brandenburg.
fighting other
Yeah.
side because I've read this paper. Okay. I disagree with what you said there because you're saying, well, we're talking criminal, blah, blah, blah. That's fine. That's criminal stuff. But we're talking about an amendment to the Constitution. We're talking about something very different here, right? If we were talking about criminal law, then I think First Amendment is very important. But we're referring
It's
right
not just
now
criminal.
to okay.
It's not just criminal. So imagine this. Imagine that the government tried to fine you for incitement, but their incitement standard was, well, if you ever say anything naughty, that's incitement.
Yeah.
Like you couldn't do that. It's
You
not
could,
just
absolutely.
criminal, right?
I think you could, though, right? If what you just said was a provision found in the 50th Amendment, if they amended the Constitution, added to it, then you say, oh, well, fuck me, because that would supersede
Very
the First
different,
Amendment, right?
very different, right? So one is the superseding argument. I mean, imagine just for a second, put aside the Section 3 just for a moment.
Yeah.
The reason why we have to ask the First Amendment question, even when it just comes to regular incitement, regardless of whether it's criminal or civil, right? It doesn't really matter. It doesn't turn on that, because if the government is imposing a penalty to you based on some conduct, whether that's I don't know, whether it's a fine of $1 million or whether they're putting you in prison, there's going to be some burden, some First Amendment thing that's going on there. So, yes, I agree with you that absent the Section 3 wins out between any conflict argument. Sorry, you said that Section 3 wins out, and that's what Bott and Paulson say, if there is a conflict.
I just don't
But there's
understand
not
why
necessarily a conflict.
Yeah, I just don't know where the legal standard of Brandenburg, I don't know how we ever bring it up. Because it's just, that seems to deal very specifically with, and maybe I need to read it. The facts of the case are more detailed, like the majority opinion, but it seems like that Brandenburg test is explicitly done so that we've created a good standard by which to criminally charge somebody with incitement to riot.
Not just criminal charge. It could be any. Now, typically, this is applied criminally. Brandenburg is applied criminally because incitement is typically a crime. But you could imagine it extending beyond the criminal situations. Do you recall Bott and Paulson having it hinge on the criminality aspect of it?
I think so, yeah.
Okay. Well, I don't recall that, but regardless,
because it doesn't matter. So here, okay, hold on, I'm scrolling under this. Okay. These ambiguities have given rise to a debate about whether Trump's speech did or did not cross the strict incitement threshold of Brandenburg v. Ohio. It could well be that it did cross the line. Trump had deliberately assembled the mob of supporters, steeled them to action, knew that they were ready to take immediate action, and directed them to take it. But the most important thing is that the Brandenburg question is beside the point. Section 3 of the 14th Amendment does not enact the legal standard of Brandenburg v. Ohio. It enacts the standard of having engaged in insurrection or given aid or comfort to those doing so, and qualifies, modifies, or simply satisfies the First Amendment to the extent of any conflict between these constitutional principles. First Amendment or not, the speech was part of Trump's participation in and support for the insurrection.
It's two arguments. Okay. So one is this could likely fulfill Brandenburg, which is what the Colorado court found, that it fulfilled it. But that even if it did fulfill it doesn't need to fulfill Brandenburg because engagement in insurrection is enough. Right?
Also, because the fulfilled Brandenburg also seems to shift around that. It feels like if you can tell me you agree with this one. If we say you need to fulfill Brandenburg, it feels like now we've almost unplugged the self-executing part, and now we almost need some kind of judicial review basically on the question. No?
Don't need necessarily judicial review. Courts are not the only actors, and Bott and Paulson make this very clear. Courts are not the only ones to enforce this. There are people who, I don't think Bott and Paulson necessarily, but there are people who think that Congress, now this is a little bit sketchy because obviously you and I have argued strenuously that the vice president does not have a role to count or decertify elections, right? But Congress does have a role in certifying the election for president. And so some scholars have argued that Congress can interpret this to the extent that they're applying it to presidents, right? To the extent that Congress is applying it to other Congress people, they of course would have to interpret whatever standard that is. Whether that's Brandenburg doesn't necessarily have to be a judicially crafted or enforced standard, right? And you could conceive of a lot of different government actors applying Brandenburg or the First Amendment principles, even though they're not.
I'm just
judges.
curious. Has Brandenburg does that standard ever applied outside of a courtroom?
Like, would an officer ever
Yeah.
say, like, well, we saw him screaming at this crowd, and we were like, we think that this violates the Brandenburg v. Ohio standard, so we arrested him?
Yes.
You think so?
So
Okay.
in Congress, in the second impeachment,
Oh, come on.
there
Impeachment's
was-
cheating because you're basically like a mock trial at that point, right?
Well, I'm just telling you, don't read into the standard is
Mm-hmm.
not necessarily coextensive with the body that's applying it. So don't confuse, because then you're going to get a bunch of arguments of should courts enforce this, should it be others. They're different things. One is what is the rule to be applied. The other is what is the actor to apply the rule. So whether the rule is engage in insurrection, Brandenburg, or something else, that doesn't resolve the question of who decides it. I think you and I are both in agreement that courts, at a minimum, are presumed able to enforce this. And there could be some other actors, but we're not going to sit here and like speculate on who those other people could be. To give you an example, in Maine, the first step was just the secretary. Remember, I told you back, I don't know how many months ago, I was like, the Secretary of State could just decide that someone's not qualified, right? Remember I said that?
Sure, yeah.
And that's what happened in Maine, and that's going to be reviewed by a court. So most of these processes, other than like impeachment or Congress like not certifying things, would or allow for some judicial review of some kind.
Sure.
But that's a
Do you
different
agree-
question than
Yeah,
the standard.
sure. Okay, sure. I can kind of get that. Do you agree that the language of Section 3 on the like given aid or comfort or the
Yeah.
having engaged in, that these are broader terms than
Yes.
just like direct incitement?
Yes, yes, they are. I think they are. So the question will become:
Well,
one,
wouldn't that
does
be like
Brandenburg apply?
another thing that supersedes then? Because like we could say that, oh, when we applied Brandenburg, you did not pass the threshold for Brandenburg, but that's not relevant. You still clearly engaged in, or you still clearly gave aid or comfort.
That would be a
right?
problem for the Colorado court decision because they didn't come to that finding.
Okay, yeah.
So the
Because
Supreme Court would
because
say
the thing that would make me the most upset, as somebody that didn't know fuck all about this for 24 hours ago, but it feels like something that would be really shitty is like, could you imagine if the Supreme Court, like this makes it all the way to the Supreme Court, they deliberate, and then we get, our, 6-3 decision, and they said, well, actually, Trump just, his speech didn't meet the Brandenburg v. Ohio standard. So now it's all done. Like, wouldn't
That,
that
I
be the
think, is
shittiest outcome of everything?
I think that's the most likely outcome.
Okay.
But just to be clear, Brandenburg versus Ohio, let's talk about this. This is a case from the 60s, right?
Sure.
The framers of the Constitution did not have Brandenburg versus Ohio in mind
Mm-hmm.
when they made their statute or when they made their amendment because, of course, Brandenburg versus Ohio did not exist at the time. It was 100 years to go.
Mm-hmm.
But the whole idea of Brandenburg versus Ohio is that it is incorporated in the rule of the First Amendment. So even if everyone else had gotten it wrong, but people who would like support Brandenburg versus Ohio is like, was always the rule. And maybe some people got it wrong, but this is the rule, right?
Sure.
And the argument would be, well, we should read Section 3, since it does not explicitly carve out things about the First Amendment, we should read it in harmony. And so whatever
course.
rule we're going to apply for incitement-related engagement, it should be in concert with the current rule on incitement for the First Amendment, which is Brandenburg.
Well,
Now,
hold on. When you
I think there are
okay,
decent
wait,
arguments.
just real curious.
Yeah.
So when we say that it has to be harmonious with the First Amendment,
Doesn't have to be, yeah.
or like we would hope that it would be. That would be like our preferential reading, right?
Mm-hmm.
We're hoping that we don't like, oh, the 11th Amendment like says that Congress can make laws abridging your freedom of speech. Like, okay, well, fuck, this is confusing, right? So ideally, we would like to read it harmoniously and in plain language in a way that makes sense without secret coded language or anything else that they mention, right? Doesn't the First Amendment mainly have to do with like creating laws that are abridging or making like restrictions that are abridging like these types of freedoms? Like, does that necessarily apply here if there's not a deprivation of rights?
Yes, it would. Yes,
It
it
would?
would. It could. I'm not
could.
saying necessarily would because
Okay.
okay. So this is why it could.
Okay.
So the First Amendment carves out. It just all it says is Congress may make no law abridging the freedom of speech.
Mm-hmm.
It doesn't define like where this ends and where this goes, right? So there are some free speech absolutes that are like, yeah, you can't even ban child pornography.
Sure.
But obviously, when the framers were writing down the freedom of speech and putting that provision in the First Amendment, they were trying to translate the English version of the freedom of speech.
Okay.
And that included some categories of unprotected speech. So category number 1 of unprotected speech, defamation, right? Category number 2 of unprotected speech, fraud. Category number 3 of unprotected speech, incitement. So these are categories, boxes, you can think of them, around the circle that is free speech, where they're unprotected, right? There's no incitement that is protected speech at all.
Yeah, or conspiracy. There's a whole wide range of these that wouldn't be
Right.
protected speech or
So
whatever.
part of First Amendment doctrine is, and this is a simplified version, but just for your purposes, is putting things in boxes. Okay, this is incitement, and so there's no protection. You're allowed to punish them over this. Or this is child pornography, and so it's a categorical rule against that there's a First Amendment violation there. And so you put things into little boxes. And if you are in a category of unprotected speech, it's very likely that the government is going to win. If you are in a category of potentially protected speech, then you have to do a little more tricky analysis about, well, is this a time, place, manner restriction? Was this done for the purpose of giving a viewpoint-based discrimination or whatever, right? So that's the kind of a brief overview of the First Amendment. I know, very, very, very brief of the First Amendment jurisprudence. And what here, like something that would be unthinkable under current First Amendment jurisprudence is that, say, Stephen Banel comes on a stream and says, I support people engaging in violent revolution against the United States. I support that. If you were to come on the street and say, I think it's good for people to burn down police stations, I think that's okay, right? So, suppose you said that one day, right?
Sure.
That would not be, under current First Amendment jurisprudence, a crime. And in fact, that speech would be protected because it's not
however,
incitement, right?
If there was an ongoing, the thing that I think makes this Section 3 a bit more complicated is that, let's say, so we agree that if I go outside and I say, I think it is okay to burn down a police station, that would be protected speech, right?
Yes.
But if there was an ongoing rebellion or insurrection and, I was out, like shouting from the streets, I think it is okay to burn down. Couldn't arguably you say, well, now you actually have crossed that threshold for as far as Section 3 is concerned?
That's the key part. You could say as far as Section 3 is concerned.
But I think that was one of the big arguments. So are you familiar with the Ironclad Oath?
Yeah. So basically that Congress required them to newly elected congresspeople, correct? To swear an oath.
I think all officers. And not that, but it was retroactive in that, like, you couldn't have been, I don't remember the exact languages, but no, actually, I'm sorry. I should know the exact language because the exact language mirrors a lot of what was closely brought into Section 3 because I believe they used that aid or comfort standard to the Confederate states for part of that Ironclad Oath. But I thought it was interesting because they gave examples of that Ironclad Oath being applied to discredit some people. You said something about Thomas. Do you remember there was a case brought up of a Maryland Senator like Philip Thomas, and he was going to I think it was to be a senator. I think they disqualified him because I think as his son was leaving to go join the Confederates, he gave him like $100 and he let his son
permitted,
yeah. And
I'm reading it right now, yeah.
Yeah, and I think they agreed on that did count as aid or comfort, and so they excluded him from the office. But that, in my opinion, and I think in your opinion, clearly that doesn't exceed any Brandenburg standard if it would have been existing at the time, right? But they were using that as a disqualifier thing because they said that gave aid or comfort to an ongoing.
That would be
right?
So here's another distinction there that I would say that one can make. That doesn't fit into the category of incitement at all. It would fit into the category of like giving aid to, right?
Exactly,
like you're giving someone money. So like suppose that you were just bankrolled the Confederacy.
Yep.
Well, there, right? Like there you're engaged in it because you're sending money. Like you're sending things that clearly shows your support. And it's not, even though money is like connected to speech there, we give government more allowance to regulate financial transactions. So the First Amendment, and we would more think of that as conduct than as speech, even though it's a fuzzy line, and the line between conduct and speech isn't 100% clear. But like if I were to pay like illegal monies to you for you to do crimes, I could be like, that's my speech, but people would be like, no, that's silly, that's conduct, and it's not. Whereas if I did roughly the same thing for you to engage in like political campaigning, right? Think of Citizens United, we would say that is speech, right? So there's some weird lines being drawn here. But I would think that you would want this act or what the Philip Thomas guy, you would analyze him under the engagement standard, and one argument would be like, First Amendment doesn't apply here because it wasn't speech, it was conduct. It was conduct that shows his intent. That could be, and so obviously Brandenburg doesn't apply there because speech is not relevant there. Here it's just a clear, you're giving money to a Confederate. That is engagement. You are materially supporting the Confederacy by doing that. And so the First Amendment, of course, is not implicated because it's not speech. Now,
but
listen,
wasn't
I'm
there,
not disagreeing with you on the.
I agree with what you're saying there too. But there was a I think I wrote this down. There was a guy who had made it was a newspaper article and he had written something
These
about.
are the harder cases. Yep, I know.
Yeah,
Yep.
they were harder. Yeah, but I think in there because that was speech, right? That was just speech because it was just a.
That's
thing.
yes.
Uh-huh.
Yeah.
And I
So
think
this
they
is the
ex-
hard case.
Yeah.
If you go on TV and in the middle of the Civil War, imagine there was a TV.
Yeah.
And you say, I support the Southern states. I think that everyone should be joining the Confederacy and fighting against the Union. Now, under current modern jurisprudence, First Amendment, that would be protected because it's not. I would think it would probably be protected.
Sure. Wait, also,
and
can
I
I
think you would
just
agree.
ask you a question? Because you keep saying it would be protected because we're going for harmony here, right? First Amendment and 14th Amendment, Section 3 also.
Ignoring Section 3 for a second.
Okay,
right?
sure.
Are you Coxon?
My OBS does something. I don't know why for you, Jim. But yeah, but like it could, yeah. Okay, so you're saying ignore the fact that it could be protected
Yeah,
First
so
Amendment speech
just going
okay.
on First Amendment jurisprudence, right? First Amendment. So I'm trying to create the conflict. So
Sure.
the example you gave with Thomas didn't create a conflict because you could get around it by saying this is not speech.
I don't.
it's
I actually. I'm not
conduct, right?
100% sure on that. I'm not trying to just argue, but like,
Yeah.
haven't there been weird laws that have come up? They bring this up because Abraham Lincoln. What was the quote they had in the paper of him where he's like, "I think by the time the Civil War is over, people aren't going to charge me with having arrested too many, but too few, or something."
Yeah.
And then I think later on, was it World War II? We've had times with like McCarthyism and stuff, where we have criminalized some forms of what we would say maybe should be free speech, but does it count as like aiding an enemy? I think these have been legal questions in the past, right? I
Yes,
don't know
100. No, you are 100% correct. One very clear example is like things like the Espionage Act and application of other provisions of the Constitution, or sorry, of federal criminal code as to like there were people who were advocating against the draft, right? People who are advocating that you should not get involved in World War I. There are people who are advocating that you should not, that you should be a communist, and these kind of laws were applied to them.
Yeah.
And so
and even
there-
kind of related to the draft, I think for one of the Civil War examples that they brought up was whether or not you could have charged somebody with discouraging people from joining the Confederate
right,
Army.
the
I think.
Union.
Yeah, or the Union Army. It was discouraging somebody from joining the Union Army. Yeah.
It feels very much like the people in the Schneck case and the other related cases where they were discouraging people from joining the army in World War I, and that was upheld. But realize, Schneck has been overruled by Brandenburg, and nowadays we don't think of just general encouragement, right? General encouragement, like, hey, don't do this. Hey, general violence, or generally advocating the revolution of the United States, right? You can peacefully advocate for the violent overthrow of the United States government, and that under modern First Amendment jurisprudence is protected. I'm not saying that there isn't inconsistencies in the past or that Section 3 might supersede it. I'm just trying to establish what the current First Amendment doctrine is.
Sure.
I'm trying to create a conflict, right?
Okay.
So that's why I said the Thomas situation did not create a conflict, because you could say that the Thomas act of giving money was engagement not through speech but through conduct.
Sure, okay.
Now you just gave a really good example of something that no one can argue doesn't implicate speech. That is, someone going to the newspaper and either telling you not to join the Union or telling you to join the Confederacy.
Yeah.
I would tell you, and I would argue, that under the First Amendment, that stuff is protected. Under current First Amendment jurisprudence, right?
Yeah, I agree.
That and you probably agree with the following too. Like, if you, as January 6th was happening, if you went on a stream with Nick Fuentes to like review it, and Nick Fuentes says, I agree with them and they should do it, what would you think about that? You think that's engagement in insurrection?
Are we asking for a criminal test or for purposes of Section 3?
Okay, let's first take the criminal.
Sure. Criminally, I don't know if we even use those crimes.
Good. Yeah, do it. Or if someone's on stream and they're attacking the police precinct in Black Lives Matter, and so like, good, yeah, I'm glad it's burning down. They should attack more police precincts.
I don't think anything is illegal about that, right?
Okay.
Yeah.
For Section 3 purposes, do you think the same conduct could disqualify you? Forever, if you're a previous oath taker?
I think so, yes.
Okay. That's the unsettling.
Is it
component to
unsettling,
it.
though?
Yeah, I think it's unsettling. Not that it's wrong.
I feel like we've switched
It's
places on
unsettling.
this. I feel like it's not unsettling. I feel like the scope is so narrow that we have to, first of all, this only applies if we're talking about an insurrection or rebellion. So any of these, a prior oath taker, we agree, for instance, a prior oath taker could be watching a house burning down, and he could be on TV going, "Oh, I support this. Fuck yeah." He could be a prior oath taker. He could run for office again. Section 3 would have absolutely no relevance here, right? And the First Amendment would protect him. We agree with that, right?
If he saw the burning
Burning
on
a house
TV,
down, or burning a, not like the House of Congress, but like burning a thing down, or it might even be like somebody breaking into Congress to go and steal a monument. Somebody wants to break in and steal, I don't know, a podium
Yeah.
or some shit. Yeah, that a prior oath taker could be looking at that on TV. He could be cheering to his fans. Yes, like steal that podium from Congress. Yes, fuck
Privately,
yes,
you
right?
mean?
Yeah, sure. Yeah. Wait, what do you mean privately?
You're saying publicly he would say that? On a,
Or I'm
on a
sorry, he'd be
screen,
saying like I support this. I think it's fine, or
Yeah.
whatever bullshit like that.
Yeah.
That would be protected First Amendment speech, and it wouldn't even fall under the Section 3 disqualifying thing because there is no insurrection
why?
or rebellion.
So you would get out of it through insurrection or rebellion.
Yes, that
Okay.
has to be because that's a.
But that's a broad
necessary-
definition too, right? Look, so
It
we're-
is
so if
broad.
someone-
Yes, it is broad.
Yeah.
I agree. Well, it's broad in action, but I think it's relatively narrow in intent.
In intent?
Yes,
Okay.
and that the actions of what one, and that's all the examples they go through, right? The giving the $100, the article in the newspaper, telling people not to. The actions are very broad, but the specific intention of trying to circumvent or rebel against or fight against the federal government of the United States carrying on its like lawful business or in opposition to government
That's more
business or
narrow.
action. Yeah, I think that definition, that intention is narrow enough such that I'm okay with the broad set of actions, also considering the narrow subset of people that it involves being
Mm-hmm.
prior oath takers who might take a future oath, although they could theoretically be kicked out of office currently with Section 3.
But they couldn't be brought to jail. is what you're saying.
Correct. Yeah, that would be an entirely different test, I think. Do you disagree with any
So
part of that?
mere
or-
I don't know how I feel about
Okay,
it, and
sure.
I'm going to tell you why in a second by going on a complete zag.
Go ahead.
First, I'm going to zig with you. Here's the zig. What you're saying is, it's mere advocacy, mere public advocacy is enough to engage in insurrection.
It seems to have been the
mere
case
showing
based
of
on
public support.
the historical things that happened after the Civil War relating to the ironclad oath. It seems to be that totally protected First Amendment speech could still disbar you from office. Yes, so mere advocacy
Okay.
could be a way to aid or give comfort to like a rebellion or an insurrection. Correct.
Insurrectionists.
Yes.
So if President Obama went or Vice President Biden had said something like, let's say that the BLM were attacking a courthouse and he were encouraging it and justifying it on a streamer or whatever, right? You think that, maybe he can have a trial about it, or maybe courts would have a process, but that based on that conduct alone, you think he might be disqualified under Section 3.
Kind of, yeah. I mean, I would be anal and careful here, and I would say no trial is required. But I mean, realistically, it would probably reach like a challenge.
Right.
But yes, that if there was a plan,
Okay.
or not a plan, but if there was something that we felt matched what an insurrectionist or rebellionist
And you
behavior,
give
and
public
Obama was
support-
on TV saying, listen, they feel like their voices have gone unheard, and this is a fight that they feel they must partake in, and blah 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 blah. Even if it's fully protected First Amendment speech, and we would never charge him with anything. We're not even asking questions about Brandenburg. That we could still argue that, like, well, Section 3, I mean, that was giving
see.
comfort or aid to people that were engaged in insurrection or rebellion against the
Let
federal
me add an
government.
important
Yeah.
caveat to you,
Go ahead,
and
yeah.
I think you're going to want this too.
Okay.
It has to. The intent for the person in doing the advocacy has to be there too, right? So, like, if this happened and then ended, and then he said that was actually good, I wish they had done more, you would say not disqualified because the insurrection's over, and so when he's giving his advocacy now, you can't link what's over to his speech now, right? Just like if he were to say it privately, he's like, listen, don't tell anyone, but I actually agree with this, and I think they should do it more. You don't think that would be engaged in insurrection because there's no intent to further or to help at all.
Yeah, correct.
Right?
But then also, you know this.
So
and an intelligent
retroactively,
person
you're- yeah.
would, the intent part though has to be very, 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 very carefully handled, because the intent part just needs to be giving aid or comfort to what is factually a rebellion or insurrection, but there is no intent saving you from the rebellion or insurrection. So, for instance,
Right.
if you truly
Yes.
felt as though the election was stolen, and you
It's
don't have the
justified. It
intention
doesn't matter,
to
yeah.
circumvent you, that intent doesn't matter at all. The only question is the fact of the matter of is it an insurrection or rebellion, and do you have an
And did
intention
you
to aid
intend
or help
on that
Yeah,
stuff?
correct.
Yeah. No, 100%. But like, I'll give you another example. So Congress, very close after the disqualification in like the 1870s, pardoned everyone, right? Trump could have pardoned everyone, in after January 6th. But after the fact, that pardoning, those justifications, those like downplaying or even the promoting of the Jan 6 as people as heroes, that would not be advocacy that would qualify you for disqualification because the insurrection's over. And so you're not engaging in it and you didn't have an intent to engage in it, right? You're just after the fact, after the insurrection, giving some benefit or giving some cover to insurrectionists, but it's not done contemporaneously with the intent to engage in it. Is that what I'm hearing?
Yeah, I don't think that you
Okay.
could. Well, yeah. Although,
Because otherwise you could be like, well, Kamala Harris bail fund, right?
well, wait, hold on. What are you asking are you asking if you can
trying to limit the
retroactively
scope.
support
Yeah.
something?
So when you say like mere advocacy could be enough, it would have to be advocacy uttered with the intent to further the insurrection. It can't be advocacy that is done after the insurrection is already over, right?
Correct.
It
No,
can't
yeah,
be
that is
advocacy
correct. That is
privately,
correct, yes.
right?
Uh-huh.
Okay.
Yeah.
Yeah.
I will be.
That's why-
I
'cause
would
otherwise-
say careful because sometimes I hear you say, "I'm sorry, I'm being such a fucking," and you maybe,
Yeah.
but you sometimes you say like insurrection and or whatever. That's an or, and I think it's a really big deal,
Yes,
right?
yes,
because
yeah.
it's engaged in insurrection or rebellion, or
Yes.
given aid or comfort to the enemies thereof. You
Correct,
don't have to have
correct.
engaged. Yeah, correct. But I think for the other purposes, I think I agree with you. Yeah, saying something like, you know what, actually, I support. I think the Confederates were good. I don't know if we would say that that is giving aid or comfort to the enemies thereof because you
in
support a prior.
1890, but back in 1862, the same statements
Yes.
made publicly in support could be.
Correct. Yeah, I think so. Yes.
Okay.
Yeah, yeah.
All right. That's an important limitation. Now
Yeah.
let's talk about me and where I'm at. So, Cenk Uygur's running for president. You know that, right?
Yeah.
And I've been on Twitter, like, kind of, you know, targeting him a little bit with my tweets and being like, "You're not
But
qualified.
you know what, dude?
This is an embarrassment."
This is a movie moment, okay? It's a movie moment, and it would just never happen, okay? But it would be so fucking funny if somehow
He won.
No. If somehow, whether or not Cenk was allowed to be listed on a ballot, like made it up through to the Supreme Courts and that somehow
yeah.
like influenced the can Trump be on the ballot through some fucking crazy, wacky, roundabout way. It's like,
Wow.
well, you know,
Heartbreak.
was he actually like, because you know what? Because as much as, you know, maybe you even thought, I kind of thought, as much as we kind of laugh at it, like, I think a lot of people say like, well, you know, it's funny because I gave you all these arguments 2 weeks ago when I argued against it. I was like, well, who actually makes this determination? Like, is there a court? Is there, you know,
Yeah.
well, who makes the determination for Cenk? Because everybody seems to think it's self-evident that he shouldn't be listed. Really, by whose authority? Where's his due process? Where's the court case to determine that? And it would just it would be funny to see the contrast between those two things. Like, well, can any person in charge of or in the business of listing somebody on a ballot or moving someone on a ballot decide that Cenk does or doesn't get there? Can he challenge that up through the courts? Because it is really a similar question about the Section 3 thing, insofar as like procedural grounds, right?
Yeah.
Yeah.
Oh, and the other part to that is, suppose your state doesn't have an election. If your state just assigns all of its electors for people who are pledged to Cenk Uygur, right?
Mm-hmm.
There's no even vote there. In that situation, if there's no vote, can the state just do that? States have a lot of authority. So, and let's say that the state also says, we're assigning our electors to Cenk Uygur, and our state courts will not have the power to hear any claims about qualifications for any reason under the Constitution. So you cannot use our state courts to do so. In that situation, there would be no remedy in that state. Maybe there's a federal court thing. Maybe there's a way to do it and through a Congress enacted legislation.
Yeah.
But you can think about situations in which the state has taken away authority to judge qualifications.
Well,
and so
careful again. I mean, super anal. They're not
Yeah.
technically taking away authority. They've just removed all the procedural ways to do it, right? Because
Right,
theoretically,
right.
a person could pass through that process.
you're right.
And then as soon as they're in
That's
Congress,
correct.
yeah,
they still have the authority. They just don't. They
they
got
don't have
rid
the
of
procedure way to do it, right?
Yeah.
Because remember, because that's what I would fight with you so much about. Is like, well, who can do this? Who makes the decision? It's like, well, it's a procedural question. It's not if they have the
Yes.
authority, and that's what Section 3 argues. The authority is there. The procedure is up to the states. But even if they were to pass through the state things and get to office, well, now it would be all of the members of Congress then who would have the constitutional responsibility to impeach said person
not do-
on the grounds of
just-
Section 3, or to
yeah.
not seat them, right? Depending
Yeah.
upon, yeah.
Yeah. Okay. Oof. And also, just to be, if anyone, what Destiny's suggesting, and there is some disagreement about this, is not Congress, is Congress not seating the president? Let's just stop there real quick. Congress not seating the president. Do you think that Congress has the authority if the states send them electoral votes equal to 270 for a candidate who's 32, or for Cenk Uygur, do you think Congress has the authority to reject that?
I feel like such a loser, okay? Because I'm just regurgitating this paper at you. Yeah, I mean, I think they deal with this exact question where they say they actually don't believe that the electoral certification that happens in Congress. I think they say they don't believe that at that point it would be appropriate to reject them because that's just
That is what they say.
yeah, correct. And then they say, but I think they say that the process would be afterwards. It would be immediately an impeachment. Yeah, correct.
Yeah. Now there are other scholars who say, yeah, Congress does have that substantive authority. I'm on the side of that Congress's role is probably more limited to, are these the actual votes? Like, are these the things that they purport to be from the state? But yeah, kind of a side question. We were talking about now Cenk Uygur, right? So Cenk Uygur.
Oh wait, fuck!
running
I'm so sorry. I just remembered too. I'm sorry. The president doesn't actually. I think there's an explicit carve out in. I don't remember if it's a constitution or an amendment that says that the president doesn't actually become president after the thing. Aren't they president elect? And isn't there language? Like if they fail to qualify, I need to hold on. Let me check. Oh yes, hold on. Sorry, I'm just going to this. Once the votes are counted, a disqualified candidate does not become president, even if he has the most votes. This is made explicit by the, ironically enough, self-executing command of Section 3 of the 20th Amendment, which sets the constitutional terms of a president's term. It states that at the time fixed for the beginning of the president's term, if the president-elect shall have failed to qualify, then the vice president-elect shall act as president until a president shall have qualified. The language thus specifically confirms the possibility of a failure to qualify and specifies the consequences of that failure. If the president-elect is covered by Section 3, he cannot become president unless Congress chooses by supermajority votes to remove Section 3's disability. So it sounds like even for the president-elect thing that, that Congress might count the votes or whatever, but that the president still needs to qualify, I guess, to be seated as president, or I don't know what the exact process looks like after that, but that there are even carve-outs there for it.
Gotcha. I think that there could be a role for Congress to assess, but I'm not sure about how substantive that role would be.
Regardless, assuming you're following
it wouldn't be the
Section 3,
vice president. It wouldn't be the vice president.
Once you seat the president, he ought to be impeached immediately. Would be the next
100%.
step, right? Yeah,
100%. Yeah. Okay, back to Cenk Uygur.
Yeah,
Why am I bringing up Cenk Uygur? I'm bringing up Cenk Uygur because Cenk Uygur argues that he is eligible, and the reason he argues he's eligible is because even though there's this natural-born citizenship clause in the Constitution, the Equal Protection Clause of the 14th Amendment, Section 1, has undermined that or has removed that.
Yeah.
That is, a new enactment, the Equal Protection Clause of the United States, has removed the prior disqualification based on natural-born citizenship, even though explicitly it doesn't say so. My concern is reading into Section 3 a partial abridgment or partial undoing of the First Amendment where it's not explicit seems a little odd to me. And that leads to, I think, two conclusions. One, either all the First Amendment standards should be the same for Section 3, or two, the First Amendment standards themselves are wrong, and Brandenburg is wrong. Because they didn't mean to overturn the First Amendment. It's just the First Amendment is wrong. That could be a conclusion that you draw from that. As between the two, I don't know. Mere advocacy being enough for engagement, maybe that's right.
I mean, historically, that seems
me
to
having
be
to do
the
what I'm
case.
telling.
Yeah.
I guess I have to tell. Like, I've been
But then
telling
we
everyone,
also-
like, don't worry about the consequences, and
Sure.
and here I am, like, being soy about them.
Sure. Well, but I mean, again, so one is, right, unfortunately, that's not an argument, right? The consequences could be far-reaching, but assuming that the Constitution is what it is, then it's up to the legislature to amend it as such. But we can't say that we don't want to follow it because it might take us uncomfortable areas, number one. And number two, the two narrow parts of this, I think, are what are comforting at the end of the day. That one, we're not talking about any real like deprivation of rights here in terms of, you know, criminal charges or fines or anything like that. And two, this is narrowly applied to prior oath takers. And the speech we're talking, and three, and the speech we're talking about has to do with insurrection and rebellion, right?
Yeah.
So all three of these parts are incredibly narrow. The only broad part is
the actions, thereof. But I mean, like,
Yeah.
the exact same thing, arguably, could be said about conspiracy, right? Like, if I go
Yeah,
to there,
that's true.
we could think of literally. I think we could think of any single action. We could do
If
like
I
an,
privately encourage you to do murder, that would be it could be a conspiracy to murder, or at least I could have accomplice liability.
literally
for
anything.
just
We could do an LSAT
encouraging
bullshit
you.
question where it's like if I say to do X and then kill someone, X can literally be any, like, hey, we should go to Walmart, we should buy nicotine gum, and then afterwards, I think we can go and kill somebody, as long as we've got some gum to chew, so we're like, chilling while we're doing it or whatever. Like, I'm pretty sure that as long as you've got like a plan for the crime, and then part of the crime you've taken like one step towards it, I think that one step, that conspiracy part, can be almost anything, can it be? Or what is the limiting part on the
It's different between jurisdictions, but,
okay.
there are some jurisdictions that require overt acts to demonstrate the meeting of the minds, which
Sure.
is the crime of conspiracy. And there's for accomplice liability, I think there's something called substantial step. I might be confusing them. Someone who is more familiar with criminal law can tell
Okay,
me.
maybe step by
But-
step is different. But it could,
Yeah.
innocuous things like let's go buy bats and kill somebody. That would be a clearly legal. Buying a bat is never illegal, but as a step towards a
buying
crime
it
or whatever.
for the purpose of,
Yeah.
of this. Yeah, and I think you would agree. Like, now you'd have to have the specific intent to engage in insurrection, right? So if I give you a bat and you're like, I'm gonna go to the Capitol, I'm gonna go overturn the country, and I give you the bat, like, not knowing that, right? That would be different, right? I would have to either knowingly do it and not care, probably, or I would have to do it with the purpose of like furthering that goal, right?
Yeah.
So I'm giving you this bat for that reason, and that's me engaging in insurrection. It would be no different than me giving a gun
Sure.
to engage in insurrection, right?
Yeah, sure. I'm only giving the conspiracy thing an example of like conspiracy related crimes are wide reaching, but we're not generally concerned about that because it's narrow in the intent to commit
The
a crime.
intent. Yeah,
right? And
I
the
think
people
that's
committing
right. That does make me feel a little better. And honestly, when I remembered, I've been taking as an assumption, and maybe that's my problem this entire time, that Brandenburg applies because that's what the Colorado court did, and I'm just taking that on good faith. But as I recall, me reading the Baden-Paulson paper, I did think they had the better of the argument there on superseding.
Yeah, and the
to extent that there is
Brandenburg
a conflict.
application is super scary because now we're into the realm. It feels like we're into more of a realm of, because one of the things that I like that this paper establishes is like whether or not it's an insurrection that's not the question that is appropriate to engage in. The question is whether it's self-executing, and then ought the states or the mechanisms of the states engage in that. And it might be difficult, but that's up for them to decide. That's not like a matter, I think, of like the amendment itself to decide. It's like to determine, right?
Let me be Neo Destiny for a second.
Yeah, go. Is this
What's
me
the
3
stop-
weeks ago or?
Yeah.
Okay, go ahead. Yeah.
What's to stop a state from doing some preposterous ruling about what an insurrection was, and actually the border crisis is an insurrection, and Biden is engaging in it by denying its existence.
Well,
So
I think,
therefore
so for the first thing we have to be careful of is it can't be an insurrection against a state. This has to be the federal level, right?
We'll say they're swarming into our country. They're causing violence all across the country. It's no different than if a country invaded.
So give me the full example.
Yeah, so we have a bunch of people who are breaking federal American law.
Yep.
They're preventing the enforcement of immigration law because they're coming in such a number, and they're foreigners, right? So it immediately implicates the powers of the government, and Biden is letting them in by denying the existence of the crisis at the border and by not marshaling support of to defend the border.
So which part is the insurrection or rebellion?
The insurrection is, well, I'm assuming that the state court finds, you don't have to agree with their determination, but we're giving them the power. State court finds that the southern border crisis is an insurrection. It's an insurrection that is involving thousands of people who are breaking federal immigration law and are trying to fundamentally undermine the enforcement of immigration law, federal immigration law.
Okay.
In that situation, they rule that, and they say, when Biden is engaging in that insurrection that we've just identified by denying it and by not acting the way he should. What's to prevent that state, in bad faith, I think, from imposing a disability on Joe Biden? And should we be thinking about that?
So the primary rolls around, and now somebody in the state of Texas is
considering adding Biden to the ballot, and
Yes.
that person making the consideration says, I consider right now that there is a full insurrection or rebellion at the border, that
Yep.
federal officers are not faithfully engaged in the law of enforcing the border, and Biden himself seems to be directing them to do so. So he's engaged
Yep.
in insurrection or rebellion. Therefore, I am not going to list Biden on this particular ballot.
Right. He's a previous oath taker. He swore an
Yeah.
oath.
So
to
I mean,
to
I
support the
think
Constitution.
that they would have the authority to do it, right?
But what's the review? Because obviously that's bullshit, right? That is bullshit because they're wrong about some key things, which is Biden's intent, right? Biden is deporting more people than ever, right? Biden is enforcing the law there. It's just a unprecedented, or I shouldn't say unprecedented and catastrophize it, but there is a significantly large immigration problem that's occurring at the border. So like they're wrong about the intent. They like wrongly done this, right? And so Biden, as we both know, is not engaged in insurrection on the southern border, but they've determined that. I have a response to this, but like, what would your response be?
It appears to be that under Section 3 they would have the authority to do that. But then the question now is, I don't think this is a constitutional question. Now it's a procedural question. Well, what are the remedies that a state provides if you feel like you've been unfairly, removed
Adjudicated?
from the ballot? Yeah.
Okay, so now that's also kind of my answer, and that would be that there are some federal issues here that can be reviewed. And one of them
Reviewed
is
federally?
I think so. Yeah.
Yeah,
The
what would
finding
it
of insurrection for purposes of Section 3, applying the insurrection, even though states apply it. There are some federal questions here that could, even though it's a totally state court process, that could find their way to the Supreme Court, whether or not the border crisis is an insurrection. Because remember, we're interpreting the Section 3 of the Constitution, and so that's a federal issue. Even though states are applying it, the issue of what is an insurrection is a federal issue for purposes of Section 3, right?
Oh, that
'Cause
would
it's
be
not a
really
state-
interesting then, because that would mean that if we say that the Supreme Court has a right to review this, or rather there's federal judicial review here, and it gets to the Supreme Court, then the Supreme Court could theoretically be making doing fact finding that would be determinative for the other 50 states, right?
So just to skip all the question and the Socratic stuff, I don't think so, because it is true that the Supreme Court usually does not engage in fact finding, because it doesn't only when they're sitting in their trial court capacity in their original jurisdiction. But the Supreme Court does get to review certain facts below. They have to give deference to them. So, for example, they should be giving deference to the fact finding of the Colorado trial court. They should be giving deference to it. But they can review it for clear error, typically, that's the standard, and say, like, you could not have come to this conclusion reasonably. Nobody could reasonably have come to this conclusion, let's say. And so they might do that and say no one could come to the conclusion that that January 6th was an insurrection. I don't think they'll do that. But I would think that what I would want is the Supreme Court to have some jurisdiction to review these decisions with deference, but for there to be some sort of funnel up there so they can make at least the common questions of federal law.
Yeah, I guess that'd be interesting. I think a really interesting, just a super easy real life one would be, let's say that you find Donald Trump's arguments in 2015 really convincing, and you don't think that Obama was born in the United States, and you decide not to list him on the ballot. What does the review look like for that?
I think it would be the same, right?
So would it be then? But it's not fact finding, because what if the Supreme Court says, well, we saw the Sheriff Arpaio CNN or Fox News thing, and maybe a reasonable person could think that Obama's from Kenya. Like, what does the review look like if they don't engage?
I think it would require the Supreme Court to take a good look. They're not going to be able to just do original fact finding by themselves, but there's going to be a requirement that the below process were good enough. I think there is a due process consideration here, to the extent that you are letting people on ballots generally as part of your procedure. I think that we should imply some limited scope for fact finding, due process considerations, and for the Supreme Court to review, though with deference, the findings of lower courts, because I think that's important. The framers of the Constitution also wanted this to be a workable thing, and they didn't just want and didn't expect there to be a shit ton of inconsistent rulings and things. And so I think that it made total sense and makes total sense for the Supreme Court to be assumed to have some ability to review some of these federal questions with deference, but ultimately to prevent the absurd results of the parade of horribles that are being sort of brought up by Trump supporters. They're saying, like, if you do this, we'll take off Kamala Harris off the ballot, we'll take Biden off the ballot. That should not be a reason, I think, to not apply it. That's just like a threat. It would be the same thing for Brown v. Board when they were like, you better not rule in that favor. We're not going to enforce it, right? We were never going to like listen to these threats, or like we shouldn't listen to those threats.
Yeah.
But I do think that there's room for some review of the absurd results.
Yeah, there must be, right? Like if somebody just says like Biden acts like a 4-year-old, he's not old enough to be on the ballot. There must be some
Yeah.
process by it. Yeah.
But even though a state could just choose to assign their electors to Trump and say, we're assigning to Trump because Biden's 4 years old, would there be a review of that decision in the Supreme Court?
No, but it matters. Even if the outcome is the same, the argumentation matters, right? Because if somebody says you're not on the ballot, like let's say a 27-year-old black man decided to run for president, and somebody says, "I'm sorry, but you're not on the ballot because you're black." I'm pretty sure, yeah, that even if the correct decision was made, the argumentation would violate constitution, right? You'd get in trouble for that. I'm pretty sure, right? Even if the outcome is technically correct.
Well, let's think about this. If a state passed a law and said no more. Law number 1, no more elections for electors. That's done. Number 2, we are assigning our electors to the first non-black candidate to post their name in City Hall or wherever in the Capitol. That law, I think, would be struck down as unconstitutional.
Yeah.
So there's limits to the plenary authority of the states to assign their electors. They could, I think, right? I don't think the Supreme Court would uphold a rule, even if it's just the states deciding on the electors, that said, hey, we're not going to consider black candidates, or we're not going to allow, that those kind of decisions, I think, are subject to review, even though we give huge amounts of deference to the states on all of these things. I do think that the courts are open for some claims. There's some limits here, even on the highly deferential decision on how to assign electors, and even on the highly deferential fact-finding of the lower courts with respect to applying Section 3 fact-finding stuff on what's an insurrection, did he engage. They should defer, but they're not just going to be a rubber stamp. They should have a second look.
Yeah, I think so. Yeah. And then that would just it would depend on the procedures and everything. Yeah, but those questions are way past the hard arguments, I think, right? Like if everything else is agreed upon, then it's like, well, what should the review look like? It's probably
because there needs to be some answer here. Because if not, what you're saying is Section 3 is dead letter.
Or even further, like anybody could put anybody in a ballot or not for any reason, and there's no review or something, right?
We should never enforce qualifications because it's just too weird to apply the process, or we don't trust states to do it.
Yeah.
Well, if you don't trust states, we have this thing called the Supreme Court, and they can review certain federal questions. And one of those, but like if a state had their own thing, they're like, we are not going to send. We're going to assign our electors ourselves, and we're not going to send to Washington an elector pledge to a candidate who is a Democrat, even though that's like you're discriminating based on the political leanings of a candidate. That's what's expected. It's expected for states to discriminate because states decide, right? All right, man. Listen, I'm proud of you, bro. You clearly absorbed a lot from that paper.
Yeah, it's an interesting paper. Yeah, for sure.
Doing well otherwise.
Yeah, I feel like this debate with Glenn is going to happen, but
is not going to happen, or is going to happen?
I don't think it's going to happen. Did you watch his? He does a 30-minute video going over some of this stuff. He just doesn't engage in anything. It's just like dumb. Yeah.
Well,
but
I hope it does. I think it would be pretty shitty for him not to.
Yeah.
But I don't know. I think he's a pretty shitty guy.
Yeah, we'll see. Have fun. Be careful. Love you.
All right, later.
Wait. Or no, never mind.
What?
What? Sorry, just a quick political question. Do you think there's a chance Nikki Haley would drop out? And then my next question is going to be like, do you think there's a chance, like, what if all the Republicans drop out and then Trump actually, like,
hits a serious roadblock in a court case, like Jack Smith leaks as part of a new deposition, Donald Trump says to Mark Meadows, you know what, give me an AR-15. We're going down to Congress Center. We're killing all these loser Congress. Like that leaks. And all of a sudden, 50% of the Republicans are like, fuck. If you drop from a primary, are you allowed to like come back? Or are they going to be stuck with some like random fucking low candidate?
I think it would. I don't know the rules. There are specific rules for the nominating process. But those are just like private orgs. I think it would go down to the convention. Like if the Supreme Court rules, remember the primaries are probably going to be mostly done by the time the Supreme Court rules on this.
Rules on which thing?
On Section 3 stuff.
Oh, sure. I was thinking of it like the
criminal
ongoing
stuff,
court cases, yeah.
But for both have, I think, a similar kind of pathway for the Republicans. If he's done something so horrible that even they are going to hold their nose, query what that is. Like, I don't know what more horrible thing that Trump can do that would lose him the majority support of the Republicans.
Sure.
I'm not even being insulting. That's
I know
just
what you
my
mean, yeah.
perspective.
There is also
And I
a
think-
world, like, funnily enough, and it's actually, I think it's even a probable world. There is a world where, because of how our electoral college works, and besides, I think it's Maine and Nebraska, every state does 100% of their electoral votes. There is a world where the Supreme Court agrees with the Amendment 14, Section 3 interpretation, and they decide that they let it stand. But every single state that would have voted Republican adds Trump to the ballot, and most of the blue states don't, and it doesn't actually like materially change any part of the election. I think that's possible, right?
It's potentially possible. I think
I don't think it would happen if I don't know if the Supreme Court would make that decision, but I'm saying they could make that decision, and afterwards, like a red state would be like, you know what, we are just going to.
If they're going to affirm, I think that's more likely. I think if they affirm, they're going to say, yeah, Colorado, this was okay to find, but we're not going to force.
You can't
all
force
the states
to list or delist. Yeah.
And so you did it because you have a procedure for it, and that is in keeping with the Constitution, and so the disqualification is affirmed. So you take that ruling to another place, but the other place might say, yeah, we don't enforce that here. I don't know what the answer to that is. I think that there would be potentially some federal courts who might want to get involved if the Supreme Court said it, and I think you would get enough dispositive states that it would it could affect the outcome, right? So if you have Pennsylvania run by Democrats, Michigan run by Democrats, Arizona run by Democrats, although there's issues of Arizona state law there.
Yeah.
Georgia's run by what's his name, Kemp, but he's a Republican, and I'm sure he's come out against the disqualification stuff. I don't know. Even if the Supreme Court says that, yeah, he engaged in insurrection, they might not have the authority or the willingness to tell every state, hey, you can't do this. Because, of course, states could have different mechanisms. States don't have to have those elections. And so what rule could they craft?
When you say they, you mean the Supreme Court?
Supreme Court, yeah.
Yeah, I don't think the Supreme Court, there would be none. The Supreme Court would simply say that they would just affirm that, yeah, the Section 3, that the 14th Amendment is still a law, and it does work the way that it looks like it works, but that's it. But it would be up to the states for how they want to implement it. Like, theoretically, a state could list a candidate that is 33 years old, right? A state could do that, and you could vote for them. Now, we would say that they're violating their oaths to the Constitution, and we would say that Congress has responsibility to impeach or whatever the mechanism is there. But they could theoretically do it. Same thing with the Section 3 thing. It could be the case that oh wow, then you get into really interesting territory there. Actually, we've already kind of gotten into that territory. One of the arguments they make in the paper for determining whether or not it was an insurrection was technically Congress, both the Senate and the House, have by majority already determined that it was an insurrection. If you look at the votes for the second impeachment, now the Senate didn't reach the level for like the supermajority for the impeachment, but the majority in both houses, over 50%, did say it was an insurrection. So you could theoretically even have a precedent that the Supreme Court agrees that the Amendment 14 is as written and it is in full force and is self-executing, and that the president isn't listed on some ballots and is on others and wins the election and goes to Congress, and there are still members of Congress that think he shouldn't be there, but they can't impeach regardless. But that theoretically, then, going by that same logic, you could theoretically have, I guess, like a 32-year-old president, huh?
Like
as long as there's not enough people in the Congress to actually impeach in the Senate, you could theoretically have like a 32-year-old president who's like a foreign immigrant, theoretically, right? if they don't go through
Yeah,
the proper procedures.
I
but
guess
then-
if you're asking whether it's physically possible, it is physically possible.
Yeah.
Here's, I don't
Those
know if
things
you-
are
if-
ridiculous. I agree because we're saying like, oh, okay,
Yeah.
without, but it's not so ridiculous to assume that like Florida's putting Trump on the ballot, no matter what the Supreme Court says, right? Almost certainly. Well, I mean, if like 45 other states all don't, maybe not, but like we can easily imagine plenty of states that would want to list Trump on the ballot,
Sure.
irrespective of if they believe the
What the
14th
Supreme
Amendment
Court
exists or not.
says.
Yeah, yeah. Okay, sorry. Yeah, go
And
ahead.
then I don't know if you've dealt with this harder question. The harder question is, let's say that Trump engaged in insurrection in January 6th,
Mm-hmm.
right? He became disqualified for president that day.
Mm-hmm.
But he was still the president. Do
Yeah.
all his acts after he was disqualified become non-existent?
No.
If you go to court to
No,
kick
no,
him out
no.
of
Not
office?
only do they not become non-existent, we can borrow from I think Chase's the Supreme Court justice's argument in the appellate court on the one case where he said that I think he made the argument of de facto office, that one can hold a de facto office and be making rulings or whatever because of the de facto office doctrine, and it's not going to mean, because I think one of the arguments for that case was, I think a guy shot and killed somebody, and then he went before a court, he was found guilty, he didn't contest it, but when they tried to appeal it, they were saying that the judge involved in the case was, I think, part of the part of some Confederate state judge or whatever, and part of Justice Chase's argumentation, where he contradicts what he'd said prior to that, but at the very end he says, even if we did say that this judge is no longer allowed to be a judge, and even if we say that he violated that oath and we've got to kick him out because of the, I think the de facto
conviction would
office
still-
doctrine, the conviction would still stand. Yeah.
Okay, so you wouldn't say that you would give some play on the joints for Trump's whatever procedure he's entitled to play out, and you wouldn't just disqualify everything that he
Basically, yeah.
he
There was
did.
some Latin expression of, what is it, ultra vires or whatever? Do you know what the fuck
Ultra
that means?
vires.
Is that? Yeah.
Yeah.
Yeah, so like I think in some cases I think you can challenge these, but in other cases you can't. I don't know how that doctrine applies, but yeah.
Before I leave, I see Zetsu in the waiting room. He might have something to say.
Okay.
I don't know if you want to drag him in real quick, and then I'll
Yeah,
leave.
sure. Oh, and he just tier 5 resub. Thanks, buddy. Let me drink one. Whew, Jesus. Okay, one sec. I will say one of the kind of the unsatisfying things though is that like I think if you engage in this level of like legal argumentation, this is like basically 99% disconnected from the public discourse over the insurrection stuff.
For sure, 100%. There's a comment in the chat that says, "When will the Trump's cases outcomes be known?" In terms for criminal, we might not
Years, maybe.
we may not know that until after the election. Go ahead, Setsu.
Sorry, like you doing this actually caused me to realize I didn't resub. So there you go. I have just a question for you guys, both of you. Is that, I guess, listen to you guys talk about this. Hypothetically, if Texas wanted to say they were going to disqualify Biden for insurrection, do you believe that they have the right? Like, so you just say like, yeah, I guess they can do that, or would you guys have an argument like be like, no, they can't?
You're asking, do they have the power to do that? I think the answer is, in terms of generally, yes.
Yes.
But in terms of like, was it lawful to do that as to Biden? I would say
How would it not be
No.
lawful?
no. The application of the standard was wrong. Like they incorrectly applied Section 3. That would be my argument.
My understanding is the standard was self-enforcing, right? That it doesn't
So
require.
that way, so I think very carefully, they have the authority to do so, and they are completely within their right to do so. But I think we were talking about earlier is there must be some review for like a reasonable application of. No, I'm sorry. It wouldn't be application. It would have to do with the fact-finding part. So, for instance, I think all of us here would agree that Texas could say, I think you're 27 years old, and I'm not going to list you on the ballot, even if you've got a birth certificate that's otherwise. they have the authority to do that. It is within their right to do that. But ideally, there would be some review on the fact of the matter itself, right?
And maybe
but
some
let's say
erroneous legal conclusions. Maybe the Texas court says, we interpret 35 to mean 30, and so we interpret 35 to mean 50. In those situations, I think that like, yes, those courts can apply those standards. Doesn't mean they got the standard right, and doesn't mean they got the application right. And so, just because we agree that state courts are presumed to be able to enforce, doesn't mean they enforce correctly, and that their error is not.
I feel like both of your guys' arguments was that it's a self-enforcing law. I thought I've heard you guys argue with people saying that there is no standard, there doesn't need to be a finding or conviction.
no,
or anything
we
like that.
never
Wait,
said no.
hold on, wait, just to be
Is that
ultra
not?
fucking anal about everything. So when we say, when it's said that this is self-executing, that means that it requires no additional legislation
yeah.
to make it, it is
Similar
law.
to 35, you're saying.
You don't need a
and
law
similar
saying
to
that, like,
13th Amendment and
Yep.
other parts of the 14th Amendment. It's self-executing in the sense that you do not need implementing legislation from Congress in order to do it.
Correct.
In
So
order to apply it. It is the thing, right?
I guess and again, I guess, and I wonder if you guys agree with me that my thought of when they created it, there wasn't an expectation that there'd be a situation like where you're like, was there an insurrection or not, and that people would be in disagreement. Because I don't think there's really a lot of disagreements as to whether someone's 35 or not. Like you can find like that there's not going to be a 50-50 split. Like we think he's 12 and you think he's 48, and just like half the country thinks one or the other. Like that, I don't think is going to happen. But there.
But what
is,
does that
like,
matter?
Well,
I mean,
that is,
what I'm
yeah,
saying is that-
you are absolutely correct that the question is very difficult.
to
However,
the-
say
yeah.
that in the future, say that we actually do have spaceships that can travel at almost the speed of light, and we're able to send people away from the planet
Yeah.
and to come back at incredibly high speeds, and they come back and, you know, they haven't aged as much, or we have, and now, well, is he 35 years old? That is an incredibly difficult question, and that's true that it's difficult, but that has absolutely no bearing on the law whatsoever.
On the
It might
authority,
be
yeah.
a
No,
difficult
it would-
question, it might not, but that doesn't matter, right?
I guess I guess if this comes with no precedent, if Trump gets knocked off the ballot and there's nothing bad happens from it, I don't care. But like my concern is if you guys actually knock him off the ballot and like the Supreme Court goes like, yeah, we're knocking him off the ballot, I'm concerned for potential implications for like Republicans trying to.
Okay,
in
but those are
some way-
concerns, right? Like that's not a legal argument. That's just you.
I know,
saying the
no.
consequence.
You're right. So when it comes down to like whether he legally committed insurrection or not, you go, that's not up to me. Like you're right.
Well,
whatever
what
the
do you
courts
think about
decide-
it, though? Right?
Well, and then
you
also,
can
hold
buy
on,
it.
and
No,
then also,
I
I
don't
think you
think
have to be really clear on how we're making these like constitutional evaluations. Like there are real concerns. Well, where was that real concern when it came to overturning Roe? Or where was the real concern when they talk about how maybe they'll review the gay marriage decision? Or where is the real concern? Like, there are always real concerns, but at the end of the day, the Supreme Court is supposed to be in the matter of deciding, like, what is the law as written, not like what are the concerns. Concerns are for legislatures, right? That should be a matter of question when we're writing the law, not when the law has been written and it's part of the Constitution and now we have to, you know, enact the law.
I know, but I'm saying that because they're writing law, when you're in an obscure situation, like so, even like the example you gave, saying like if we can move at hyper speed, so suddenly who is 35 is suddenly up in the air, like how we would actually determine that suddenly, where right now you go, when we wrote the law, we had no expectation that we would move at hyper speed. So how do we apply a law that had no expectation of us being able to suddenly pseudo time travel? Like
You amended or write a new
and-
one, right?
Okay, and so then, but how would we apply? So before you amended or write a new one, how do you apply that in the moment?
As written,
That's a good
according to
question, yeah.
according to
I know,
conservatives,
But
right?
you can't. But you like so to whoever's in power would construe it however they want, basically.
Well,
And
we
they
have
could
we
do-
have
and they'd
don't
be-
we have legal? You guys know this better than me. Don't we have legal procedures? Can't you get like a stay or an injunction or a temporary injunction as you're like litigating a matter or whatever?
Oh, he's asking substantively, how would you? What is the basis to come to? It's a new phenomena, right? It's a new phenomena, just like the framers of the Fourth Amendment did not have envisioned like infrared technology or
Yeah, they've had to apply that,
metadata, all that shit. They've had to apply the principles and that's one of the reasons why originalism can't be the end all be all. Even though originalism, as a sense of like as a historical practice and looking into what the framers intended, is good. You need to have a evaluated approach as well, because there could be new phenomena for which there is no original
Yeah.
meaning. So you take the value, which is we want people of a certain kind of maturity, right? A certain kind of maturity, a certain amount of discretion, and so that we can avoid the kind of situations of all these young kids, the children of royals becoming president. We want to avoid the situation of these dynasties being created and these boy kings. And with that principle, then I think that you can do some work and come to a decision that way. I don't know. It's not going to be easy. It's going to feel unsatisfying, but we'll have to enforce it. We'll have to find a way, and the courts will have to come to a decision. That's just what we're going to have to do. Otherwise, you say, all right, well, because the circumstances changed, now the Constitution just it can mean whatever we want it to mean. We can get rid of that part of the Constitution. Like what's your answer? That Constitution is now that part of the Constitution is invalid? Can't be applied?
No. And wait, which part? Which example are we going back to?
If we get
Section
into
3.
interstellar technologies where
Yeah.
do you think that therefore we couldn't
A court would need to
apply-
make a decision. No, I don't. Can we apply it? The question is, what standard we apply? You'd almost need to go to a court.
But
for
you'd
that,
have to
because I
apply
would say,
something, right? You have to apply something.
How? I'm saying, but once you've involved something that kind of breaks the entire thing, you have to go. Okay, someone has to decide who makes that decision. If you just go, everyone makes a decision based on their feelings. I don't feel like that ends very well. Do
Hopefully,
you?
the Supreme
Like,
Court will come to.
Yes.
Whether it ends well or not, whatever. The Supreme Court will ultimately have to answer what does 35 age requirement mean in context of the interstellar travel situation. But
Correct.
I
That's
but I
my
just want to make
position.
sure that you understand, right? Like, we both agree that that provision should be enforced somehow. It should not just be ignored. It should be enforced, and maybe it just means flipping a coin because there really is no good answer. But that
Yeah,
has to,
it would
we
need to be
can't just
enforced,
ignore
and
it.
then and only that because the Supreme Court can't take something up until it has to be enforced and then challenged, basically.
Sure. And
So
that's
that
all we're
there's no
saying
other
here.
way for it to get there. Yeah.
There are some common questions of law that the Supreme Court will answer, and the alternative to them is not answering it and just having
Okay.
Section 3 be de facto overruled. Now, the other parade of horribles is what if states do all this stuff? I think that there are ways in which the Supreme Court could review these absurd decisions from state courts because they would have some ability to peer behind the fact finding and to see if there was some clear error in the applications.
So if
I
the
think
Supreme
that's
Court
true.
came back and said, "Hey, actually, like, given the situation, like I said, we're in an interstellar travel level situation here.
Yeah.
That we say you do need a conviction, otherwise, like, we never saw this situation coming, but you need a conviction, so therefore you can't keep him off the ballot." Would you both accept that?
Yes, if you added it to the Constitution as a new amendment. I don't think you can add a requirement like that because now you're in the, or if you want to,
You don't think
listen,
so?
if you want to, you can, but then you can't turn around and pretend that you're some like textualist, originalist, constitutionalist when you are legislating from the bench more than any fucking prior judge ever, right? Because remember, especially with this court, hasn't one of the biggest criticisms of Casey and Roe always been that this looks like a bill? This looks like legislation. Why are Supreme Court justices giving guidelines on like when an abortion is like a constitutionally protected thing? So to have like that criticism and then to totally disregard, right, stare decisis, or fuck it, if it was a watershed decision, if we thought it was a bad decision, it was a bad decision, to totally disregard all of that and then to look at this and go like, well, this is kind of hard, so, we're just going to add all of these extra requirements that, aren't part of
Were
it.
never
like,
there.
we drafted, that was an amendment that was ratified by the
By the
states.
people.
Yeah, and they're not,
Wait, so
we
are
had,
you guys
we had,
against?
there were
guys
amendments
both
that said that
against
like you have
substantive
to have
due process
legislation
then?
or whatever. No, it's not a
Well,
due process.
no, no,
violation. They could have
no,
added
no,
that. They
I'm-
could have
I'm not
put
against-
with a conviction.
Well, I'm
They
saying
could have that.
Substantive due process isn't like
Oh.
it's like the penumbra type thing. Are you saying, or I didn't know? Are you
No,
both
no, no.
against substantive due process? Because it sounds like
No.
what you're saying that like you can't do this, like they can't do that. They need an amendment. I'm like, we didn't like. I thought you guys were both be in favor of substantive due process.
No, 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 no.
which is
Hang on,
exactly
hang
what they
on.
did.
Hang on a second. When you're talking about substantive due process, you're talking about a chunky little phrase called due process, or you're talking about the privileges and immunities clause. It was clear from the history, I believe, based on what I can't recall right now exactly why I know this, but I believe I read the history that shows that the intention of the framers was to incorporate the Bill of Rights with the 14th Amendment in some capacity. Okay.
Okay.
The words due process of law and liberty, those are obviously going to require judicial expansion, and there are things that are
agree.
absurd readings and things that are not absurd readings, and it's totally within the wheelhouse of our courts to decide where the implied liberty interest ends and where it starts, right? Like I think would agree.
Doesn't that apply here too?
Hang on a second.
Go
No,
ahead.
it doesn't, and I'll tell you why. I think you would agree with me, wouldn't you, that there is a fundamental substantive due process right to have sex with your wife. Agreed?
I'm not. I think there's arguments for it, but it's not in the Constitution. You realize like sex with your wife is not in the
So do you think it
Constitution.
would be constitutional for a state to say you're not allowed to have sex with your wife?
Well, yeah,
unless
well,
you
hold on.
file
Yeah,
an
also, when we
application?
say
If you accept
substantive due process,
no.
by-
But if you don't, like, that's what I'm saying. But I would say I agree with substantive due process. But I would say that if you can agree with that, then I can also agree with them.
but-
That wouldn't be something different for this situation.
Substantive due process doesn't mean you can amend the Constitution whenever you want. It means
No.
we are
Yeah.
looking at this word due process of law with respect to liberty, and we're trying to define the scope of liberty and what it includes and what it doesn't include, and we have to. It's hard because the
Agreed.
Constitution doesn't clearly define it, right? And so we have to look at and there's a grounding here, right? There's a grounding which is our history and tradition, right? It's still grounded in history and tradition at some level of abstraction about what kind of rights are so apparent in our history, right? And so like
Yes.
teaching your children, having sex with your wife, right? These are not explicitly listed in the Constitution. It's not the same for insurrection or rebellion section 3. Those parts were explicitly
If they're
definite-
explicit, then why do people disagree?
because people
wait. Also, be
People
careful.
disagree.
People don't disagree that they're listed. They might disagree with
No.
like some other.
What is?
the interpretation
The
of it, right?
definition. No. So that the whole situations, because you're saying like, how would we determine if someone did insurrect? Apparently there are people in disagreement with that. I agree completely with you when it comes to like liberty. That's why they had to, like, for abortion, where they go, it sounds like legislation. You're like, well, we have to kind of expand on this stuff.
Also real quick, I think it's important to understand when we say what they disagree with, right? So Section 3 could say that nobody can be holding any of the office in the United States if you're a fucking loser. Now the question is, well, what do we you can't say, oh, well, people disagree with that because they disagree what a loser is. That's not what we're arguing about. We're arguing about whether or not you have the ability, the authority granted to you to not have somebody on the ballot because they're a loser. That's what the discussion is about. Now, if we agree that authority exists, then the next question is, well, how do we determine if they're a loser or not? And that's whatever the mechanisms, the procedures of the states are. That's up for states to decide.
No, what I'm saying is that the example you guys gave was, so like, let's go with abortion. So that I would say I did agree with Roe v. Wade and plan, like, I'm okay, like, I was fine with those. But, they did in fact have to go into some like legislation where they go the trimester. They had to go into those details, and you're saying that would have had to amend the Constitution to get those, right?
It's the same thing, right? So what were they talking about in Dobbs and Roe v. Wade? They were looking to history to define what is liberty and what's not liberty. What are we looking at to define what is insurrection and what is not insurrection? We look at history. That's our guidepost, isn't it? The values.
We don't have. It's the same. Do you believe that it was that he did, like? So our history is the Civil War. Yeah. Do you think
Also, wait, hold on.
Yeah, same.
I'm sorry. Hold on. Wait. I'm sorry. Quick question. Wait. I don't know why we're comparing it to the abortion question, because those are questions of, and tell me if I'm wrong, this is a question of substantive due process, penumbra of rights, all that shit. I don't believe that the Amendment 14 is a substantive due process question, is it? It's
no.
Clearly written, like, right there. Yeah.
You guys are the ones who brought it up. You guys said, like, well, here's this example of, like, where we had to, like, that it looked like legislative to go, so we would need an amendment to, if the Supreme Court came back and said, no, like, you have to have a conviction. You said you'd need an amendment for that, right?
Correct.
Like,
for him to accept it. Yeah, because it so clearly doesn't require it. Because it would be one thing if
questions of substantive due process, okay, are going to be like complicated inferences made by multiple different things, but that's where there's not like clear text providing us an answer. Right? If there is a clear something that in part of the original text of the Constitution or part of an amendment, then it's not a question of substantive due process. It's clearly written right there. We wouldn't need additional interpretations or a penumbra of rights or multiple readings or inferences of multiple things. We would just look at it as written, and if there's no conflict or no question, then we would just go with that. No, I don't understand why.
No, I'm saying that. So even if we go with, for abortion, let's say abortion was actually just, we could find it. We said, like, it even said, like, abortion is protected. They would need to go, well, what does that mean for something to be protected? And then we go, we have to create a system of these trimesters to try and decide that. None of that would be in the Constitution. It would just say abortion. And so the thing is, would the Supreme Court be wrong in suddenly doing Roe v. Wade if abortion was literally in the Constitution? Like, would that be wrong of them? Because they have to decide, how do we actually apply that? And if they applied it by saying, yes, you need a conviction, I don't see how how you could be like, nah, they can't do that. Yeah, they can.
Yeah. So when you're saying, like, can they do something?
No, that's right. I don't mean literally. Like,
is it okay for them to do that? What I agree with them is
they could say, actually, it's talking about ice cream. They could technically do that, but I'm saying, like, can you? Like, I'm saying, would you accept it? Like, would you say? Because it seems like you guys are saying
when you say accept it, I think it would be unacceptable. Yes, because I think that is a preposterous reading of the history and a preposterous reading of what the framers thought was required. Now you can disagreeing with a ruling of the Supreme Court, like, and by the way, the court moved away from the rule feeling like structure of Roe v. Wade in Casey, and they got rid of that framework.
Also, I'm sorry, I could be totally wrong, but somebody tell me the reason why we talk about like substantive due process and everything when it comes to abortion is because the Supreme Court have they ever ruled explicitly on abortion? I thought that was essentially fabricated out of the right to privacy.
Yes.
So if the Supreme Court said that, like, abortion is legal or whatever, like, I thought that the legality of abortion stemmed from the construction of the right to privacy that came through the substantive due process, like, argumentation essentially. So
yeah, I haven't. It's been a while since I've read it. But
it's not just right to privacy; it's also right to bear and beget children, a right, autonomous decisional right to have a family,
but all
and
that
decide what that family
same
looks
point.
like. I don't think it necessarily depends on privacy. Like if there were a rule that said no. I mean, think about this. If there were a rule that said it is illegal to have more than one child in the United States, would that infringe on your privacy?
Potentially.
How?
Like, I mean, to the same extent, you go that if you just said like to beget children, would that not include the number thereof?
No. I'm just giving you a law and asking whether you think it implicates the right to privacy, the right to have children, the right to have any children. Does that implicate the right of the privacy?
I would say
right?
yes.
What was the rationale
Okay.
used in Obergefell or whatever the fuck? That like
I can't recall.
if Congress is like, or if like some law body has like insight into your bedroom or whatever, that makes it like a weird like wasn't that part of the? I don't remember reading about.
I think there's more at stake in these cases than just privacy. I think there's it has to do with like, if a law says that you can't teach your children like a language that you speak, or that you're not allowed to raise them with your values, or you're not allowed to tell them or to give them specific instructions. There could be some First Amendment things there for sure, but there could also be some like decisional autonomous rights with respect to your family that the government's not meant to intrude upon. So I just think that let's not get into Roe v. Wade discussion.
Yeah.
There's
Yeah,
obviously
that's
going to be some expansion, and the courts are going to have to interpret unclear elements of any kind of abortional right 100%. And we're not saying that the court doesn't have some room here to interpret things, and they could interpret things reasonably differently. What we're saying is it's unreasonable to impose a requirement of criminal conviction. And that's okay. It's okay for us to disagree with that, unless you think we have to agree with whatever the Supreme Court says.
No, obviously.
Okay.
The whole reason, every single time someone goes to the Supreme Court, there's two sides that one side's going to disagree. That's every decision in every legal situation.
Yeah, so we would disagree with the ruling that said that the criminal conviction is required. What's the problem?
No. Well, no, because
What's
we're
the
saying I
inconsistency?
disagree with it. Would no. I'm not saying you're inconsistent. I'm saying, so what action would you say? So let's say they do that. What action do you feel would be justified? Do you would you just be like, you know what, I disagree, but I'll move on with my it is what it is.
You
like
have
maybe.
to. What do you think I'm going to advocate for tearing this motherfucker down?
Well,
Are
no,
we going to
I mean,
engage in
terms of-
insurrection or rebellion?
Exactly. No. Yeah, and then you need to get convicted of it first. No, but I mean, so think about Roe v. Wade. How much pushback, and even like I said, like where there was clauses, like the amount of work that went into trying to oppose Roe v. Wade. So they didn't just roll over and accept it. I'm saying, would you roll over and accept it, or would you go the conservative
I would
Roe v. Wade
advocate
where they
against
fought
it. Well, I don't know if I would put all my eggs in that basket. I don't think it's like that important to my life that I'm going to like dedicate my entire life to pursuing
come up
this
that
error.
Or
I don't
ever
think
again, honestly.
But that's more proof that like this, then the court should do this, because the
If they
court
did
should
the
get their law right.
If they came out the reverse way, so let's say they agree with you, they go, yep, they can take him off the ballot. They found that he's engaged in insurrection. That's good enough. Would that mean that you think that all the other states have to take him off the ballot as well, or could the other states say, no, we don't think he engaged in insurrection, we're leaving?
I
him
think
off the ballot?
I think all states should. Whether or not they have to, I think is a difficult question. I don't know.
Also, remember
So
very,
say
very,
if
very,
the
very
Supreme Court
precisely.
found it,
The,
we would say that.
the legal question is if they have the authority to, right? That's like the big question, right? Like after that, assuming that they have the authority to, which they should, but that's the question, then you would hope that they would. The same way you would hope that, like, if you're not 35, you shouldn't be on the ballot. But like, does Mississippi have to not list this candidate because he's 34 years old? I mean, they don't have to. They should. They have the authority to, and I hope that they would do a fact finding
Stephen,
and agree on the fact of the matter,
the
right?
question is like,
The Supreme
can court
found
order?
He was 35. Can they keep him off for saying like, yeah, we don't think he's 35? Even
Well, the
Supreme
problem
Court
is,
said he
Pisco said the
totally
Supreme
is.
Court doesn't do fact finding, so I don't know how that actually
Yeah,
works. I have no
exactly.
idea.
The Supreme Court, like, could they order someone to
Thanks,
all
Tribal. Thanks
states
for
in the
representing
union? If
everybody.
only one state is before them with a claim, right? It's only Colorado, but let's say it's about age, and they say like, this guy's 34. And he's like, yep, he is 34, and so what you did was fine, and so that all checks out. Could the Supreme Court, in the consequence of making that order every other state in the union to take them off their ballots?
No,
I don't
so
think.
you're
I
right.
don't know if they could do that.
I'm
They're
saying-
I don't
not
think they
parties,
would order
right?
it, but the ruling would probably be like
You
instructive.
try to apply,
right?
yeah. You try to take the ruling and you try to apply it through the federal courts to the extent that the states don't open their courthouses for those claims,
Yeah,
and you'll try
I
to
just-
enforce it that way.
The situation of like some states saying like, yeah, we have to keep this person off the ballot because they tried to overthrow the government, and other states going like, no, they didn't, we're keeping him on the ballot, and that he can get elected. So it's like a percentage of the states literally didn't have him on the ballot. The president was
That's our
also
system.
kept off the ballot.
That's
I'm
our
like,
system. I'm
I know,
sorry, but
I'm saying I'm not saying it's not. I'm just saying you do see the bizarrety in that, right?
Yeah, but that's not a
it's
legal
not
argument.
bizarre. It's not bizarre at all
I'm not
because
making a legal argument. I'm
Oh,
just
sure.
I'm asking you, do you like? I'm not saying
Our
are you guys
system
like,
is
no,
bizarre.
that seems totally
The fact
normal
that
to
there
me.
are some states that make it so that my vote is counted When I'm in Nebraska and I vote in an election, even if my whole state doesn't agree with me, at least my vote can get counted as long as like 1/5 does. Like one of my electoral votes go, that's cool. But like, how bizarre is it that states can have totally different, like in one state, I can mail in a ballot that they sent me that I didn't even ask for with no proof of ID, and I get voted. In another state, they might require me to show an ID at the fucking ballot box. Or another state might say, hey, listen, 51% of the country disagree with you. Your vote literally doesn't fucking matter at all. Because all of our electoral votes are going to another candidate. Like, these are all crazy things. The way that we run our elections is like quite interesting.
That's the system.
Yeah, that is the system.
No. So I wouldn't say that. So going, each state has their own rules. I mean, I wouldn't say that's as bizarre as we have a president who half the country literally.
Dude, wait.
If you, in terms of, also, just a quick thing, and then people can go. Like, I would venture a guess that I don't even know if I could. I would venture a guess that less than 10% of the people in the United States could explain how our president is elected. I'm not even sure if I could do it 100%. So it is a bizarre system. We think a lot of people don't even know the difference between popular vote and EC. Go ahead, Pisco. Yeah.
But it's not bizarre in the structural sense in that this was what was intended. It was intended for states to have this authority. States can assign their electors however they want. They do not have to have elections. And you acknowledge that, right, Zetsu?
Yeah.
Okay.
Yeah, no. They have their own rules. And so,
would it be bizarre for you, like, all right, half the states don't even have elections? Is that bizarre?
Yes.
Yeah, it would be bizarre, but it's
Yes,
legal
it would be
and
bizarre.
fully within the states to do so. Yeah.
But
Yes,
it's not
no,
bizarre
I'm
as a constitutional structural matter. That's what I mean. As a structural matter, it's totally what was intended.
There are times when I'm saying is, you're right. But I think you guys have said this. He goes, you can do something just because you can do it. That doesn't mean that.
Wait, they did do it. But back when George Washington was elected, I think half or more of the states didn't even have elections. That's what they did.
All right.
Oh, you disagree?
No. I don't disagree. My position is not here of one of saying
States
I
can
disagree.
have very different procedures, very different things.
Yeah, look
about
at
how
that.
they
I
do
think
it.
historically we didn't even used to elect senators, right? Weren't those nominated and elected from our state legislatures?
True.
Yeah, so, I mean, like, yeah, states have done a lot of wacky things. I do agree it's bizarre. I just think it's careful. There's a difference between like bizarres and like, damn, that's really wacky, which I've learned in the past 4 years encompasses a lot of the United States legal system. But that's a different argument than like, that's so bizarre, therefore we shouldn't do it this way, or it's not legal, or it's not the intention of the original drafters of the Constitution or the writers of the amendments or the laws, you know.
I'm not saying they shouldn't do that. Well, I just so we're clear, I'm not saying like I'm not gonna go protest if they take them off the ballot in half the states. I'm not gonna do anything about it.
Yeah, would you agree with it?
Do
Do you think he's disqualified before I leave?
I don't. So like I said, my view on it is that I don't think they foresaw the situation, and so I can't give you a clear answer. I'd go with whatever the Supreme Court. If the Supreme Court wants to say no, they don't, I'd accept it. If they say they need a conviction,
you don't
I
have
wouldn't
an
the same
opinion
position.
Hold on. Actually, wait. I would push
What?
back against that. Okay.
Go
Firstly, I don't like the argument from novelty. Okay. We're talking about pretty exceptional things. Okay. We can make novel rulings. Well, for instance, when what was the are you familiar with the Price case or whatever? The Price cases or whatever?
No.
The Supreme Court, I think, authorized the President of the United States in order to blockade ships, even though there wasn't a formal declaration of war. And then they basically argued that because he was fighting, what was it, the rebellion or insurrection, that the president had the authority to do it without it being like piracy or whatever. Do you know what I'm talking about, Pisco?
Yeah.
Yeah, the Price
Yeah.
case. Yeah, that was a novel decision. That was a really big. That was a really big decision in terms of granting Lincoln that power, the ability to close and blockade ports of like U.S. ships. And to say that like, well, this is like novel or new, like I agree. The Civil War was really novel and crazy, and Donald Trump saying that the vice president should overthrow the election is really novel and crazy. And sometimes these things come up and they're crazy. I agree, but it's like, what other event in history would we look to for novelty other than an actual rebellion or insurrection when we're trying to evaluate a current rebellion or insurrection? Like,
Although I'm saying that I don't think it was.
you don't think they would
novel, like,
foresee
man,
that somebody else might try to
was-
engage in insurrection? Like, or what?
No, I'm saying that the Civil War, I don't think there was people going like, was this an insurrection? Was this not? I don't think that was an up in the air question.
Hold
to
on.
say, like, there
wait.
was-
Wait.
Has
Also,
there been a
wait.
case where we said it was or
No.
wasn't?
No. First of all, that is completely wrong. Now,
It isn't?
retrospectively, obviously it was, but at the time, states were making legal arguments. We do have the right to secede. We do have the right to vote ourselves out of the union. A lot of them didn't consider themselves in bad legal or poor legal standing at the time.
They thought they were being aggressed upon by the northern states.
Yeah.
This is our land. They're occupying our seceded upon land.
Mm-hmm.
They're the ones who are attacking us. They're invading us. That's why.
That was why
Is
part
there-
of the
I
reason
have a
why
lot of
the
Civil War knowledge here. You're serious? Like,
Yeah,
I mean,
but
if
that
you're
was
right,
part of
then
why
maybe I
the-
agree with you more than I think.
That was part of why that Price case's decision from the Supreme Court was a big deal, because Lincoln did not. I don't know about this, but I don't think Lincoln ever declared war against the Confederacy, right? Because I think Lincoln's
There was
argu-
no war.
Yeah,
This was never
it
a
wasn't.
war.
Yeah, because he didn't want to declare
South
war
ain't a
against them.
nation.
Yeah, because it would make them a separate country. It wasn't considered a war because they weren't a separate nation. They were. It was a rebellion. It was an active insurrection turned rebellion. But the Confederate States themselves, do you think they didn't consider themselves rebellions the
They
entire
thought
time?
they were a country.
Yeah, much the same. The United States, we didn't consider ourselves rebellious colonies. We thought that we were a new nation post 1776 independence. Same thing with the
Wait, so you're
Confederate
saying
States.
if a state declared, so even like today, if a state declared itself an independent country, you don't think that'd be an insurrection?
Well,
Wait,
hold
if
on.
the state
If-
did what?
If a state just said, if California said, you know what, we don't agree with you guys anymore, we're going to become the country of California. You guys don't think that would be considered, like, that's not
I think that
insurrecting
would
the
be
United States?
insurrection. Yeah, it would
Well,
be.
but-
I think it.
by whose perspective? We would, but they
Yeah,
wouldn't,
we would.
right?
The
Or-
people who applied.
I guess,
it-
man, this is
What's
weird.
wrong?
No, I guess, no, I'm gonna, okay, how would you both define insurrection? Like, so if you just said, like, what is an insurrection, what would you say that, like, how would you guys define it? Because it feels weird to me that
I
saying,
think
like,
there are
well, I
two
don't
good
think it
insur-
is. I feel like it's very easy just to go, like, actually, I'm not overthrowing the government. I'm installing a proper government, so I'm not insurrecting it. You're like, oh, well, shit, I
What
guess
you're
they didn't
arguing for right
insurrect.
now, we'll give you the definitions. You know we have them ready. But
Sure.
what you're arguing for is that no one should ever interpret what insurrection means. That's what you're
No,
arguing
no,
for
no.
right now. You're
No,
saying
no,
it's
I'm
so
saying that
subjective that we shouldn't even bother to do it.
No, my position would be that I would suspect that insurrections are so clearly insurrections that there wouldn't need to be a debate on them.
I think.
Okay,
Well,
but
also, wait.
Destiny's point. Wait, I just want to say this.
yeah.
What Destiny's point is right now is that even the Civil War, the most clear insurrection, at the time it happened, there was vast disagreement about it. That's his point.
Yeah, because when South Carolina and the rest of the states joined them to secede from the Union, they didn't do it as a like, we're gonna go march and fight and kill. They did that legislatively initially when they voted in their state legislatures for secession. Like they seceded from the right. You heard the term. They
Can you vote
seceded
to
from the
insurrect?
Union.
Like-
Yes, they did because they
Yes.
didn't consider it an insurrection.
I know,
They
but
thought
I'm
that
saying-
they argued that they had after Lincoln won and they knew the intentions of Lincoln. They argued, well, hold on, we have the right to secede because you're violating our rights. That was the argument that they made, and so they voted to secede from the Union. They didn't just put their armies at the border and say we're going to war with the United States. They said, oh, well, that's great, you guys feel the way. Well, we also feel like we have the right to secede. You can't tell us what to do with our slaves, so fuck you, and we're going to secede, and that's fully within our legal right. Now, again, retrospectively, there was a civil war, so we can look at this and disagree
it's
with their
clear
perspective.
now.
But had they won the war, maybe
be
they would have
different.
felt the whole way. Like, yeah, they tried to aggress on us after we enacted our rights. They violated our due process and we wanted to start our own country, blah, 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 whatever. But at the time, yeah, it was a contested thing. Otherwise, if that wasn't the case, why would they even voted to secede? Why would they even do that? Why wouldn't they just, I guess, like go to war?
Yeah. I
So
think
just-
that's right,
so
Jesse.
give me
His
your-
point
wait,
is that
your definition of what you would say an insurrection or rebellion is. How would you define those terms?
okay, I'm about to give you two definitions that
Sure.
I think are both good, but just to be 1,000,000,000,000% clear, controversy and whether they are or are not controversial, or whether it's clear or not clear, are not part of these definitions. And I hope that you would agree
Yeah.
that based on what we just talked about, it doesn't make sense to be like, well, Civil War was a clear insurrection. Clearness isn't part of the definition of this word. I mean, the word either applies clearly or it doesn't apply clearly. But like, I don't know, the popular, it's almost like self-ID, right? Do you think that
no.
there should be self-ID of insurrection where like, well,
No,
just because you say it is?
If I compare it to someone who's 35 and you said like, well, when does your life actually start? Do we count it at birth or does it count it? Like, well, when does life really start? And you go, if someone at the moment, my understanding is we go off of when you were born. But if someone actually challenged me and said like, actually, I don't believe there's a lot of challenge on that. But if someone did try and challenge what it means to be 35 and said I was that I should be allowed to run, say they were 9 months away from being 35, and they say, I think my life should count at conception, not at birth, and that went to the Supreme Court, I wouldn't be like, well, obviously I'd be like, well, no, if you're actually gonna challenge this shit, I don't actually like, I wouldn't
What
have
would
imagined
you?
anyone
What
would
about
challenge
what
that.
about the case of?
And I would accept either direction.
What about the case in two potential examples? So one would be a funny case would be imagine if 10 million Koreans migrated to Montana. Okay, are you familiar with like Korean birthdays or anything?
No.
In Korea, they have in South Korea at least, they have a weird thing where I think they count like the year you were conceived in. Like you're actually a year older. Like, so I think in South Korean terms, I think because my birthday's in December, when we change it. But like if your birthday's in January, I think like you might be 1 year old in the US, they would say you're 2 years old in South Korea. Oh fuck, people are saying they changed this recently, so they don't do it anymore. Fuck.
Okay.
But still,
But that would be one where they count their years differently. Like maybe if enough Koreans live in a state, maybe that is actually a question in terms of, well, how old am I if we do count at conception? Or the second thing would also be, people take this for granted, but you two would know better than me. Isn't there actually a lot of debate, or at least don't some people debate, what does it actually mean to be a naturalized citizen? Like, does that mean that you were born on U.S. soil, or does that mean you were born? Like, isn't that a subject to debate sometimes, and that it's never clearly defined in the Constitution, even though it's literally a requirement to be listed on the ballot to be president? I don't think that's ever clearly defined.
I don't know offhand.
Sure,
in terms of that.
but I'm saying those might be those are challenging questions, but the fact that they're challenging doesn't mean that they can't be then qualifications
Answered,
Yeah.
So we still enforce those, right? Just because that's what you just said is a good argument in favor of why we should enforce this, is that there can be questions, hard things, even in things that are very, very clear. Like even for 35, where everyone thinks it's clear, there can be tough questions. That doesn't stop the principle of enforcement.
I see what you're saying. Yeah, no, I agree. You're right. So in terms of if we just say, does the state have the right to do that? Then I guess you're right. Yeah, and just no, I think you're correct. I do think it's fucking weird and bizarre, but you're right. That isn't a standard for me to say like that. No, I guess I agree. Yeah.
Listen, dude. I was there. I was when Josiah told me. I'm like, I mean,
you were there where?
When the
I
laws
was
were
there
written,
that day.
when the Constitution was
4,000 years ago.
I was the shaman king.
Isildur. No, fucking. I was there in terms of your mental state where you are. I was taught. Well, Josiah brought this up to me. I wanted to reject it right away. But it just follows. It just follows. We need to enforce the Constitution. We can't be because it feels weird, don't enforce it. We need to interpret what these words mean. And if insurrection means something, does January 6th, is that included? And if engaged means something, people who enforce the Constitution make that decision.
Yeah,
just like for the age requirement.
Do it. But you're saying each state would get to decide whether an insurrection has occurred or not.
Yes, but there could be review. Just like for any other qualification issue, there could be review in the Supreme Court and through the federal courts. There could be.
We just agree, if they can't, because the Supreme Court can't say yes, there was an insurrection or no, there wasn't. Can't they would?
Yeah, they can. Yeah, for clear error, 100%. Why couldn't they?
Clear. Okay, clear. Again, we're back to clarity. I thought we just said we can't. Never mind.
Well, hold on, wait, Pisco, wouldn't it be the Supreme Court wouldn't do that, but they would affirm a lower court's decision or something, but the Supreme Court would never take on a case just to decide if there was an insurrection or not. They would just hold it.
They can't, because
the Supreme Court could decide whether something was an insurrection. If that were a necessary part of something that they had to decide, right? Let's say that there was an appeal of a criminal conviction of insurrection that was actually charged, or let's say in the Section 3 challenges, they're going to have to decide whether or not January 6th was an insurrection. They're going to have to if they reach the merits, right? If they reach the actual merits, they're going to have to decide whether or not that was an insurrection. So they'll decide that. And they'll use definitions like the ones that I can give you. An insurrection as used in Section 3 is 1, a public use of force or threat of force, 2, by a group of people, 3, to hinder or prevent execution of the Constitution of the United States. You're going to say that's very broad. It is broad. But that's also not an excuse not to enforce it.
So
just because it's broad.
After the Civil War, were there people that tried to hold office and said actually the Civil War was not an insurrection, that they tried to make that argument in court? That they tried to hold office, and does anyone do that?
Not only
did that, that might have happened, but in the cases where that did happen, they passed some bills afterwards. I think it was before the Spanish-Mexican War, or Spanish-American. Yeah, where they pardoned people that Section 3 had applied to. So they made it so that they were able to come back. By enacting in the Senate, House of Representatives of the United States of America and Congress assembled, that the disability imposed by Section 3 of the 14th Amendment to the Constitution of the United States, heretofore incurred, is hereby removed. So they passed legislation to remove to people that had applied to it.
Yeah. So
and that was in 1898.
That was done.
And 1872, I think. Yeah.
And also,
has there been any other than Civil War? Has there been anything else that's been considered a rebellion under this section? Again, I don't mind.
I'm not sure. I'm not sure.
We don't normally have people organized rebellion.
Well, I'm just curious. Is there anything else to look at? I'm not saying
there are a couple cases.
I agree with you. I'm just curious if there's more. Is there more legislative history on terms of insurrection and rebellions that aren't just the Civil War?
It wouldn't be legislative history, would it? I mean, this would be like enforcement. It'd be like enforcement stuff.
Hold on. To be clear, there was stuff. Are you saying before the Civil War or after? Because there was stuff before.
After.
Oh, after.
There was some espionage case that they in the 20th century that they tried to do, which was not sustained. but I forget what the grounds were on that one. But I can get that back for you. But they used general language, okay? They didn't just refer to the late insurrection, which they could have. There were drafts of the proposed amendment that said the late insurrection, referring to the Civil War.
Yep,
But
and
they
they changed it.
specifically changed it to not be that. And so if they wanted to limit it to the facts and circumstances of the Civil War, they could have done so. But the reality was they were scared of South Carolina. They were scared it was going to happen again. Because guess what? The Civil War wasn't the first time the southern states got all uppity. They were extremely nervous about the potential for this to occur again. And so they specifically intended it to apply to future insurrections. That's why they use general language.
Yeah.
There's no argument.
And there's stuff like
outside
in
of
the language of the original Constitution that sunset things like relating to, owning or buying and selling people, I think was sunset to 20 years in the language of the original Constitution. Like they could have sunset if they wanted to, or made it
Yes.
apply to a specific thing if they wanted to, but they explicitly didn't. And then again, also, I think it's so important that like, because we get lost in terms of like where we're at now and we think like, oh, well, certainly they couldn't have meant this. Like, yeah, things probably felt a lot different right after the Civil War. Same thing with after World War I. I'm pretty sure most people thought that was the final large war. It was the Great War. Like, we're done after this. And then fucking 20 years later, there's another World War II, and it's like, fuck, holy shit. And now it's like, are we going to be in World War II? Now there has been one for a while. So, like, it's easy sometimes to look back and like, oh, well, obviously World War II is going to, close a lot of major hostilities around the world. Or maybe after World War I, well, we're probably not going to have another big one for a while. Like, that's pretty crazy. I think it's a mistake to go back and be like, oh, well, here we go. We've made it, 100 plus years or 200 years or whatever the fuck after 100 whatever years after the Civil War. And now we're, probably good. And back then they never thought another one would happen. But, as Pisco said, like during Reconstruction, I think people were super scared that people would take office again and try to secede again. And there would be more rebellions and more. Yeah, it was like fucking traumatizing as fuck. So much so that they passed an amendment to forbade people from holding office that had engaged in said behavior, right?
In that respect, it was radical. I mean, these are radicals, Republicans, who, in the good sense of the word, who are sick and tired of these damn insurrectionists. They did not want Jefferson Davis to be in power again. They didn't want these oath breakers to ever hold office again, and they didn't want any future oath breakers to do so. They wanted to discourage it from happening again. That was very clearly the intent here. And I just think that you should
Trump
have...
would fall into that pretty easily. Yeah, no, I see
Yes,
that.
and I think that you should say, yes, he does fall into that easily, and they would have recognized January 6th as an insurrection, and therefore he is disqualified. He engaged in it, and it applies to presidents, and the Supreme Court should do the right thing here. They should.
I'm curious if let's say that for the people, if we removed, so let's say Trump did everything he still
Oh my
did, like,
God,
so the
hold on, I'm
electors,
so sorry.
all of that.
Wait, real quick, and then you can fuck. Hold on, I don't know why I've never thought of that or why that is in the paper. That's such a good point. Or you can tell me if this is not a good point for Susan. Somebody said if Section 3 required a criminal conviction, wouldn't a presidential pardon remove that disability? Couldn't you theoretically just have a president or whatever pardon anybody, and now Section 3 is completely, totally defeated
And that would
on its face?
undermine...
Yeah, you're right.
Because
No,
these are
that
only for
is-
federal charges too, because we're talking about federal insurrection. So a president would basically have the ability completely to.
And it would undermine
yeah.
the specific grant of authority to Congress. As Congress... Remember, this is a Congress-facing amendment. They wanted Congress to have the power
To limit it.
To limit it.
By huge vote, yeah.
The executive branch would be completely able to undermine it if that was the case. No, you're right. I did not think of that. That's, yeah, no. But
The
so anyways,
arguments
my-
are fucking strong. The only I kept saying that it's 75% that they're going to overturn it because they could do the incitement thing, they could do the Brandenburg thing, which I think is the most likely outcome. But I even with this court with 6 conservative justices, 3 appointed by Trump, I still think there's a 25% chance they affirm it. I don't say that lightly.
yeah.
It's still not
25% is that's still.
Yeah, roll a die 4
That's
times.
pretty
I mean,
high.
that's my take. But I do think the arguments are super duper duper strong, and anyone who wants to actually debate the merits of it should do so, and not just rest on these like absurd arguments about officer and what about Biden if they're disqualified by Texas or some shit.
So I'm curious to ask both of you. So hypothetically, let's say
Our
Trump
last
did
question. I do have to go after this.
Okay. Everything he had done. So let's say he called the governor, tried to get Mike Pence to overthrow it, the false elect, all that happened, but no one went inside the building. So that the protest, like everyone stayed outside the building. Would you
Yeah,
guys
that's a
still
hard
say he
case.
tried to?
That's a hard case. I mean,
You
because
would say-
technically he engaged in insurrection when he had that intent, and there was a threat of force the first time that happened. So pinpointing when exactly it started is difficult. And whether or not
No, what I'm asking is saying if we remove that one thing, so if all of his actions, all actions
Yeah.
remain except for the 200 people or whatever going inside the building, would you still say that he committed an insurrection? That he tried? trying to send false electors, like those. Do you think the building thing is the biggest, like the people going inside the building is the biggest aspect of it?
No. It's so
I would
the
say it's the
evidence.
least.
Well, no, I think it matters because his intent is the most important thing, the most difficult thing to prove, and his reaction after they're in the building is very relevant to what his intent was before they went into the building. And so there's a lot of relevant evidence about Trump's intent that is unearthed by the going into the Capitol. Do I think that had no one gone into the Capitol, would Trump be disqualified? As a legal matter, I think that there could be a difficult case to prove, because you'd have to show that he intended it without the evidence after the insurrection had started, if that makes sense. So the insurrection, lasted only like a few minutes or something, or whatever long, because no one ever.
It's almost like asking, like, was this first degree murder if the person like cut up and buried the body afterwards or something, and they're trying to like make a claim that like my client didn't know what he was doing was wrong. It's like, well, did they really need to bury the body? Like, maybe not, but the fact that they did that shows that they knew what they did was wrong, or it demonstrates an intent before the act or whatever. So like that part might not necessarily be part of what's important, but because of what happened afterwards,
it'd be a much weaker case.
Yeah,
I think.
Maybe. Well, it would be much weaker if we were only talking about January 6th. Now, there's still so much before that to speak about as well. The pressuring people to change election results, the pressuring of the DOJ. I don't know how. I'd never heard about that before. That's a crazy thing. Threatening Rosen that he was going to fire him if they didn't send a fake letter to states saying that they'd found evidence of wrongdoing. The elector scheme. Asking Pence to do everything.
Like fall under Oathbreaker, wouldn't that be enough in your mind?
Do those... I don't know if they...
You said oath, that your part of your oath to office is to uphold the laws. If you're trying to circumvent the laws to remain in power, you don't think that counts?
But there needs to be a nexus with force or threat of force.
For it to be an insurrection.
Someone somewhere needs to do that, because
Maybe, yeah.
not necessarily you, the person who's engaging or giving aid or comfort, doesn't necessarily have to engage in force or threat of force. But someone along the chain needs to have that as an intent.
Well, hold on. Actually, I don't know, because remember I asked her that question earlier.
Except
about
for the rebellion
yeah.
little carve-out stuff.
Like, let's say hypothetically, let's say Pence did throw everything out, and let's say that it went to the House, and 26 states were Republican representatives, and they voted for Trump, and all of that was done with no violence. I think you could make the argument that maybe no insurrection, say the J6 marchers weren't there, but a rebellion, maybe?
Possible, but I haven't thought about it enough to be confident on it.
Or at the very least,
not
you've
the
hit
answer I
like
was hoping for.
bloodless coup. I mean, like, because you subverted the transfer of power. You've obviously violated your oath to the Constitution. You are doing illegitimate processes to make, like, I think at the very least you had bloodless coup. Maybe rebellion, not insurrection. Yeah, I don't know.
Right. Like if Trump said to all of Congress, "I will send in the military and kill all of you if you don't do that," that would be both insurrection and rebellion, I think. Yeah. But you're using a threat of force there. What we're talking about is no threat of force, and we're just saying he's trying to do some illegal shit.
Yeah.
But the problem with that is that really does scoop up a lot of legitimate challenges.
For sure. Maybe, yeah. But
thank
God we live in a world where we have a man that gave an hour-long speech prior to telling everybody to go to the building, where he explicitly called out the man he was telling to violate the Constitution, overthrow the election, where the crowd was chanting 1776 in reference to another rebellion, where the crowd was chanting hang Mike Pence for not, where the crowd was engaged in insurrectionist violence, where Donald Trump was failing to uphold it. Like, every single part of a insurrection is met in like 52 different ways. So thankfully, we don't even have to think about that hard question, because so much is met in other ways. But yeah.
Good talk, boys.
Yeah. Love you.
Yeah.
Love y'all. Bye.
All right.
How are you doing? Wait, what do you do? What is your job?
I'm a conflict and ethics attorney.
What does that mean? For like a corporation, do you try to see if like firing somebody or?
No. So for very large firms, there are a lot of implications for bringing in cases. So an example is there was a large firm that without like a good check took on like a Defensive Marriage Act in Congress and lost a shit ton of clients for that. And then like when they try to drop them, they then lost even more clients because they then like, oh, you just dropped someone because you got a backlash. And so that what that should have gone through was a review committee to decide whether you want to take on that matter or not. Or oftentimes like to make sure that people aren't butting heads with each other. And so when you have international firms, every single matter needs to be like vetted severely. And so you need an entire department to handle that, because the attorneys themselves can't do it because they're they can't bill for that time, and so they can't spend 2 hours reviewing their conflict reports that they can't bill for when they could have been spending those 2 hours billing a client at a hearing or something.
Gotcha.
And so it's basically a good way to get out of billables because in litigation, billables is the biggest nightmare. So that's really the reality. Before that, I did litigation, and it was not fun. I don't know why anyone would ever want to do it because it's just
literally a professional debater.
Depends on what position. If you're the partner, then maybe. But if you're the associate, then I remember worrying about some of my colleagues like that were actually potentially becoming suicidal while they were in trial. Like they looked like they wanted to die. Like there was one guy I was almost concerned. I'm like, I wasn't certain if I should bring up to someone, go like, should we like, he's looking at that window a little too longingly.
Jesus. Just like really stressful, like having everything, like all your ducks in a row, or all the paperwork filed?
Yes, the amount of paperwork that you have to do, the amount of like all the trial prep, everything you have to do to be ready, all of even especially if you have to do things like motion for summary judgment, those things can take like 50, 60 hours of time you have to like suddenly do, and like the amount of organization in each one, all of your just the amount of just not fun arguing, but just raw busy work that you have to do and make everything look nice is just, you don't have a life for that period of time. Sure. But then the partner just comes in and makes the argument so that they're all smiles that like afterwards, because they're like, man, I just argued for a week straight. They're like, yeah, and I like my fingers hurt like, from all the writing I did over the past month. And it's like,
and you don't really see anything that goes on in the background at all unless something gets severely fucked up. Like your lawyer forgets to ask for a jury trial for one of Trump's cases, or you accidentally email the wrong person and you sent like all of your what happened with Alex Jones when his attorneys accidentally sent like every single text message of his or something on his phone to like the plaintiffs. It was like, Jesus, yeah. Rip.
Yeah, I've had that. I've had opposing people trying, like their clients try and call me, and you're like, as soon as you have to realize, you're like, wait, who are you? And you're like, they call, because not everyone introduces themselves. And then you're like, wait, who am I talking to? And you go, you can't talk to me. You need to like, and then contact their attorney and go, just let you know your client tried to contact me. But that was actually on the craziest case I've probably ever had was a, but no, like, it's also just because the level of bizarrety that you deal with, like for example, here's an example. So there was a matter where someone was drunk on a motorcycle, didn't have a motorcycle license, wasn't his motorcycle, was going over 70 miles an hour in a 35, downed his bike, flew into oncoming traffic, hit a car, and then died. And his family was trying to sue the person he ran into. And like, that it's that level of stupidity. They go that I have to deal with this, and I have to have these conversations with people about like, no, you don't have to you're not expected to dodge oncoming traffic.
Jesus.
And then not only that, but the guy was like demanding like $5 million and like trying to like cause issues. And so I had to like every single week send him a new updated letter challenging him and saying the only things he gave me were half a police report. I'm like, I know it's only half. It says pages 3 of 6. I know there's additional ones that put your guy at fault. A picture of a flyer to his funeral and like half a death certificate. I'm like, this is not enough information to even make your case, but yet he's still demanding it. And then like getting upset with me. That was one of the ones that made me go like, you know what? I don't want to do this anymore.
Rip.
Yeah.
All right. I got to take off soon. I want to fight with a couple people. I love you. Thanks a lot. Be careful, buddy.
Bye.
Bye. What do you think of the chances that if the jury in Georgia finds him guilty, that the federal indictment would add the incitement using Georgia's motive? Maybe. I'm sure they're sharing a lot of information with each other. I'm just going through a couple people real quick. Eliath, who are you? What do you want?
Oh, shoot. I thought that was just another Discord group. My bad.
Okay. Well, way to go. Bye.
I was just debating. Whoops. Good luck. Have fun.
Do people just think this is a random Discord channel? The Ukraine discussion of the Shapiro date was absolutely abhorrent. I think I might have been like, holy shit, I know that you're just in your hand. This is either non-falsifiable or largely incorrect. It doesn't mean in the sense that Biden chatted with people privately to coordinate the alliance's rhetoric. This and other similar statements are non-falsifiable. We cannot know the contents of any of these private conversations for the foreseeable future. If he means this in the sense that Biden secured concessions / policy moves from the alliance members that they wouldn't know about. I thought at one point, I don't know if it's still the case. Didn't the EU literally send more? Sent more to Ukraine than we did? Is he saying that none of this was done with the encouragement or with the coordination of the United States, or the sanctions regime against Russia, while coordinated, was laden with like the deliberate loopholes and largely focused on minimizing the pain on participants as opposed to maximizing the pain for Russia? I see the dog shit oil price cut. As far as also the failure to sanction machine tool sales that are essential for running Russian arms factories. As far as arms deliveries, the United States is most likely acting as an anchor here, as opposed to being the one in the transparent the first delivery tanks. While Biden was waffling about jets only after the war, it was the Poles that defied Biden's cuckoldry to deliver Soviet tanks and jets. And he reminded the doves in the alliance how stupid their attitudes were. Damn, I would have to go back and read this. He doesn't bring up the banning some of Russia's participation in SWIFT either, because that was a really big deal too. But maybe that's not. I hope the United States learned from Iraq and Afghanistan that open-ended missions with unlimited budgets and no clear goal are the worst policies you can ever do. I do not understand why Destiny suddenly invokes the Iraq and Afghanistan nonsense when this conflict is wholly disanalogous to those two. This is arguing such a well, I mean, as in, like, we can't support Ukraine fighting for 20 years. Of the United States, now the other parts, first comes the no clear goal tag. Zelensky's outlined a clear goal, Ukrainian victory. Yeah, and we outlined a clear goal for the war on terror is the elimination of terrorism. I mean, when I say clear goal, I mean like a reasonable, achievable goal that like has clear and consistent guidelines for what it means to. Biden has done neither, I guess. The point here is that both debaters said that Biden has deferred to Zelensky in defining what the goals are. This is not the case. Well, Biden, the United States, has said that we'll support Kiev for as long as they need, right? But Biden refuses to state this publicly. If you, like me, watch the conflict since before it even began and you piece something together, you'll know that Biden is pretty clear of its own. It's just that the goal is moronic, abhorrent, and unachievable. Biden wants to shove Ukraine under the rug. Now, on to discussing the actual aid volumes. The United States has donated less aid as a percentage of GDP than literally every single EU member. It took the US. Well, bro, our GDP is way bigger than every EU member. What? Is it? Do you think this guy's Ukraine? Oh, never mind. That's not fair. I can't write him off for that. But actually, never mind. It is. This guy is Ukrainian, and it's painfully obvious when he's saying. When he talks about this. Anything that mentions an off-ramp starting at 118.55, for example, I agree that there has to be some reasonable off-ramp, blah, blah, blah. First, it's fucking disgusting to even frame it in this manner as though Ukraine is just a toy to get bored of and throw away. Ukraine is not my country. Sorry. Don't want to sound like an asshole, but Ukraine is defended insofar as it is in America's interest and the world's interest to defend Ukraine. When that calculation changes, then the conclusion changes and then the support disappears. I'm sorry, but nobody's going to support Ukraine through a 90-year conflict with Russia. Even Ukraine won't support Ukraine through a 90-year conflict with Russia. Neither will any of the surrounding countries. Like, that's part of military conflict. That's part of building international coalitions. That's part of, like, maintaining people on your side. Is like, there has to be a reasonable end to the conflict. Like, losses have to be limited. There can't be crazy war crimes. Like, you have to stay in good standing with your allies for all of these things, et cetera, et cetera, et cetera. Second, endorsing an off-ramp without saying anything about what it would be is beyond idiotic. Well, the off-ramp would probably be separation, unfortunately, of the Donbass with Crimea belonging to Russia. Unfortunately, it sucks. The off-ramp sucks, but... Any agreement that does not do that would deeply... Wait, whatever agreement you advocate for, it must begin and end with the idea that a resumption of war between Russia and Ukraine is going to become nearly impossible. Any agreement that is under this stupidly war, you can endorse something like Japan, give it territory for NATO, blah, 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 but I still find it really pathetic. Lastly, a quick note on what the reality of this looks like. Biden's most recent statement on this was no NATO and an Israel model for Ukraine contingent on some kind of ceasefire. This falls precisely in the category of deeply moral off-ramps. First, Israel's security agreements with the U.S. are obviously not contingent on no motherfucking ceasefire. Second, I won't believe this bullshit. Israel auto manufactured its own. Ukraine has to beg for some retired F-16s for the better part of 2 years. Third, Israel is fighting 2 bums in 3 rows with an AK to go between them. Ukraine is fighting Russia, delivering the same. I don't want to sound like an asshole. I'm sorry, and I might sound like an asshole saying this, but like, I can't do this. I'm going to alienate every Ukrainian fan I have. Like, regardless of what you think about it, and I don't even have to say this, you can talk to the Saudis, you can talk to Egyptians, you can talk to the Turks, you can talk to Jordanians, maybe, or at least 1/3 of them. You can talk to anybody that you want. Israel is a fortress, okay, that rose from the fucking ashes of everything in the Middle East and stands as a strong, independent country. That is one of the reasons why we support Israel. Whether you agree or disagree with the policies, you think it's a genocide, or et cetera, regardless of what you say, that's a strong reason to support Israel. I love Ukrainian people and Eastern Europe and blah, 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 blah. Okay. But to pretend like Ukraine didn't have a whole host of fucking insane corruption problems prior to 2014, after 2014, and like, will Zelensky even be a good president or prime minister, whichever one he is? I think it might be prime minister. I don't remember the difference for Ukraine. But like, would Zelensky even be able to rule that country post-war time? Is that country going to go back to being insanely corrupt? Like, Ukraine was literally one of the most corrupt countries in the world. Now, none of this is to say that, like, you know, we should or shouldn't support somebody on the merits of, you know, any other number of foreign policies as you can argue. But like, to make this comparison of like, well, if you guys are going to support Israel when they're doing this, blah, 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 you should be willing to support Ukraine in a war against Russia forever. That's entirely disanalogous, I think. Yeah, I don't know. This is dumb. What is this?
That's why he had a real shot here. Aza Bros, Hutch Bros, we fucked
I
up.
just keep screaming out. His son is watching me. What are the realistic outcomes for this conflict? ATP. The front is mined to hell between occupied Donbass, Mariupol territories, and Ukraine. It seems like the perfect conditions for. Oh Jesus! Wait, hold on 1 second. Okay, sorry. Okay, Hassan's watching your debate. Then go watch Hassan watch my debate. Anyway, yeah. I'm sorry. I love you guys. Fuck Russia. I do support Ukraine, but like, it can't be. It can't be another forever war. Okay, we've got too much. He was edging us for nothing. What do you mean edging for nothing? You can watch Hassan watch me. I'm not gonna watch Hassan watch me. He challenged you to a debate at the end. It's been 2 years. We supported the Afghans for a decade. Yeah, but like, is that like the model? Is that what we should be doing? Yeah, fuck that. During the Soviet invasion. Wait, hold on. United States support, if you're talking about like the Mujahideen or whatever for the Afghan civil war and the Soviet invasion or whatever, the level of support there was way different than full-scale fucking occupation and everything else. Yes, to hurt Russia. Yeah, but we didn't nation build or support Afghanistan for decades and decades with trillions and trillions and trillions of dollars, right? Holy shit, your total aids in Ukraine destiny, pathetic. This is after Biden's miserable failure to arm him anywhere nearly enough to even match poor Russia's contribution to the fight. I don't think that we can talk about this later. I don't think Ukraine's issue was that it didn't have enough arms or didn't have enough people or whatever. I think Ukraine's issue is probably that like they probably don't have the military apparatus to fight the type of war that they would need to defeat Russia. Probably. I think the United States might be the only country in the world
that has the ability to coordinate across so many different military disciplines with so many different types of tools of war in so many different ways dynamically on a battlefield in order to effectively utilize like this much shit. I don't know if Ukraine could do that. What is this based on? I think Michael Kaufman and a couple other military analysis people. Is it Andy? No, is it Michael? Am I making this guy's name up? No. Fuck. What was the name of the? There's one guy that we read a lot for military. Oh, I think it's this guy. We've read a bit from this guy, and there was one other guy. But yeah, it takes a lot to be able to have like tons of different stuff in a theater, in a military theater that's all being used like in a coordinated fashion. That's a really challenging thing to do. Destiny, it's arguable to say even the United States would be able to do it. I feel like the United States proved it could do it. I think we did during the first and second Gulf War. I think the United States maintains powerful intelligence, where our air force and our coordination in terms of bombing, picking targets, and everything is incredibly high. Our ability to support with a wide variety of tools, like forces in the air and on the ground, we rolled through Iraq in like a month. Saddam Hussein, that guy had like the largest fighting army. I think it was definitely in the Middle East, like the second largest in the world. We did that shit in like weeks, okay? Because you had the weapons, Gogolito, but we didn't just have the weapons. We also did a really good job at effectively minimizing civilian casualties, despite what Noam Chomsky might think. The coordination of our armed forces was impressive. Listen, I don't know, but... What are you... Is Ziana fucking with me? Fuck you, okay. What about Biden withholding ATACMs though recently? That seems pretty clear cut in terms of a stupid and unassuming withholding. I'd have to go and see what the actual rationale was. But I know for a while, I think that one of the scary things was the idea that if you give Ukraine too many offensive weapons, that like shit could get crazy and escalate really quickly. Like I think that was part of our big limiting factors, that we didn't want to give them things to strike into Russia and everything. But I don't know. I'd have to go and see the specific thing on that. You should give confidence intervals on takes like these. I'm fairly confident, like 60, 70%. My understanding is that the United States is like the only country in the world. I don't think China can. Russia obviously can't. I don't think anybody in the Middle East or Africa, South America. I'm pretty sure the United States is the only country in the world that can conduct like highly coordinated, highly sophisticated, involving like all three branches of military like types of attacks. I think the United States is the only one that can do that. I'm pretty sure. It's not roasting you hard watching a debate. Okay, well, listen, go watch him roast me. Have fun. If Hassan wanted to debate me on any of this, tell him to shoot me a DM and we can argue about anything that he wants. Actual vile anti-Ukraine messaging. What do you... I got like 2 minutes. What do you want? You're not even in the channel. Do you think you'd ever be interested in talking to Joko Willink with all these conflicts happening? Oh, that guy actually seems interesting, yeah. And I think he's conservative too. That might be a fun talk if you ever wanted to. Okay. Tomorrow, we will chat about whatever you want. I don't know. I can't believe I fucked my sleep schedule up so much to read that fucking paper. But we'll see if Glenny Boy wants to talk at some point. Right, cappuccino, my dude. So we'll catch you guys next stream right now.